everyone, and welcome to another very insightful episode on immigration and on Immigration Talk Show. And I'm really happy that you are able to join us and stay with us because a very insightful webinar is lined up for you. Of course, I'm your host, Napasa, and today we will be diving into another very important topic and very timely, I would say. And before I tell you what the topic is, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, with that in mind, friends, thank you so much once again for joining us. Our topic of discussion for today is H1B season is here, and will rising deportations affect your chances? So, yeah, we are going to find out in today's webinar because, yes, there has been a lot of changes recently and immigration policy shifts, stricter compliance measures, and so on and so forth. So, yes, H1B applicants also and current visa holders are asking, what does this mean for me, right? And will it affect their chances? And how can they prepare for this season with confidence? So to help us prepare and discuss and know further about how to prepare ourselves, well, I'm really honored to welcome a very special guest, none other than Charles Cook, a leading immigration attorney with over 35 years of experience and the author of In Pursuit of a Better Future, a comprehensive guide to navigating the US immigration system. And he has definitely helped countless individuals and businesses, to successfully manage their immigration process. And today he's here to share his expertise again, once again with us. So, yes. Hi, Charles. How are you doing? Thank you so much for joining us
It's great to be with you. I love being on with you.
today. We too. We love having you, and it's exciting that you made it here. In spite of your busy schedule, that you are here to speak
Yeah,
with us for an hour.
my travel schedule's been a little crazy recently, that's for sure. Just got back from Peru last weekend, but we are in the midst of the H1B season and the literal utter nuttiness that is the Trump administration. I don't know if nuttiness is a word they use in India, but you should learn it if you're coming to America.
Tell us more about nuttiness then.
So one thing that's important everybody to realize, today is the very first day that your company can register for the H-1B visa lottery, but today's not the only day. The boss and I were talking earlier is, how's the day going? Well, today's easy because these are the cases we filed today that we've ready for, that we spent weeks getting ready and all our ducks in a row and we get our lottery entries in. But it's the ones that call us on the last day at 4 o'clock say, "Oh my gosh, I've got to get my lottery application in." Those are the ones that they're kind of always kind of a little iffy, but these are the easy ones. And honestly,
So,
Napasa, this is
yeah.
way better than preparing an entire H-1B application. I mean, this is just so much better.
I'm glad. So, every year, 35 years of experience, do you, face a lot of last minute, like you just said, people on the last day who are going to call you and say, how many numbers was the highest maybe for you?
Well, we probably do. We are not an H-1B shop. There's a lot of law firms that's literally all they do. That's not us. We're actually a full service law firm. We do everything from H-1Bs to labor certs to EB1s to deportation defense, employer sanctions. We defend employers in H-1B audits. We do the whole gamut of work at our firm. We've got 50 folks who do this stuff, and most of them have a lot of experience like I do. So for us, this is just another trip around the block. But I think this year might be a little different, honestly. First of all, it's more expensive. It's not $10 anymore. I think that will dissuade some people. I do. I think we will not get the number that I was surprised with last year, honestly. I thought it was going to be a little bit lower. I think, and especially with Trump basically about to start a recession, I think the numbers might be a little lower than last year, which is great for people that enter the lottery because it'll increase their chance of course, getting selected.
So, yes, folks, do join us in conversation. What you can do is participate by commenting wherever you're watching. We are streaming live right now on YouTube, and our handle is at Immigration Talk Show. Well, you can also call us up. You can have a word with Attorney Charles here himself by calling us on this number 425-436-6335, and the access code is 988-888, displayed right on top of the screen. So call us. And so, Charles, what can we expect? I mean, of course, there's rising deportations every day. We have, especially before the season, I think all we were hearing is deportations, a lot of it. So, what do you have to say
You,
about that?
in a past question, would you be surprised if I told you that Trump has deported fewer people than Biden did during the same exact time 4 years ago? You'd probably be surprised by that because it's true, but it's true. See, here's the difference now versus Biden. Biden never talked about it. He never talked about it because I think he felt politically it wasn't a good thing. But the ICE machinery that Trump set up the first time, that kind of petered off during the first parts of COVID, that came roaring back. And Biden had his best year ever deporting people in 2024. He deported over 300,000 people. Trump will get to that number, but the difference now is you're hearing about it every single day in every newscast and every newspaper. And that's because Trump is a marketer, right? He's marketing it. He's selling it. He's trying to make it look like he's doing something more or better, when in fact, he's doing the exact same thing as the last guy. Now, one difference, of course, is the people running the immigration service are now tasked with not necessarily approving cases. If you go to the USCIS website, it says, keeping America secure. I didn't notice the word secure in the name of the USCIS. I thought there'd be service. That's what the S stands for, not security. But they literally got the head of Homeland Security riding a horse on their website. It's so take that for what it's worth. Take that to mean that applications will be denied at a higher rate. Remember, Trump last time, denial rates for H1Bs, 30%. During Biden, 3%. So we're going to see, again, a reapproachment to these adjudications, and not just at CIS. So this rising tide of deportation, this is going to carry over to the consulate as well. The consulates are going to get harder and make it more difficult to get visas to come to the United States. We're going to see a lot of decisions that don't make any sense. And of course, as we learned yesterday, you better not say anything about Palestine because you're not getting a visa if you do. I don't know if you saw that yesterday, but they will be revoking visas and denying student visas, and I imagine others, if your social media suggests that you're pro-Palestinian. How about that? That seems a little crazy, don't you? Don't you think?
It is, it is.
The country of free speech isn't so free anymore, is it?
And travel ban is what I also heard.
Oh, that travel ban is going to come either today or Monday. So I would suspect that it'll be the usual suspects. He'll ban travel from Afghanistan, Iran, Yemen, all the bad actors. But I suspect that we're going to see a broadening of those countries as well. One country that will not be on the list is India, because Modi's done a really great job of sucking up to Trump. And whether you like Modi or not, I mean, the reality is he plays Trump like a violin, and so that's good, and that's really good for Indian nationals. Very, very good.
Good negotiations, I would say. So, yes, and deportations happening. And how directly or indirectly is it impacting H1B applicants this year?
That's a really great question. The systems that they're putting into place right now, like the registration system, for example, these things are designed to make ICE and USCIS, one, work closer together, and two, be more active as opposed to reactive. So if ICE, let's say somebody's H1B is terminated, the employer sends a letter to the immigration service. That person has 60 days. That ICE is not going to come visit you on day 1. Will ICE come on day 61? Quite possible. At this stage, they're very focused on the undocumented. They're very focused on that. But they're in this for the long game. If my math is right, there's 201 more weeks while Trump is president. I would suspect by week 100, we will see a shift to really doing active enforcement against visa holders who violate their status or overstay their visas. Because the information they're gathering now and their incredibly active use of AI, very active use of AI at ICE and USCIS, is designed to let ICE have their job easier. So yeah, I think you got to be very careful. If you're in H status and you violate it and it comes to the government's attention, I think you got a problem. And if you're terminated, that's the piece of advice. Everybody wants to wait till day 60 to see if they can change to the H1B, get a new employer. I would suggest filing a visitor visa, change of status right away. And then, and while you're doing the H1 search, and if you get the H1 new employer before the 60 days, just file it. And then you can withdraw the visitor visa. But this way, you're protected by the visitor visa for 6 months. So it's a much better protection, and it should avoid individuals being caught up in any ICE enforcement actions.
Well, great points. Thank you so much, Charles. And you're talking about, termination also. So, what about H1B holders, where they at high risk of deportation if their employment is terminated by any chance? And maybe what
Again,
legal options do they have?
Well, I think I kind of already answered that. And the answer is file a B1 change of status, B2 change of status, change to a visitor, and protect yourself. And if you do that, you're fine. You're not at risk. If you don't do anything and 60 days lapse, I think you're at exceptionally high risk. Because remember, the government knows where you are, right? They know exactly where you live. They know who your employer was. And ICE is inherently lazy. They're not going to spend weeks looking for one person. But if they can take a drive down the street and pick up somebody in 30 minutes, they're going to do it because they all have quotas. And an H1B who's been terminated, who's out of status after 60 days, is just as good as somebody.
Mhm. Okay, so friends out there, you can also join us. Thank you so much, Neha, for joining us with your comments. We are going to take them up. Just stay with us. And also, Monali Thakur, thank you for joining us with your questions and comments. I would really suggest and appeal folks out there to join us on call as well. And our number is 425-436-6335, and the access code is 988-888. So I think, yes, we are here back again with Charles. So Charles, thank you for telling us about termination of employment under H1B, and there are consequences, of course. So now I would really like you to highlight what measures or what can applicants under H1B take to ensure compliance with immigration laws and avoid potential deportation risks.
Well, first, it's really important to remember you are hired for a very specific job. You need to be doing that specific job. You should have your H1B job description memorized. And if you're doing something different than that, you need to change employers because ICE is ramping up their audits from the FDNS, which is the Fraud Detection National Security folks. They're adding people to that. They're changing adjudicators to fraud people and visiting employers. And they'll show up out of the blue and they'll want to talk to you. And you should be conversant. You should know your H1B job back and forward. You should have your pay stubs in your desk so you can show them. You should, if you're not going to be there that day, leave a note with the receptionist at your building. Hey, if anybody comes and visits, here's where I am. Because if you're not there, they'll just think you're not working and they'll just move to revoke your H1B. So one, being in compliance with your job. Don't get an H1B as a software engineer and be working at a cashier at a 7-Eleven. That's not a good thing. It's really not a good thing. One, two, don't work outside your job. You have no legal right to work outside the H-1B employer. None. That includes remotely. You can't work remotely for a company outside the United States, in the United States, on an H-1 visa for U.S. employer. That is illegal. That will violate your status. And of course, one of the most common errors we see happen to people is they travel on their H-1B, they come back from vacation, and CBP, Customs and Border Protection, the friendly people at the airport in the black uniforms and the guns, they make a mistake on your I-94 card and they don't give you the full time. So every time you travel, you should be checking cbp.gov I-94 to make sure that your status dates are equal to the dates you believe they are, so you don't accidentally overstay. 3 or 4 times a year, we're trying to retroactively fix somebody who wasn't paying attention when they traveled and returned to the United States.
Okay. But, Charles, I also heard that it's going to be a little relaxed now that people who are probably under cap exam, they can also work, say, for example, a professor for a university. They can also work part time or be a guest lecturer somewhere else or maybe take tuition. Does that
With
work?
another H-1B. You can have 2 H-1Bs at the same time. So you can have a
Okay.
cap exempt and work cap subject, but you can't work there without an H-1B. You have to file that H-1B. So really, really important. Don't be caught with your pants down on this. I can promise you it will not be a pleasant experience. And they will charge you with fraud, which will essentially bar you for life from coming to the United States.
That's going to be sad, really. But thank you so much for highlighting that. And yeah, now what about USCIS? How does USCIS verify the H-1B employer's compliance, especially with wage and work site requirements as well? And what really happens if violations are found?
Well, USAS sends out their FDNS folks. They are generally contractors. They don't show up with a badge, but they have a little permission from immigration, the USCIS, to do these audits. And as they do these audits, what they're doing is they're making sure that, one, you're doing the job that you said you were going to, immigration was told you were going to do. 2, you're getting paid the wage that you're supposed to be getting paid. Now, here's a great example. Let's say you hired as a software engineer, but after a year, you get promoted to software engineer 2. Your employer needs to change your H-1B. They need to update that H-1B, because if FDNS shows up and say, well, you had a different job? Well, it's kind of the same job. No, it's different, and you're getting paid more. I think this is a violation. And then they send out a notice of intent to revoke your H-1B. Now you've got to deal with that problem. And if they end up revoking it, then you're out of status, possibly with a fraud finding. So again,
No.
you are now in a day and age in which exact, strict compliance is 100% necessary. There is no room for errors in the immigration sphere.
That's very interesting, Charles. And what if it was all written in the job description that maybe after 6 months you're going to be getting an increment, or after a year you're getting an increment? Even then, you'll have to file a new H-1B, like when your job role gets upgraded.
If you're getting a change in your job duties and your job requirements, you should be updating your H-1B. It was, if we go back 10 years, I would say, don't worry about it. You're fine. In 2025, 100% you should be doing this. 100%. You cannot play games with this. You cannot, more importantly, you cannot trust anybody else with your immigration status other than you. You need to take ownership of this. So that means you need to be a pain in the butt to HR. Hey, you changed my job. The lawyer started this. I haven't heard from them yet. What do they need from me to file the update? I mean, you need to be proactive in dealing with your employers on this.
Very interesting. Thank you so much, Charles. Very important update, folks. I hope you're taking notes. And now let's quickly take up a couple of comments from our audience. Let's take up Neha. Neha saying, I'm currently on an H-1B and I heard that deportations are increasing. If my visa expires while waiting for an extension, am I at risk of removal, even
No,
if my employer has filed for an extension on time?
no, your status is automatically extended for 8 months once you file an extension. That's the law. Your lawyer should give you a copy of the law so you can take it with you wherever you go. Do make sure to carry that extension receipt notice with you. Ask your employer for it, because that's one way most states you get a driver's license extended. But it's your status. And in the United States, I hope people are aware of this. You're required to carry with you evidence of your status at all times. That means the I-94 card, not necessarily the passport. So you should have a copy of the I-94 card in your wallet at all times, or the receipt notice in your purse, so that if especially if you live within 100 miles of the border, you can be stopped at any time by an ICE or CBP officer with no warrant. And if you don't produce the documents, they can arrest you and put you in removal proceedings. It is actually a deportable offense to not have evidence of your status with you.
Well, yes, I hope that you are all doing that, folks out there here in the United States who are migrants. And Charles, now we'll take up Monali's comment. And Monali is saying, I was laid off currently, and I'm struggling to find a new employer within the 60 days grace period. If I fail to secure a new job in time, do I automatically get deported, or are there any legal options to stay and transition to another status?
So if you are in the 60 days, obviously you're fine. As I said earlier, you should be filing a change of status to visitor. This extends your status automatically for those 180 days, and you're automatically in status while that's pending. And it also gives you an opportunity to extend your job search. So it's worth filing that extension, that change of status with legal counsel for you and your family. That will protect you during that time frame.
Okay. All the best, Monali.
Now I will tell you, if you don't, then yes, you can be deported. You can be picked up and arrested, put into deportation proceedings. You can't be physically deported without going through a court hearing, which means you could be in jail for months waiting for a court hearing.
And that's going to be ugly.
Not a pleasant experience.
Now let's thank you so much, Charles, for taking that up. And now let's go to Kiran. Kiran is asking, how will the recent changes to the H4 visa policy impact the lives of young Indians in the United States who mitigated as minors?
Well, we know, for example, first of all, if people are not aware of this,
Sorry,
if your child came into the country before they were 14 years of age, you are required to register them on their 14th birthday as an adult. And you are in violation of the law if you don't register them. That registration requirement is not active yet, but will be active, I think, in the next few weeks. So really important to remember that. As far as the kids that are going to age out, there is been no other than that. There's been no real change in the immigration laws, because first of all, only Congress can change the immigration laws. The president can't change immigration laws. So what you're seeing here, I think, is a situation where you have thousands of Indian H4 kids who are aging out and either have to leave the country or change to a student visa and begin their own terrible H1B journey in the United States. That's why they need to keep fighting for a change in the law. I will tell you that there will not be a positive change in immigration law, at least for the next 2 years. There is zero chance that's going to happen politically because of who's in charge of Congress.
Right. Okay, thank you so much, Kiran, for participating with your question. And I really hope folks can also join us on call. So the number is 425-436-6335, and the access code is 988-888. Do join us on call. And now let's take up RK. Hi, RK. Thank you so much for joining us with your question. And RK is asking, Charles, do you see scrutiny on level 1 and 2 wages for H1B?
It really depends on the job. We actually had this debate in our office a couple of days ago. We were hired to get a H1B visa for a lawyer, a new lawyer, brand new lawyer. And obviously the company wants to use level 1 wages because level 2 wages are significantly higher for a lawyer, significantly higher for a lawyer. And we concluded that they're going to be okay with a level 1 wage because they are literally, everything about the job is entry level. So the key here is really looking at and making sure that the job itself is one that allows for level one wage. If you put in a detailed job description that is clearly indicative of a non entry level, that is somebody just out of college to do that job, then you're probably going to get investigated and dinged on that. Level two wages, I'm not so, if you have a job that's generally speaking a level two wage, I don't see a lot of scrutiny on that. But level one wages, 100%. 100% there's going to be a massive amount of scrutiny.
Thank you. Thank you for taking that up. And RK, thank you for your question. Very interesting. So now let's take up Jitendra. Hi, Jitendra. Thank you for joining us on YouTube. And Jitendra is asking, how do the immigration policies of countries like Canada and the United Kingdom compare to those of the United States? And what makes them more attractive to Indian immigrants?
Well, I am neither a Canadian nor a UK immigration lawyer, so I'm not an expert on them, although I am informed. Canada has recently had a massive change in their immigration policies. They have basically kind of shut the door on a lot of work visas because Canada immigrated about 1 million people a year for several years. There's only 35 million people in Canada. It was an enormous number of people that came in. And Trudeau has now lost his position as Prime Minister. He was kind of the leading force behind that. So I would suspect that Canadian immigration, while probably more flexible and slightly easier than the United States, is not as easy as what once was. The UK, on the other hand, is a terrible immigration system. Their system is very difficult. It is very hard to use. It requires a great deal of oversight by an employer, and it is designed to not have immigrants. I have a very dear friend who's a UK immigration lawyer, Nick Rollison, and I think he would tell you the same thing. England right now is as tough to immigrate to as any country in the world. Probably more so than most.
Thank you, Jitendra, once again, and thank you, Charles, for taking that up. Now, coming back to my questions, Charles, suppose an H1B employee is laid off and cannot secure a new job within the grace period. So, what can they do, if they have to remain, if they want to remain in the United States legally?
Well, I think I kind of answered this 4 times already. File a visitor visa
Yeah.
or file a student visa. Go get a master's degree. Go get a PhD. File that change of status. But do not wait to day 59. Really, file that early on in the process so that you can find out what's going
How long
on.
does it take
You know
to
what?
shift
Oh,
to maybe
well,
another status right
how
away?
long is a change of status taking? It's funny, Napasa, you put my phone number up here, and people are calling my phone number, and that's what's ringing right now. Let
Okay.
me just take a look at USCIS and the great thing about immigration, there are very few great things, but one of them is you can find the processing times from the Immigration Service. I'm going to go on their website right now, and hopefully, if it ever lets me in, tell you how long a visitor visa change of status is taking from an H1B, for example. So right now, immigration is telling me the processing time is 3 months, which is about normal. That's about, sometimes it gets longer, but it gets less, but it's about 3 months. And during that time, you're fine. Now, when you file for a change of status to a visitor, that means you're going to be visiting. You have to explain, I've been working for all these years in the United States. I want to take a few months and drive around the country. I want to go to Yellowstone. I want to go to Disney World. I want to eat lobster in Maine. Here's my bank account that shows I have the money to do this. Here's my return ticket for 5.5 months from now. If you do that, you'll be approved. You don't do that, you're not going to be approved.
Okay. So thank you so much, Charles. And there you go, friends. Before you even hit your 60 days grace period, you have to be filing for your other option. And 90 days, that's what, 3 months is what, you have in hand. So I think you should not wait that long for sure. Thank you, Charles, once again.
You're
And
welcome.
yeah. So, suppose a tech company sponsoring multiple H1B employees faces a compliance audit. now that audits are a real deal. A lot of it is happening and resulting in revocation for some visas as well. So what legal remedies do affected employees have, and how do they really safeguard their status?
Well, the first thing an employee who is affected by this to do is hire a lawyer, your own lawyer, not the lawyer representing the company. You need to find your own lawyer, someone who's experienced in these issues. Two, you need to try to figure out what happened. Why is the company facing a problem with the compliance audit? What is going on there? Two, was your job affected? Was it you? Were you one of the people who were affected by this? If you were, frankly, immigration believes that you are complicit in it, that you know about it, and that you allowed it. And if that's the case, it's going to be really hard to get an H1B visa in the future, which is why you don't work with tech companies that suck. You don't work with these marginal companies that are kind of skirting the law, that are just becoming job shops. You got to stay away from these companies. They are not there to help you. They're there to make money for their owners. So again, go see a lawyer right away. Maybe you can become a witness. If there really was abuse, you may be eligible for a T visa. These are visas for people that are victims of human trafficking. And we've done a couple of these for software engineers who basically were treated like human traffic persons. So again, talk to someone who knows what they're doing, who has experience with this, and from there move forward. But I would say every case is different. So there isn't really a general guideline other than get a lawyer.
Absolutely. It's always best to consult with an expert, and an immigration lawyer would be best. And folks, you can always contact Attorney Charles, and that you can do so. I think it's best to email Charles. So mail him at charles@immigration.net, and go visit www.immigration.net to get to know more about Attorney Charles
I
Carter.
answer all my emails. Yeah, email me. I answer all my emails. So
Yes,
there
he
you go.
does, and he's really prompt, very quick. So I'm sure you'll never be, disheartened with that. But if it is an emergency, definitely call him also on his number, and that is 404-949-8154. So, Charles, I also got a couple of case studies or scenarios rather, and this first one is, about a visa denied after administrative processing. So, Ravi, who is a software developer from India, has his H1B petition approved under consular processing. However, after months of administrative processing, 221G, his visa was ultimately denied with no clear reason. So, what are the possible reasons an H1B could be denied after administrative processing? First off.
Well, it depends. Has Ravi ever been in the country before? Does he have the student visa OPT issue? That's something we've seen come up a lot recently. And my good friend John Wasden has been litigating that like crazy, very successfully. First of all, the consulate's required to give you the ground, not the reason itself, but the ground. So within Section 212A of the Immigration Act are the grounds, 1 through 10, for which you should be denied. Now, so you're gonna know a general category. Then once we know the general category, then we can figure out what the deal is. What is it? A 212A2, that is a criminal charge. Is it 212A3, which is a security ground? So it really, again, very factually specific case. Usually after a consult with somebody, I can figure out what the problem was. Then we have to determine whether or not that's fixable. Sometimes it's fixable. Sometimes it's not fixable. Did that person apply for a visa before? Did they overstay a prior visa? Again, a lot depends. Maybe it's the employer. Maybe there's something with the employer there, and they're sending the H-1B for revocation. Again, very specifically, we talk about the facts to our clients to see what if anything we can do.
Okay. And, maybe employers could support their employees also in such cases, extended administrative processing delays. What can employers do maybe for them?
Well, same thing. I mean, it's the same approach for a foreign national, the employer. Find out what happens going on. You can always appeal a visa denial to the visa office. If we believe there was an error, we can send an email to the visa office. These are the people that oversee the consulates and give legal advice to them. So if it's a legal issue and the consulate's wrong, we can get that corrected. It might take several months. We can get it corrected. If it's a factual issue, that's it. You're probably toast. It just depends. Again, facts.
Okay. And that is very important. A lot of it, right? So, okay, about 221 Gs, delays, how can applicants minimize the risk? Maybe you can give out a few tips to those watching.
That's a great question. If I had to answer that, I wouldn't be an immigration lawyer. I would be God because nobody seems to know. Uh, there's a lot of speculation that your religion makes a difference. If you're Muslim, you're almost always going to get a 221G, almost always, anywhere in the world. It could be you had a prior legal incident. It could be you had a prior visa application. There's an endless number of reasons. None of them appear to be legitimate. Virtually all 221Gs are resolved in favor of the applicant. But here's a lesson that we learned from 9/11. Nobody gets fired for saying no. You only get fired for saying yes. And here's what I mean. Everybody knows about 9/11 and the hijackers. People don't know about is March 11th, 2002. On March 11th, 2002, the Immigration Service approved Muhammad Atta's F1 visa extension.
Okay.
6 months after he murdered 2,000 people. People got fired over that. The lesson learned was deny, deny, deny. Only approve when you have clear belief and understanding that you should be approved. Thus, nobody gets fired for saying no. So there's never a downside to saying no. There's never a downside of you waiting.
Thank you so much. I mean, that is very important information. And thank you, Charles, once again.
You're
So
welcome.
I got another, yeah, I got another case study which I was just reading through, and this is about an H1B worker who was facing deportation due to late extension. So Sophia, another H1B worker, was relying on her employer to file her visa, but due to negligence of delay, the petition wasn't filed on time, causing Sophia to fall out of status,
All
and
right.
she's now at risk of remotation. So, what legal options does Sophia have if her visa extension is not filed on time?
I will tell
And
you how
if you
we've
could,
handled that when we've been hired in this situation. We file a retroactive extension, called a nunc pro tunc extension, if the employer was at fault. Now, sometimes it could be something as simple as the FedEx didn't get delivered. I mean, that happens, which is why you never wait to the last week to file. You always file long before that. So you ask for nunc pro tunc relief. The simplest thing to do, honestly, is just to leave. Get on a plane, go, wait for the approval, come back. You've solved the problem. Overstaying by a day because there was an error or a week or a month is not going to get your visa denied. You're going to get the visa. Now, the other thing you can do is if it's nunc pro tunc, you got to pay premium processing. So you premium process a late filed nunc pro tunc relief. And if it's the employer's fault or the lawyer's fault, maybe it's the lawyer's fault. And that's the case. We usually get involved when a lawyer has screwed up. And then we just we file a bar complaint against the lawyer and we throw the lawyer under the bus. We win almost all of those getting reinstatement. We actually, last year, we reinstated somebody who had out of status for 2 years. We reinstated them because the lawyer had screwed up massively and just kept screwing up, like a series of screw ups. And we got them reinstated. So, yeah, it's possible to fix. But again, very fact specific.
it's always safe to leave, that means. And what about, if removal proceedings begin, what legal defenses or appeals are available, maybe?
Well, something depend in removal proceedings. If you've been inside the United States for less than 10 years, you essentially have no defense other than I'm afraid to go back home, which you're not really going to win from India almost all the time, or you can take voluntary departure. That's it. Because the immigration courts have no jurisdiction over visa adjudication. So the immigration judge can't fix a visa error.
Okay. Very interesting. I'm enjoying this conversation, Charles. Thank you so much. And I'll quickly say hi back again to RK, who's back with another question. We'll quickly take that up and, also address some other questions from our Facebook groups after that. So, RK, if the start if the start issuing more NTA for denied COS from F1 to H1B or H1B extension, what happens with the individual authorization while in immigration court?
Well, this is not an if. This is going to happen. It happened during the first Trump administration. It will happen now. The way it works, though, if a change of status is denied, it does not come with a notice to appear or an NTA. You have 30 days to appeal that, or to ask for reconsideration. So it's not automatic. If after a period of time you've lost the decision, you lost the H, you've lost the extension, and you are in removal proceedings, your defenses are limited because the judge can't really do anything about your visa status. So most of the time, for people like this, you're going to be taking voluntary departure and just leaving the United States. My suggestion, however, is that if you are at risk of being served with a notice to appear because you're out of status, then you probably should leave first. There is no work authorization that comes. There is no work authorization just for being in deportation proceedings. The work authorization in deportation proceedings comes from eligibility for cancellation of removal, that is more than 10 years in the United States, and a U.S. citizen, spouse, or child, or if you're applying for asylum. Those are the only two times you're going to get a work authorization in immigration court.
Okay. Thank you, Charles, for taking that up. And thank you, RK, once again for joining us. So now, Charles, we are going to take up a few questions from our Facebook group. So um, there we go. We have our first one. This is from Anand asking, my visa stamped for company A till 2028, but I left company and went back to India. In India, company B filed my H1B in the year 2026 while me being in India. Then do I need to go for stamping for company B? I heard if our H1B processing happens while being in India, then it has to be consular processing, only for which we have to go for interview. Is that true?
No. You have a valid H-1B stamp in your passport, and you have a valid I-797 for a different employer. You just travel on the old stamp and the new approval notice. You do not need a new visa.
Okay.
You're welcome to get one if you want to. You want to waste the money, but you're not required to.
Okay. That's good news for Anand then. All right. So next question is again on the screen. This is from Sagnik asking, my previous visa was F1. Have scheduled a Dropbox for H1B visa, first time stamping at Chennai for March 7th, that is today. Do I need to cancel and schedule OFC and interview? My hometown is in Kolkata. Can I schedule both OFC and interview in my hometown? And can I reschedule the appointments now, or do I need to wait till March 7th?
Today is March 7th.
Today is March
That,
7th.
that question is from 2 weeks ago, or we're in a time warp. I haven't figured out which one it is. I'm curious to know what he ended up doing, because clearly I would have just waited till the interview came and seen. But well, I guess we'll see.
Yes, we will. All right. So this is from Navya. Navya, this is also a couple of weeks back, and saying, hi, I have a question related to document form Dropbox for H1B stamping. I'm working with consulting company. Can anyone please tell me if I should take EVL, that is employment verification letter, from the consulting company with whom my H1B is filed, or the client that I'm working with? Thanks in advance.
We ask our clients to carry both,
Okay. Navya,
because
that's both.
they're going to ask for it. So you might as well have it.
Okay. All right. Thank you, Charles. Now, this next one is please advise me on this situation. So, I entered USA on H1B, and my employer didn't run payroll for nearly 3 months since I didn't have any job from the client side. Then, when I got job from the fourth month onwards, my payroll started running. Will I have any problem because of this during my H1B renewal or stamping? Thank you.
Yes. First of all, you're out of status. You're out of status if you don't get paid within 30 days. That's the law. So either ask your employer to reimburse you for that money, or I would file a complaint with the Department of Labor, Wage and Hour Division, and they will force that employer to pay you back. So yeah, that's a big problem. We see this all the time, Napasa. It is against the law to do this. And
It's
until people
illegal,
start,
right? I mean, you
it's very
can't
illegal.
make somebody
Very
work for
illegal.
you for free. Yeah.
Very illegal. It doesn't
Thank you.
matter. You don't have a job. That's irrelevant. You were hired to come in. They let you come in. They are required to pay you within 30 days of your entry.
And America is so expensive. I don't know how did he even survive for the 3 months without pay. Goodness
I
me.
don't understand that.
Yeah. Anyway, so thank you so much, anonymous member. I really hope that you have figured out.
Yeah, me
And
too.
now let's go on to our next one, please. This is also another anonymous member asking for those on H1B who have purchased a home and car are planning a vacation to India, given the current situation, how are you preparing for potential challenges if, God forbid, anything unexpected happens? Okay.
I would suggest that people fill out and have a power of attorney with somebody that's in the United States, so that you have it notarized in the United States that gives somebody else a power of attorney over your things. We also have a power of attorney over children if you leave them here, and you don't give it to the person. But if you can't come back, at least somebody can dispose of your house and your property while you're gone in your name. So, I mean, you might want to consider power of attorney. We have those on our website. And you're welcome to use those for the state of Georgia. Every state's different. Make sure you have one for the state that you live in.
Okay. And once again, that's www.immigration.net. Go check it out. So, yes, let's go on to our next one. Control, if we can display
Same
the
question.
next one.
Same question. But there are some in
I
our
think it's done.
live here. There's a couple of great questions here in our live. One from Empire. Maybe you could put that up.
Yes, we should. So Empire is asking, do you expect an increase or decrease selection rate for this year's H1B for both regular and master's cap? And also, do you expect any change to the H1B or next year's fiscal year 2027?
Two great questions. I was wrong last year. I thought there would be a decrease last year in numbers. I think there's going to be a decrease this year. The Trump session is starting. That's the Trump recession is clearly starting. Job gains are rapidly shrinking. Hundreds of thousands of people have been laid off in the government, which means private sector will also follow. So I suspect that we will, and many contracts have been canceled. Many contracts have been canceled by Musk and his minions and Doge. So I would suspect there's going to be a decrease in the number of applicants and thus an increase in the selection rate for both regular and masters. As to the second question, we're going to see massive changes. We already know that they're going to publish a regulation here in the spring, maybe the summer, where they're going to change how the lottery is run, and they want to run the lottery based on salary. Really. The higher you get paid, the greater chance you have of getting picked. Now, is that legal? Does that follow the law? Probably not, but they're probably going to do it. I would also suspect that they mandate a minimum level 2 wage on H1Bs. This administration, there are a lot of people in the administration, not all of them, that hate H1Bs. Musk loves H1Bs because he's using hundreds of them at his companies. And he himself had one at one point. But a lot of people hate it, like Stephen Miller, who's really in charge of this stuff. So yes, we will see massive changes. And I also suspect that the lottery fee will go up dramatically next year, maybe several $1,000s.
Wow. I mean, already there is an increase this year, and again, more increase. I think it's going to get crazy. So, but all the
Yep.
funds that they're going to be accumulating with this. So great. All right, let's take up Nena's questions. This is what
I
are the
had some good
specific
questions.
implications of turning 21 for children of H1B visa holders, particularly if their parent has not yet secured a green card? And what options are available to these young adults to maintain their legal status in the United States?
Well, they need to change their status as student. They can change the visitor too, but that's so temporary. Many of them probably going to be in university anyway. So I wouldn't wait till they were 21 to change their status, because they have to have 1 full year in their degree program to obtain OPT when they graduate. So if they wait till 21, they may already be in their 4th year. So I'd probably change them when they were 19 or 20 to a student visa. And again, if you become current, they're still going to get a green card through you. But this way they're protected and not waiting to the last minute to change to an F1. And then at that point, they're on the H1B hamster wheel as well, going through the process. Now, of course, depending on, how old they were when you filed the I-140 and how long it was pending, they may be able to recapture some time. That's why you never pay premium processing for I-140s, because you want it pending as long as possible, because it extends the age of your child past 21. So student visa holder is probably the only real option for most people, or to leave the United States.
Okay. Thank you so much, Charles, for taking that up. And Nana, I hope that you have gotten your answers. And if you have more questions, anyone out there, you can keep commenting. Also, I would say if you're resonating with whatever Charles has been giving us, very insightful, really, so far, so great. So do not forget to also subscribe to our channel. It is Immigration Talk Show in YouTube, and also check us out on LinkedIn, Facebook, X, Instagram. And yes, you can call us on this number, which is up there on the screen, 425-436-6335, and the access code is 988888. All right, so Charles, I got more questions actually, and this is another case study which I was reading. So, this H1B worker at risk due to employer fraud. So, Aman and Priya were working for a tech company and which is an IT firm, and later found to have misrepresented visa filings. So, USCIS launched an investigation, blacklisted the company, and now all employees are at risk of losing their status. So, what legal protections exist for H1B employees if their sponsoring employer is flagged for fraud?
None. There are no legal protections for H1B employees. Obviously, if they're terminated for any reason, it's 60 days. If they quit, it's a 60 days. So maybe you immediately begin looking for a job, looking for a school to go to, or change it to a visitor. Those are, and maybe you're experienced enough to be an O1 instead of an H1B. Maybe you're extraordinary, and we've been pretty successful in changing people from H1Bs to O1s. But as far as legal protections, not many. And if you are a witness, perhaps to the employer's abuse, there also may be a T visa. So again, it very fact specific. You want to get your own lawyer right away so you can figure out exactly how to navigate this problem.
Okay. Okay. And, what about this H1B worker? Can they transfer their visa to another employer if the company is under investigation, or they'll just have to be gone from the country?
Well, again, if you transfer, you should be fine unless the investigation involves you or your job. Now, if they're investigating the company for not having real jobs, yeah, they're going to question you on your new employer application, because it's all in a database. Now, AI is tracking all this stuff. So, you change the point. Oh, you were with company X. We were investigating company X for not paying its employees. So they might send you a request for evidence on your new employer's application and say, hey, show us you actually got paid the whole entire week with your company. Don't ever throw your pay stubs away.
Okay. Okay. And, what about employees? What can they do to verify an employer's, or maybe how do they report this fraud, maybe to protect themselves from this in this process?
So there's an agency in the government called the Department of Labor. And if you Google H1B Department of Labor, you will go right to their website, and you can report worksite abuse. This includes not getting paid overtime. This includes not getting paid the salary required to be paid, or not getting paid at all. And they can get your money. They are your lawyers. They will get your money back for you.
Okay.
But
All right.
you will not get visa protection.
Okay.
The Empire had a great follow-up question that I really, really want to answer.
Sure. Let's take it up. So how would that do you expect an increase or decrease? We've taken that. So how would that work? You can't compare a teacher's wage with a software engineer's wage, of course. And will it be top wage based on occupation, which makes a top paid teacher on the same level at a top paid engineer?
Well, Empire, you have hit the nail on the head. This is when you use you, it's not me making this up. Right? This is Trump and his minions. They don't care. They literally are looking at the highest paid people, period, not by occupation, because there is no occupation within the H1B. So if there are 65,000 people getting paid over $150,000 a year, then nobody making less than that in any job will get an H1B. This is disastrous for nurses, doctors, accountants, teachers, every kind of profession has entry level people. And yet, this, because they keep saying, well, H1B is for the best and the brightest. And it's not. It's never been for the best and the brightest. It's been for the most available worker. And this is the H1B, unfortunately, has been abused by a lot of employers. And as a result, whenever you abuse something like this, you're going to get a slap upside the head that will shake you to your shoes. And it's not going to be pretty. It's not. And it's
Right.
not just going to be IT. There's a lot of IT jobs that are not going to qualify. There's a lot of other jobs out there. Doctors, there's like 5,000 doctors on H1Bs. They all make more than IT guys. So that's 5,000 IT guys not getting it. There you go.
But I mean, great questions, Empire. Thank you so much. Very interesting questions. I'm glad folks out there can join us with their questions. They make this whole session more interesting. So I think with that, we've covered most of our questions, Charles. But before we leave, do you have anything more to add and wrap up and maybe give out tips to whoever is maybe getting into this fiscal year 2026 H1B lottery?
Remember, employer can only enter, one person at a time. You can have multiple employers enter you, but it doesn't make any difference because you're only going to get one shot at the lottery. So pray. I mean, it's truly a lottery. There's no way to enhance your odds. It's just the lottery. It's like going to the store and buying a lottery ticket. May the odds be ever in your favor, as the saying goes. Napas, it's been great being with you this week. Thank you for having me.
Thank you, Charles, for really joining us. I enjoyed this whole conversation and what a session. So I'm really looking forward to having you back. Maybe tell us whenever you get some time again, and it'll be great to have you back.
Love to have you. Have a good day.
You too, Charles. Thank you. Folks, don't forget to maybe contact Attorney Charles, and that you can do so by, email him. His email address is chuck@immigration.net, and go visit www.immigration.net. And also, you can call him up in case it's an emergency. You really need to have a word with him. 404 949 8154. But yes, his email address once again, ckuck, CKUCK, @immigration.net. Sorry earlier. So, yes, thank you so much, folks, for joining us. And I'm sure you loved today's session. So, do not forget to subscribe to our channel, hit that bell icon if you haven't already subscribed to us. Our handle is @Immigration Talk Show. We are on YouTube. And you can also check us out. We are on LinkedIn, Facebook, X, Instagram, everywhere. Check us out and connect with us. You can also email me. My email address is nipa@staffingly.com, and call me or WhatsApp me on this number, 408 335 6444. Thank you once again for joining, and stay tuned on Immigration Talk Show because we got more awesome webinars lined up. So stay with us.
Hi everyone, welcome to Immigration Talk Show. I'm Rajni Bharara, your host, and welcome back to this amazing show. Well, today, before I move ahead, let me very quickly read out this important disclaimer first. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to this amazing show. Um, Today, we are diving deep into the H1B visa changes for 2025, and we have none other than immigration litigation attorney Jonathan Wasden, who is here to guide us through it. So, without any further ado, let's welcome John to the show. Hi, John. Welcome back again to Immigration Talk Show. Thank you so much.
Thank you for having me.
Thank you so much, John, for being here. And this is a very important and a very timely topic because people are really confused about, and people really want to know what's happening with H1B visas because some days, the eminent political figures and the important people are supporting them, and then they are going against it. So people are really confused about, what's actually happening. And are they in favor of H1B visa, or are they not in favor of H1B visa? And is the H1B visa really secure, or what's going to happen? So a lot of questions there, which we are going to deal with today. John, let's directly, start the show. And because I have so many questions to ask from you. So my very first question, John. So, but before I ask you this question, I would like to tell our viewers that one of the big changes this year is that, jobs actually need to really match the degree someone has. And, it's not enough to be close anymore. It's been described as direct relationships. So, John, if you can tell our viewers that how do employers make sure that their job descriptions are spot on to, avoid getting rejected?
So there's really two different categories of employers and two different burdens that you've got to establish depending on what type of company you're going to work for. If you're going to work for a direct product company, say like an Apple or somebody like that, it's typically very easy to establish the degree requirement. You have to just put the specialty occupation code, and the Department of Labor connects that code up with the type of degree, typically computer science, and that usually will not get a whole lot of questions asked. The second category of employers are the staffing consulting companies. There is where we see all of the scrutiny on degree requirements, and it's tied into another requirement which has been resurrected in the new regulation that's come out, which is attempting to force employers to show that they have a specific work project for the employee at the time of filing the petition. And that's a project with a third party, placement type situation. So in those cases, for those employers, what we're seeing is USCIS is pushing for involvement from the end client and having them endorse or provide information, information about the degree required for the project.
Okay, thank you so much for answering the question, John. Also, I would also like to know from you that if someone requires a specific job and they have like a specific degree, and but they are not completely related, but like closely related with the relevant experience. So, would that still be considered a valid match under the new rules?
One second. My apologies. Yeah, so the closely related thing is going to be driven by a couple of different factors. And again, if the Department of Labor says that the job that you're doing, the specialty occupation or the standard occupational code requires a degree in that specific specialty, then that should really satisfy it. Now, the question is going to be for staffing companies, the project that you're working on, they're asking for details about that project to show whether or not the degree matches up with the project you're going to be working on. In reality, the vast majority, if not all, are going to be the same. They're all going to be requiring a degree in computer science or equivalent. And most of these things, I don't think the degree requirement is going to be the issue. I think where the issue is going to come in is the involvement of the third party or the client and them endorsing the petition basically, or providing their requirements for that contract.
Okay. Okay. And what if a company is hiring for a brand new role, where there isn't a perfect existing job description to follow? So how should they approach crafting that description?
So I guess it would really depend on what they're hiring for. As a general rule, hybrid positions do get a little bit more scrutiny, right? Quite a bit more scrutiny, depending on what the hybrid is. It's historically been the kiss of death to have any type of requirement for business administration in an H1B. So I would say any type of hybrid that requires, a business administration is probably going to be a tough sell. But, if you're talking about, other types of hybrids where it's equally technical, those I think are pretty easy to craft the job description and fit into an SOC code. Just it takes a little bit of work and analysis and some documentation, but I don't think that's going to be a huge insurmountable burden for people to make.
Okay. Okay. Thank you so much for answering the question, John. And to our viewers, I would like to say that we are live on Immigration Talk Show. And if you have any question regarding the topic, related to H1B, you can also give us a call on the number 425-436-6335. And you can put the access code 988888. Yes. So dial this number, put the access code, and you'll be able to ask your question directly from John on the show. So any question related to H1B, please dial the number. So John, coming back to you, I would also like to ask that, USCIS is saying that for extension, they'll usually approve them unless something big has changed, right? So I would like to know that what counts as major change. People are a bit confused about what could cause problems. So if you can please explain our viewers that what exactly is major change, in either the job or the company that could cause an H1B extension to be denied under this new policy?
Yeah, so all things staying the same, USCIS is allegedly going to defer to the prior adjudication that approved the petition if nothing's changed. Again, but what they're really getting at is a project-centric analysis. So if you've been working on a project with client A, and then for the new petition, you're going to be switching to client B. That's not going to be getting any type of deference or respect from USCIS to the prior decision, because it's a new project and they'll analyze that particular project.
Okay. Okay. And let's say if a company maybe is acquired by another entity, does that also always necessitate the new H1B application for existing employees, or are there exceptions?
So that there may be some RFEs, showing connecting the dots of ownership, especially if the acquisition was done, mid visa petition, like halfway through your 3-year stint. They'll want to make sure that the employee maintains status and they were working for the right employer all along. And so the maintenance of status issue may come up, and you'll just have to provide that documentation about the transition of ownership. That shouldn't really be a huge concern, but in terms of deference to the prior decision, if you're working on the same contract, you show that it's the same ownership situation as before, just a new owner has stepped into the same corporate structure. It shouldn't be a problem. You should be eligible for deference as long as the project hasn't changed.
Okay. Also, John, this is one question which I, usually get a lot from people. So they also want to know that, let's say, if the employee receives a significant raise, that reflects the market value. So also, is that considered a major change that could, impact the extension?
that is one of the trickier things to deal with, because the Department of Labor and USCIS have differing views on what constitutes a major change, especially in the wage area. USCIS doesn't comprehend how wages work in the private sector. And so you're going to draw some scrutiny if you have evidence of bonuses that really are disproportionate to the prevailing wage that's listed on the petition. Now, typically, their USCIS is not going to have access to what you're actually getting paid unless you give it to them. And the place where that happens typically is in the site visit. And the important thing for employers to know and for employees to know is during the site visit, two things. One is you have the right to a lawyer to handle that process. The other is your lawyer really shouldn't be giving evidence of pay to USCIS, because pay evidence is something that is by statute given to the Department of Labor exclusively. And USCIS has no oversight or no statutory authority to manage the wage requirement in a particular case. So if you give them that information, you're just asking for trouble. So my take is, when I represent people in site visits, is I push back on any type of request for wages just to avoid the problem. Because quite frankly, I just don't trust USCIS, especially FDNS, the people doing the site visits, to comprehend how the real world works and understand how business works. So I just don't want to complicate the situation at all.
Okay. Thank you so much, John, for those insightful answers. I see a lot of people joining us and are also posting their questions in the comment section, which I'm going to take in a bit. But before I do that, I also want to talk about, these worksite inspections. So, John, we are hearing that there will be more worksite inspections to prevent fraud, right? So it sounds like the employers need to be prepared. And if you can talk about, what are the key things they should have ready?
Yeah. So, the first thing there is they say it's to prevent fraud, but USCIS's definition of fraud doesn't really match up with the legal description of fraud. And again, in their mind, they're trying to make sure that the project that you're working on is the same project as when you had the petition filed initially. That's something that we're in the process of preparing to challenge in court. That's an aspect of the new rule that we're litigating. We've won this issue once before, back in 2020, and we got this project-centric analysis rejected and kicked out of court. I don't see the end result being any different in the next case that we file. So until that court rules on it, though, we're stuck with USCIS's reg. And fraud is overtly going out and providing false information on an immigration application to get your visa. But switching employers is something that the law allows. That there's no fraud in switching contracts or switching projects, not employers. So, focusing on where you're working is not something that's fraud. And they misconstrue that and they screw that up all the time. So again, that's why, it's important for these site visits that you take advantage of your right to counsel. There's a law called the Administrative Procedure Act, and it's if anybody's writing it down, 5 USC 555. And that's what gives you the right to counsel in administrative proceedings like this. And your lawyer is going to know what the problem areas are. Your lawyer is going to know what they're actually looking for and how they're going to use it, and is going to be best situated to protect you and shield you from invasive, unreasonable questions and demands for document production. And so take advantage of that. I know a lot of people will sit there and say, oh, I haven't done anything wrong, I'll just give them everything they ask for. Those are the people that end up getting visas revoked and get fraud findings, because USCIS will take information that you give them that you have no idea that there's any problem with, and they will flip it and use it against you And that could be the end of your future in the US because some high school educated FDNS officer misunderstands what's going on. So you just really want to be careful. And if your employer hasn't retained somebody for the site visit process for the company, I would say just, it's probably worth retaining your own person just for that site visit, just to protect you, because it's a relatively cheap expense considering what's at stake. So I would just make sure that you don't give in, you stick to your guns, you tell them to talk to your attorney at every turn, no matter how hard they nag you, no matter how hard they try to manipulate you. Just keep bringing it back around to talk to my attorney, he'll schedule everything. And don't interact with them directly.
Okay. So should they like hand over the documents to them, or should they tell them that talk to the attorney? And
yeah, the only document they should turn over is a G28, which is the notice of appearance of counsel. That has the attorney's information. And the only thing they should say to the officer is, here's my G28, contact my attorney, or I'll get my attorney's information to you, or my attorney will reach out to you. Everything should be channeled through the attorney. A very simple reason. If you say something or provide documents to FDNS and USCIS, then they can flip that around and use it as a fraud basis of a fraud finding against you. If I say something as an attorney, they can't really flip it against you so easily. And so, you buy yourself a little bit of protection and insulation. These site visits are getting far more frequent and far more aggressive than they've ever been before, in large part because they have, hired so many of these FDNS investigators, for lack of a better word. I think they're over 2,000 now, and just 4 or 5 years ago they were around 800. So they've really expanded their reach and scope, and they're bored with nothing to do other than harass people. And these are not the open-minded type of people that you would like to have working in government. They are all on board with Stephen Miller and Trump, and they are not to be trusted.
okay. And John, this is also one of the important questions that we get from a lot of our viewers. Sometimes they're worried about losing the original document, right? So they also ask that can they keep the copy of the document with them if they get these visits, or do they really need to have the original document with them?
So for the G28, the G28 can just be electronic. Anymore, everything, you should take a digital copy of everything with you anywhere you go anymore. It's easy to do. You've got the cloud. So I would have all of your documents organized electronically. If you want to hold on to the hard copies, fine. But I would think electronic copies should be fine as a general rule.
Okay. And John, also, are there specific red flags that these immigration officials are likely to look for during these employee interviews?
So it's interesting because they will just get hooked on something that is incredibly inconsequential and you wouldn't in a million years think would be a problem, and they will twist it into a problem. We see this a lot, especially at the port of entry with CBP, but we've also seen it with FDNS, where somehow they get access to your email, like you give them your phone or you give them access to your email account, and they'll see that somebody emailed you a draft resume that you used as a template when you created your resume. Everybody who's ever made an initial resume, especially early on in their career, has borrowed somebody else's resume for formatting to make sure they're doing it right. I did, many times. What USCIS and CBP are doing, however, is they're saying, oh, you're using somebody else's resume. That's fraud. You're inadmissible. That's a fraud finding. Absolutely bonkers, absolutely crazy. Doesn't meet the legal definition for a fraud finding, but that's how far they're going and how far they're reaching to mess with people. And so you just really need to protect yourself and advocate for yourself, and set up some firm boundaries so that you don't give them the opportunity to mess with your life like that.
Absolutely, absolutely. And John, do you think, are there like some specific industries or maybe some sectors or company sizes that are more likely to be targeted for these worksite inspections?
Yeah, I think the consulting, staffing industries are the ones where all this focus is being placed. There is a smaller degree of attention given to EB5, and that's a kind of a minimal role for FDNS, but most of it is looking at F1 OPT issues and H1B issues. That's where the vast majority of their time is spent. And it's all, for those cases, it's almost all within the staffing and consulting industries for IT.
Okay. Okay, thank you for answering the question, John. Let me quickly say hi to RK. Hi, RK. I see your questions, and I'm going to take those and ask from John. And hi, Bhavin, Rahul, and Trisha. I'm very quickly going to take your questions. Please stay there. Let me, finish a few of my questions, and then I'm completely going to move to your questions. John, I would like to talk about the H1B lottery also for a bit. So the H1B lottery now, not only focuses on individual applicants, focuses on individual applicants and not just applications, right? So how does this new process change the odds, and how can people improve their chances?
So there's really no way to improve chances for an individual applicant any longer, because it doesn't matter how many companies register your name, you only go into the lottery once. So it's when they came out with the lottery the first time around, immigration lawyers looked at the process that they were suggesting and said, this is going to be a massive mess. You're going to have companies filing a whole bunch of duplicative registrations, and it's going to skew the odds in their favor. And USCIS, again, in their infinite wisdom, said they weren't concerned about that, and they would fix that problem by making employers certify that they would file a petition if they were selected in the lottery. And we all know what happened. They looked like fools for creating a lottery system that was so flawed, and so then they started lashing out at individuals and companies that got H1Bs for multiple registration filings. But in the new system, the new system is what a lot of people had recommended they do in the first place. And there's really no way to game that system. You go into the lottery once, it's in the random, and you get selected or you don't. And there's really no way to up your odds.
So then there is a downside to having multiple employers, submit registrations on behalf of the same candidate.
No downside, but there's no upside either. So, your name only goes in one time, regardless of how many job offers you have. So there's really no benefit or harm to having multiple jobs.
But then will this be considered, or maybe do you think it is going to reduce the chances? Because then, they might think that this person has applied a lot of times, or not the person, but has a lot of employers who have filed on his behalf. So will they consider this as maybe gaming the system? Because you never know. I mean, these days, anything is happening, right? So just curious to know.
Yeah, no, I don't think they'll consider that gaming the system, just because, again, gaming the system means that you're increasing your odds of selection, and there's no way to increase your odds of selection in the current system because your name goes in once. So the number of job offers you have is pretty irrelevant to where you may see them digging is in the petition process. If you have a whole bunch of different job offers, they may question if those were bona fide job offers. But as long as the petition that you're getting hired for is a bona fide job offer and they can establish that, I don't think it'll be a problem that you got a bunch of others.
Okay. And also, are there specific maybe degree levels or fields of study that are currently seeing the higher chances of selection?
You have the master's draft, master's lottery, and you have the bachelor's lottery. And again, there's really no way to game the system. So your odds are the same if you have a master's or higher, a qualifying master's or higher. And if you're in the bachelor's group, everybody has the same odds. So I don't think there's really any secret sauce that you can come up with to increase your chances of selection.
Okay, and what about the smaller companies? Because they often feel that maybe the larger companies have more chances. So do you think that the smaller companies have a disadvantage under this new system compared to the larger corporations that can afford to submit maybe more registrations?
Potentially, because if you have multiple employees that you're putting in, you would have more bites at the apple for those employees. But when it comes down to it in the adjudication process, if you're selected, you're still going to have to show that you have the bona fide job offer. And that's where, the abundance of job offers to people, either from the company side or abundance of job offers for the individual, isn't going to help you. If you're applying for 1,000 employees, it's highly unlikely that you're going to have 1,000 bona fide job offers. And so that's going to draw scrutiny. So I think it'll all even itself out, but I don't think it'll hurt or help in the selection process.
Okay. Thank you so much, John, for answering those questions. Now, I would like to also talk about the I-129 form. So, there's a new version of the I-129 form for all petitions, right? So, if you can please, tell our viewers that what do companies need to know about this new form?
So, for the new form, and also the supporting documentation, if you're doing staffing, they're going to want some extra details about the project and the client that you're getting placed at. And, again, this is one of those things that we're litigating, that we're preparing to fight. And if we're successful on this, the next thing we challenge is the form and have them change the form, because if the form is asking for things that, isn't supported by the outcome of the lawsuit, then the form needs to change. But for right now, the focus is going to be on the project and establishing whether or not you have a project. We're also seeing a return to a policy that was kicked out in court back in 2020, which is the short approval process. So you'll request the validity period on the petition, but if you don't have documentation to support a project for that entire duration, they're shortening it again. And so that's something that you're going to have to contend with, is do you have documentation to show that that project is going to last for the duration of the requested validity period?
Okay. So are there any particular sections of the new form that are causing maybe confusion or errors for applicants?
So not right now. I think most lawyers that are handling this are seamlessly transitioning to the new form. I'm not terribly concerned about the form per se as so much as I am concerned with the substantive requirements and the regulation that are driving changes to the form. And those are things we're just going to have to fight out in court. I think we'll be successful on the short-term approval issue. I don't think they can do that legally. And I think we'll be successful on their invalidating their project-centric requirement. But until we get there, USCIS isn't going to change until the court tells them to stop.
Okay. Also, but John, do you think that will there be any potential consequences maybe, or even if the applicants make even the minor errors or inconsistencies on the I-129 form?
So inconsistencies are always going to be a red flag. Okay. And so, for the employee, you just want to make sure that everything that you submit to your employer is as accurate as it can possibly be. And you just want to make sure that there's nothing in your work history that you're using to support your qualifications that has any problems. And it may be worth, talking to your own counsel, your own attorney, if you suspect there might be a problem, just to make sure that all your ducks are in a row and everything checks out. Your employer is hiring the attorney to file the petition, and you can't pay for that. Like in the rules, you're not allowed to pay for that for good reason, which means that they don't really represent you. They represent the employer, and they have the employer's interest at heart. So if you're concerned about a problem in your immigration history and how to deal with that and how to address it, it's best to get your own independent analysis of the situation by an attorney that actually works for you. And your attorney that works for you can talk with the employer's attorney, and that you can come up with a strategy that's best for your situation. But just don't get tricked into thinking that just because there's an attorney working the case for their employer, that they're worried about you. They're worried about the employer.
Okay. Well, thank you so much for answering these questions, John. Let me now quickly move on to our viewers' questions, because I'm sure they've been waiting to get an answer from you. So let me quickly take RK's question first. RK, he's here, and he says, do you see the new administration trying to change the H1B regulations? What do you have to say? Because they are mostly trying to change everything.
So here's the dirty little secret. As a general rule, and this was definitely true in the Biden administration, the political level, the people appointed by the president and confirmed by Congress, those people had very, very little impact, if any, on the direction USCIS headed. USCIS has been heading in the same basic trajectory for 20 years. And it's all the senior executive civil service people that are driving that. And they have been 100% on board with Trump from Trump's first administration. And in fact, the regulation that they created was pretty much everything that the Trump administration tried to do in its first term. And it got finalized under the Biden administration. It was basically a Trump regulation that Biden's team signed off on. But the people that were really driving that policy and doing that work were the career civil service executives. And they don't change with the administration. But they are completely on board with Team Trump. And I don't really see how Trump would make the regulation any worse than it currently is, because it's everything that they wanted on their first go around. So I don't really see them going through the regulatory process to change it, mostly just because it's a very, very long process. It's very difficult. And it's even more difficult when you have a brand new regulation that just came out. So I'm not terribly concerned about seeing any new regulations coming out dealing with the H1B.
Okay. RK, I hope you have got your answer. He also has one more question. He says, are they allowed to give short or 1 year extensions?
So legally, no. But are they doing it? Yes. Now, they were doing something similar back in 2018, 2019, and we sued them on it and pointed out where in the statute it says that they can't do that. And the court very quickly sided with us and invalidated USCIS's policy. I don't see how we're going to have a different outcome this time around, just because the law hasn't changed, the statute hasn't changed. And so I think ultimately that process will get invalidated again. But until a court rules on it, until the judge bangs the gavel and enters an order, we're going to be stuck with USCIS screwing people over by doing these short-term extensions. So far, I haven't seen anything as crazy as we saw in the first Trump administration, where you'd see one-day approvals where they were mailed out and they were invalid by the time you received it in the mail. That level of insanity hasn't occurred yet, but I wouldn't put it past them to try.
Okay. RK, thank you so much for your questions. I hope you have got your answer. In case you have more, continue posting your follow-ups in the comment section. And meanwhile, let me take other viewers' questions. Rag is also here, and Rag says, okay, I think, Control, if you can please show the question. Okay, what changes can we expect with L1A and blanket L1? It's not related to H1B, but if you would like to answer this, John.
Sure. So we're already seeing problems with the blankets at the consulates. I expect the L1 category in general is just going to get a lot of additional scrutiny that they haven't seen so far. I mean, the dirty little secret is, as much as USCIS hates the H1B program, they hate the L1 worse. And in their mind, the only people that really are eligible for L1s are massive multinational companies. And smaller IT companies really shouldn't qualify. I expect to see the policies of the consulate and also within USCIS to track their belief on that. And you'll see policies on L1s and adjudication trends on L1s get really, really tight and very difficult.
Okay. Rag, if you have any more questions or follow-ups, please continue posting them in the comment section. But I hope you got your answer. Thank you for your comment and your question. RK is actually back, John, and he says, so this means they will not try to remove the lottery method of selecting H1B.
No, they won't take away the lottery. There's really no way other than the lottery to do it, just because they get so many applications in a fiscal year that they have to do the lottery.
But John, don't you think, sometimes, because mostly, especially the current administration, they are always talking about, merit-based selection of the visas, and people should be here in the country on their merit basis, right? And then they have this lottery selection process. Do you think these two align with each other?
Yeah, so I guess the merit filtering would be, do you qualify for the specialty occupation? Do you have the required degree? Do you have the highly specialized body of knowledge? That's where the merit comes in. And if you have a whole bunch of people that have that level of knowledge and that type of degree, how do you pick between them? It would, the lottery is the most efficient way. If they switch to, a weighted process in the lottery where they give different points and weight to different factors, they could do that and change the lottery in that way. I'm skeptical about how effective that would be and how quickly they could get such a regulation through the process. I think that would probably take longer than they have patience for. And it would be harder for them to get worked out in practice. It's because I don't think they understand, the space that well. You don't have people working in USCIS that have, bachelor's or master's in computer science. You don't have people with the degrees, and the experience to even know how to create a weighted system because they don't understand the industry. So I'm not terribly optimistic that a weighted lottery process would come into play based on merit characteristics.
Okay. Thank you so much again for answering the question, John. Let me quickly take maybe Trisha's question also. Trisha is also here. Trisha says, what are the key changes to the H1B electronic registration process in 2025, and how can employers ensure they are complying with the new requirements?
So the biggest change is it's no longer an employer-centric process. Obviously, when you have employers, filing a whole bunch of registrations, and each registration goes into the lottery, there was opportunity for some shenanigans because you can dramatically increase the odds of one person selection by having a whole bunch of different companies filing applications. That's gone now, and so it's pretty easy to comply with the lottery rules at this point. Where the only thing that I have concern about going forward is how far USCIS is going to take this bona fide job offer at the time of filing requirement. That's what we don't know. If they're going to say that you have to have a signed contract at the time you file your registration, that would be an absolute nightmare. It's completely unworkable in reality. But if they took that position, if your job is bona fide only if you have a contract signed at the time of the lottery registration, that's going to be a mess. It's going to cause all kinds of problems for people.
Okay, so Trisha, I hope you've understood everything and you got your answer. Thank you so much for your question. Continue posting your follow-ups. But Rahul, also let me take the questions quickly. And Rahul says, I'm in the process of applying for an H1B visa in 2025, and I've heard there might be changes in how the lottery works. Can you explain what different this year and how it might impact my chances?
Yeah, so again, it's employee centric, right? So an employee can have 20 different job offers, but they only go into the lottery once. Whereas before, if they had 20 different job offers, they could go into the lottery 20 times. And so they would have 20 bites of the apple instead of just one. Now everybody has the same odds. Everybody has that one chance in the lottery. And there's really no way that you can game the system to increase your odds of selection.
Okay. Rahul, thank you for your question. Let me take Bhaveen's question also in the meanwhile. As a current H1B holder who wants to apply for a green card in the near future, do the 2025 changes to the H1B process impact my green card application or timeline?
So probably not the application or the timeline. But what I will say is we see USCIS has become very, very aggressive in terms of going through people's histories, especially their initial H1Bs, right before the adjustment of status interviews. So we see them go through initial H1Bs looking for any reason that they can invalidate that initial H1B and take the cap number away. So once they take that cap number away, you have no path for extensions. You would have to go back into the lottery to stay in the US while you're waiting for your green card. And we see them do that time and time again, where somebody's almost at the finish line, almost at their adjustment of status, and they screw with them by revoking the cap H1B. And it's almost always, in fact, I've never seen it go another way, based on something the petitioning employer did and not something the individual did. And we're 10 years down the road, and you're not working for that same employer, but you're getting penalized for what that employer did. And so just make sure all of your documents are very, very consistent and squared away. And if you're an H1B that's working for a staffing company, I would not go to your adjustment of status interview alone. I would take an attorney, and I would take an attorney that's a little more on the aggressive side, just to make sure that they are not just going to roll over and let USCIS mess with you. So I wouldn't do your application by yourself either. I'd make sure that you have an attorney put eyes on that and really scrub it to make sure that your 485 is tight and your supporting documentation is tight.
Absolutely. So make sure that you do that. Bhaveen, thank you so much for your question. And who better to deal with USCIS better than John, because John has an experience dealing with them. So make sure that you get in touch with Jonathan Wasden, everyone. You can give him a call on the number 844-592-7336. I would like to repeat the number, 844-592-7336. You can also email him. His email ID is support@wasden.law, support@wasden.law. And you can also visit his website, which is www.wasden.law. So make sure that you get in touch with him. And for your H1B cases or any immigration-related cases. Now let me move to another question from another viewer. I think Rag was actually back. So Rag said he had this L1. Okay, he has in this also. He says, with the Dropbox changes, will a third country national counselor option be in vogue again for L1 and H1B?
Sorry, say that one
With
again.
Dropbox changes, will a third country national counselor option be in vogue again for L1 and H1B?
That I'm not sure. I don't know. I'd have to look into that one, honestly.
Okay, all right. Thank you, John. Let me take maybe ZQ's question. ZQ says, are there going to be ICE raids in schools and offices? Sorry, seeking an attorney's point of view.
So if the schools are complicit, yes, I would say in your red states, it's definitely going to happen. I would not be shocked at all. Keep in mind the way the Trump administration is rolling out their entire immigration enforcement, plan is for maximum attention. I mean, Trump is an attention seeker who has to have people talking about him all the time, and there's no better way to do that than do something incredibly, confrontational, like sending people into churches, schools, offices, and that gets his base really excited because they love the idea of ICE going in and arresting people and kicking out illegal immigrants, and it gets him in the news. So it's a win-win for him. So yes, I would say the odds of that happening are incredibly high.
Okay. ZQ, I hope you've got your answer. Let me quickly move on to Empire's question. Empire says, doesn't the administration already have the regulations blueprint how to change the H1B to a wage base from the last term? I know wage-based H1B impacts smaller companies, but do you think it's fair? Not fair? I mean, do you think level 1 worker has the same merit as a level 4 worker? What do you have to say, John?
So, really, merit is a question in the eye of the beholder. If you're a small company, or if you're, any company, really, you've got to have people working at every level. You've got to have your entry-level folks that you're developing. You've got to have your senior folks that are kind of more in a advisory management expertise role. And you can't have, the saying is, too many chiefs and not enough Indians. You can't have too many people at the top and not have people at the bottom that you're developing and bringing along. So I think you need a mix in order for the system to work right.
Okay. Empire, I hope you have also got your answer. Thank you so much for your question. We only have 10 minutes. Let me quickly move on to our Facebook questions also, because we have a lot of questions coming from Facebook groups too. So Control, if you can please share your screen and maybe share the Facebook questions. Okay, so we have this question, John, from a viewer or a follower. He says, hello, can I submit the I-539 application online even though I have 2 children applying for F2 status? What do you have to say?
So I'm assuming they're talking about the extension of H4 status. So you can submit that online. If your kids are in college I guess I'm confused about what their primary status is. Are they an F1? I don't know. I need more details on that one. I need to talk to them offline before I can answer that.
Yes. So to this viewer, I would like to say maybe you should directly get in touch with John regarding your case so that he can help you better. And also, like he said, he would need more details regarding your case. So yes, for now, let's move on to our next question. So Saundarya says, hi all, asking for a friend of mine filed for an H4 extension and received the receipt notice, but the renewal is still pending. Their current EAD is valid until March 1st, 2025. Is there a risk that their I-94 will expire after that date, even though they have the EAD receipt notice? If not, what should they tell their employer to ensure their position is held during this time? Need guidance for what are the options they have with the employee, and has anyone been in this situation? What steps can they take? So John, if you can please guide them.
All right, I'm going to read that. There's a lot going on here. So, I mean, it is a common thing, and I think we're going to see a whole lot more of this, that they will be delaying the adjudication of the H4 extension, which causes a problem for those people that need the extension approved in order to have their EAD extended. The prior Trump administration, the first time around, put the H4 EAD in their crosshairs, and they were really trying to make it impossible for H4s to have employment authorization. Same with L2s. And they were trying to change the regulation to just fully eliminate it. The problem was they couldn't get it through the regulatory process. And so when they weren't able to get it through the regulatory process, they just changed the way they adjudicate the H4 and the H4 EAD. They first split up the primary H1 and the H4. And then they split up the adjudication of the H4 extension and the EAD. And so you had a process that used to take a couple of weeks that now is taking, upwards of a year. And they designed the adjudication process in a way to almost guarantee everybody with an H4 EAD would be without status temporarily and would be without an EAD. And you couldn't apply for your EAD because you didn't have status. I anticipate we're going to see something similar to that again, and we're going to have to go back into court again. The last time when they did this, we ended up suing and getting the process changed. And there's some structural things in the law that we were able to change through litigation, like L2s getting their EADs incident to status, so they don't have to apply for an EAD. But we're probably going to have to be going back into court on behalf of H4s, because these processing shenanigans that they're going to start doing are really going to mess with people's lives. So everybody in that situation really needs to be aware and needs to start taking some precautionary steps. And if folks want to reach out, we can tell them what they need to be thinking about doing early on to protect themselves.
Okay. All right. Thank you so much for answering the question in so much detail and for that insightful answer. John, let me very quickly take this next question. Navya, hi, I have a question related to document for Dropbox for H1B stamping. I'm working with consulting company. Can anyone please tell me if I should take EVL, employment verification letter, from the consulting company with whom my H1B is filed, or the client that I'm working with?
So that's something you'd probably want to have an attorney put eyes on both documents just to make sure, and also on the petition, just to make sure there's nothing that's problematic. But as a general rule, what the consulates are looking for at this point is they're looking for proof that you have a contract you will be working on, that you have a client project. And so probably both of those would be useful to submit. One showing that the employer issued you an offer, and the other showing that the client has a project for you to work on. But again, you want an attorney to look at those to make sure everything matches up and that there's no contradiction or inconsistency. Because if there's any inconsistency in those two letters, that's going to be the kiss of death. And so, talk with an attorney, make sure that you're not doing something that's going to end up hurting yourself.
Okay, all right. Thank you so much again, John, for answering that question. Empire, if you remember, is back, and he says if they aren't going to increase the cap, it's the next best thing is to try to give as much of the small 85K H1B to level 4. What do you have to say about this?
That's a policy decision. That's what they pay the people at the top of the government to figure out. And if they want to do it that way, that's fine. We can work with that. But, what is the best way to implement policy? I don't think anybody in the Trump administration is listening to me on that one. So my opinion probably doesn't matter much on that issue.
Okay. All right. So, Empire, I hope you have got your answer. Well, thank you so much, John, for being here again. Those were our questions and answers. And thank you so much. It was an insightful episode. I still have a lot of questions pending. But then I would like to do a part two of this and would like to ask those pending questions maybe in the second episode. And we can get into more detail about the H1B and the changes that are going to happen in to H1B in 2025. And we can take more questions because I still have a lot of pending Facebook questions too. So how about we do another episode on H1B and take the pending questions in that episode?
Yeah, sounds great.
Perfect. Thank you so much again. And to our viewers, I would like to say that to get in touch with John, make sure that you give him a call on the number 844-592-7336. I would like to repeat again, 844-592-7336. You can email him. His email ID is support@wasden.law. And you can also visit his website, which is www.wasden.law. Well, thank you so much again, John, for being here. It was great having you. And looking forward to seeing you very soon in another H1B episode.
Thank you, Rajni. It's good to be with you.
Thank you so much. And to our viewers, thank you so much for posting your questions. Thank you so much for being here. And I would also like to tell you that we recently launched, not recently, but today we launched our website, imisupport.com. So make sure that you also check out our website, imisupport.com. And if you have any questions, you can also reach out to me. My number is 732-707-9151. But for now, I'll have to take your leave and we'll be meeting very soon. But for now, like I said, I have to take your leave. Make sure that you like this video, share this video, and also subscribe to Immigration Talk Show. For now, take care, bye, and keep subscribing and keep watching Immigration Talk Show. Hi everyone, welcome to Immigration Talk Show. I'm your host Rajni Bharara, and before I move ahead, let me read out a very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to Immigration Talk Show. I am Rajni Bharara, your host, and today we are diving into a crucial topic: DHS targets visa fraud, what F1 and H1Bs need to know. Well, with new DHS policies cracking down on visa fraud, individuals with findings of fraud may now face deportation. Yes, this is especially alarming for those unknowingly caught up in fraudulent OPT employers. To break it all down, we have immigration litigation attorney Jonathan Wasden with us. John has years of experience fighting immigration cases, and today he's going to help us understand what these changes mean for visa holders and how to protect your immigration status. So, without any further ado, let me welcome John again to Immigration Talk Show. John, welcome back.
Thank you. Thanks for having me, Rajni.
Thank you so much for being here. And this is a very important topic, John, and very timely one. So, before I move ahead with my questions and before I, begin with my questions, John, if you can please give the audiences a brief about this new policy of DHS.
Sure. So the NTA, or notice to appear process, initiates the deportation or removal process. And that's what DHS's Immigration and Customs Enforcement, ICE, needs in order to, arrest, detain, and eventually remove or deport somebody. The policy over the notice to appear process has been in place for the previous policy, I should say, has been in place for a while, and it just prioritizes who the current administration wants to see removable and removed. And the Trump administration just came out with a new, updated, changed version of their policy and their priorities and what they're looking to attack and remove. And embedded in there on page 4, in paragraph 4 of page 4, is something that I think is very telling about what USCIS has been doing for a long time, and then also telling as to what the Trump administration wants to do. And that is really going after these secret fraud findings that are entered by DHS that you have no notice or hanging over your head until you're in a situation where it's very hard to challenge.
Wow. But John, when you say that the current administration want to see removed or want to remove, what do you mean by that? I mean, who they want to remove?
So, there always has been a big push for people who are, unlawfully present, who have entered without a visa or have overstayed visas for a certain period of time. Criminal, what are called criminal aliens, people that have certain qualifying convictions. They've always wanted to remove those people. And so that's not terribly earth-shattering or nothing about that is particularly new. And what is new, though, is targeting people that have unknown fraud findings against them and including them. All of those other people that we just talked about, there's very clear violations of law. They had an expiration date on there's I-94. They overstayed that for more than 180 days. And, they're here unlawfully or accruing unlawful presence. Or they were given some other type of notice that they had done something wrong, or they were on notice that they had done something wrong. What's unique about the current changes targeting those with undisclosed fraud findings is that you don't know that you've done anything wrong. It's just some USCIS employee subjectively looking at your record thinks you've done something wrong. And you've never had any notice that that's going on, and you've never had an opportunity to rebut that allegation. And they're taking those very subjective findings by some random USCIS employee and using those as a basis to put people in deportation proceedings.
Wow. So does it mean that whether you are legal or illegal, you have the equal chances of facing a deportation now? Because you don't know.
So I guess it just creates a lot of certainty about who is legal and who is not, because you could have a valid visa and you could think you've done everything correctly,
Yeah.
But somewhere in the back of USCIS, they've gone through the process of identifying, you as somebody who is inadmissible and therefore eligible for removal. What's the real problem with that is they're making that decision here in the U.S. based on facts that occurred here in the U.S. Under any recognizable process of law. They would have to give you notice and an opportunity to respond, and then give you written notice of their decision after they've evaluated your response. That's a very, very, very basic requirement in American law for these administrative proceedings. And they're just completely going around that and just ignoring what the law says that they have a clear obligation to do.
No, so they are just trying to find a loophole, and as soon as they are able to get it, they are trying to implement it as in the name of policy.
So,
Is it?
yeah, so a loophole would imply that there is, a gap in the law. But there's very clearly no gap in the law here for the government to point to. The law is incredibly clear, it's explicit, that when they're going to take an adverse decision or adverse action against a non-immigrant, they have to inform them of the intended action, and they have to inform them of the evidence or information that they intend to rely upon, and then they have to give them a written decision letter. And they're not doing any of that. And there's very specific reasons why they're not doing that, because they want to put people in a position where their access to the courts is minimized so that they can avoid judicial review of what they're doing. If they think in their mind, if they wait until you're out of the country, the consulate, where you have limited access to the courts, or at the port of entry where you have limited access to the courts, or in the removal proceeding process, that their law breaking will never come to light. And that's their intent.
Okay. But John, also with this, I would also like to know that under this policy, what actions are considered to be a visa fraud?
So they don't really get into that, but what we have seen just in practice is, these people who were on OPT here in the US, especially during COVID, it seemed to start during COVID. There were scam companies that were going out on LinkedIn and other social media networks, actively recruiting recent grads who were from China and India predominantly. And they would go through this sham interview process that looked really legitimate. Some of the companies were actually at one time legitimate companies and just kind of went off the rails and started scamming people. So those companies actually had, prior projects and prior contracts that they could point to in the recruitment process. So by every measure, these looked like legitimate companies. The recruitment process looked legitimate. Then they would hire you, you would get your OPT, you'd list the company on your I-20, and then they would spring on you, in order to place you at a project like we promised, you need some additional training. And so you need to pay us for that training, and we'll give you the training. And that is the basic scam. And then once you pay them the money, sometimes they would have training, usually it'd be kind of dubious quality, and then you'd never hear from them. And that was the basic setup of the scam. So you would realize the scam and then move on and find a new employer. That is what USCIS has been saying. It constitutes immigration fraud, not on the company, but on the individual student. And that's one of the things that we've been fighting in court for quite some time. And the government so far has been very reluctant to defend.
Wow, so but I'm sure all these peoples, because a lot of them when they apply for visas or when they want to work abroad, they don't. I can call it lack of information, because sometimes they don't know that they just want to get in, right? They just want to take a job or get a job. They because of the lack of information, they don't know that this is a rule under which you're not allowed to pay or you cannot pay. So, but then, John, is it a rule? I mean. People are people aware about this?
So there are certain rules prohibiting payment to employers. Usually that's in the H1B context, where it's explicitly clear you can't pay for the attorney fees and you can't pay for any of the fees associated with the petition or the LCA preparation. This is a little different. There's really nothing on point saying that you can't pay somebody for training, you can't pay for marketing or what have you. The, you know, what USCIS tries to do is they try to, when they do site visits or at the port of entry with CBP, is they try and force you to say that you didn't pay for the training, you paid for an offer letter. And if you paid for the offer letter, then boom, they say you're guilty of fraud. But they assume everybody paid for an offer letter. And they ignore the fact that, the representation that was made to them was you're paying for training so that we can then market you for contracts that, the company would make money on, presumably. And so, what USCIS considers to be fraud doesn't really match up with the definition of fraud that's in the law.
Okay. Okay. And before I take up my next question, that a lot of people have joined us. So let me quickly say hi to all of them. I think Ashwin has also dropped a comment. So hi, Ashwin. We'll be taking your comment in a bit. And guys, if you also want to ask your questions to John regarding this topic, you can also give us a call on the number 425-436-6335. And don't forget to put the access code 988888. Yes, you can join us on a call and ask your questions from John. And if you're liking this webinar, if you're liking this show, make sure that you like it, share it, and also subscribe to Immigration Talk Show. And yes, coming back to the topic, John, then also, I would also like to understand that how does DHS investigate or do their research and find out that this maybe the student or this person who holds an H1B visa is committing a fraud?
So, as near as we can tell, because they haven't really disclosed any of this information to us, and maybe that's the better place to start. DHS runs E-Verify, which is the process and the database that students rely on to determine whether or not the company that they're accepting a job offer from is legitimate. And they've been certified by DHS as being so. All of these companies that we're talking about were E-certified. So you get the job offer, the first thing the student does, they go check the system. Yes, they're legit. And then they proceed on with the interview process. The DHS has not disclosed at any time publicly what companies they suspect of committing fraud in this way. So you would think that the government would be looking out to protect people and would alert the public to these companies are suspect and we've blacklisted them. But they're not doing that. And they're not doing that because, such a blanket blacklist would be illegal if they were admit that they were doing it. So that's the first problem that we've got here is just the very nature of the blacklist is something that they realize that they're not able to do, and so they're not publicizing it to the world. Instead of taking a proactive approach and helping people, they're intentionally letting people step into a trap and then penalizing the victim of the trap instead of the person that set the trap.
Okay. So that basically they're setting a trap and wanting people to, get in.
Yeah.
Okay. John, with this also, I would like to know that how does it also affect, people who are currently participating in OPT and those holding H1B visas, or maybe someone who is currently seeking a re-entry into the US?
So if they have one of these blacklisted companies on their I-20, then they should be concerned. And you know who these people are because you have friends that have tried to go get a visa stamped and have been told, no, sorry, you worked for a blacklisted company. USCIS made you inadmissible for fraud. And so if you have people that or some of these companies were so large that it's common knowledge who they were now, then you can reasonably expect that at some point in the future, it's going to catch up with you. There have been people that have made it in and out of the country multiple times and have gotten stamped multiple times that have worked for these companies. But inevitably, at some point, all of them, even with multiple re-entries, have gotten hit. And they find out about it at the port of entry or when they go for stamping a later date. So it's going to catch up with them, whether or not they have a new visa category or an H1B or an F1 with a new employer, it will follow.
Okay, then what steps should they take? I mean, these OPT participants and H1B holders, to ensure the compliance with the new policies, and and also especially when they are traveling, they're planning to internationally travel.
So definitely, if they have impending travel, they should talk with a lawyer about how to handle CBP, what CBP is going to say to them, and what they should say, based on the facts of their particular case. CBP is very aggressive these days, much more so during Trump than they were, under Biden. And we hear stories every day from clients that after the fact, they weren't clients before, but they go through CBP. CBP puts them in secondary, grills them, terrifies them, and threatens them with jail time, which is absolutely absurd. They can't do that. They can't put you in jail for working for a blacklisted employer. They know that, but you don't. And so they get you to sign some incriminating confession that they wrote, and you haven't typically had a chance to review. And then they use that to support their decision for expedited removal. So to protect yourself from that, there's two things you can do. Talk with an attorney, figure out what your actual rights are at the port of entry, and then have a G28 form signed with that attorney so that if you're in that situation, you can request CBP contact your attorney and allow your attorney to get involved. They don't have to let you do that, but they won't do it 100% if you don't have the G28. So that's an important first step to take.
Okay. Thank you for answering the question, John. A lot of people have joined us. RK is here, Santosh is here, and also Ronak is also here from LinkedIn. Guys, I'm quickly going to take your questions. But before I do that, John, I would like to come back to you and ask that does it affect F1 students the same way it is affecting the H1B holders? Or, I mean, they will have to take different steps?
So for this current situation that we're talking about, the OPT scams where they scam students, that is applying to people regardless of their current or laterally acquired visa status, because we're dealing with what's called admissibility.
Mm-hmm.
So anytime there's an extension of status, a change of status, or a visa stamp, or an admission at the port of entry, your admissibility is being reviewed. And if at any point during your immigration history, somebody has marked you and determined that you committed immigration fraud, that should prohibit you from ever getting any other immigration benefits in the future. And so it doesn't matter that you switch back and forth to different categories. If that inadmissibility flag is on there and has not been removed, it's going to be a problem for you at some point.
Okay, okay. And with this also, John, I mean, how can these F1 students verify the legitimacy, the legitimacy of their potential employers? I mean, whether the job and the employer is someone that they should be thinking of working.
Yeah, well, they unfortunately can't rely on the government to vet people and disclose who are problem companies. So it just really requires a lot of self-advocacy. You've got to go out there and ask for references of, other employees that have worked for them to verify that they're actually doing what they say they'll do, that they're actually placing you on a project, that, everything is working the way that they're promising in the interview. And then just in utter abundance of caution, anytime an employer is asking you for money, run. Don't do it. Just, it's not worth it. It will only be seen as something that's bad for you in the future if it comes out. Even if it's just for marketing, even if it's just for training, I would say just protect yourself and don't do it.
Okay, that's a great advice. Thank you for that, John. Now, I think I should take the viewer's question. And guys, I would also like to tell you that very soon we are going to have a detailed webinar on this topic where John is going to take each and everything about this topic and going to inform you everything in detail. So you are allowed to join that webinar, and the details are going to be soon out when it is happening. But then I am informing you about it. So, stay tuned with Immigration Talk Show. We are going to post about it. Okay. Let me quickly take maybe Ronak's question first. Ronak says, if somebody has a fraud company on their service, Do people need to reach out to Jonathan now, or do they have to wait? John, what do you have to say?
So we have a lot of people that have got these companies listed on their I-20 and have never been given notice that there's a problem yet. And that's very typical for people who have stayed in the US that have changed status to H1B or continue on F1 status. The reason why that's so typical is that USCIS is intentionally not giving you notice, and they're waiting for you to leave the country. Because if they gave you notice and a chance to respond and made a decision, you could very easily challenge that in court. So what they're doing is they're waiting for you to leave the country and wait for the consulate or the port of entry to tell you, because that becomes much harder to challenge if the consulate denies your visa or the port of entry removes you. So, and in most cases that we do, we have a mix of people that have never left the country, that have never been informed of a problem, and people that have been to the consulate and put in 221G and been told that USCIS flagged them for fraud based on these OPT companies. So, if you worked for one of these companies and they've been blacklisted and people have had problems just by the mere association with them, then, reach out to us and we can discuss it with you, because it's probably better to be proactive and take this before you get notice than be reactive. It'll save you a lot more time and a lot more hassle.
Absolutely. And Ronak, I don't think so. In things like these, you should delay them. You should directly get in touch with John and his team. The details are mentioned, on the screen. You can give him a call on the number 844-592-7336. 844-592-7336. You can also email him. His email ID is support@wasden.law. And you can also visit his website, which is www.wasden.law. So yes, get in touch with John and his team as soon as possible, so that they can help you with your concern and with your immigration related case. And John, before I take Karan's question, Karan has also posted a question on LinkedIn. Before I do that, I would like to also talk about the case that you recently won. If you can please, inform. I already know, but also our viewers about it.
Yeah, in a similar vein, USCIS was penalizing students for their employer's multiple registration violations for the H1B lottery. So we sued on behalf of a plaintiff who was a student who was changing status to H1B, who'd been selected in the lottery, and he had been working for a while, and then they revoked the cap number and they revoked the petition's approval. And so we went to court saying you can't take away his cap number because he's done nothing wrong. The law only allows you to revoke a cap number for fraud when it's the individual foreign national or non-immigrant who's committed the fraud. The government tried to get the court to dismiss the case, saying that the court didn't have jurisdiction or that wasn't a valid claim. And the court told the government, no, this is a valid claim, that we do have jurisdiction, and now the government has to defend the merits of their decision, which is going to be very tough for them to do, in my opinion, because the law, again, here is pretty clear that in order to take somebody's cap number and penalize them by revoking the cap number, they have to have been guilty of doing something that made them inadmissible.
Okay. So congratulations on that win, John. I have a lot of questions about the case, which I'm going to ask, but maybe before that, let me take Karan's question. And then, we can, after some viewers' question, maybe we can talk about the case a little bit. So Karan here wants to know, when should someone clear their record? Is there a specific timeline?
So there's a statute of limitations of 6 years that applies to when you've gotten formal notice of something. The problem is, if you wait until you get formal notice, you might be in a situation where you don't have access to the courts to clear it. So again, if you're at the port of entry and you get removed, if the port of entry says that they're basing that decision on their own discretion or their own analysis of this situation, there's not much you're going to be able to do. Same with the consulate. So the only time that you'll be able to sue once you get notice from the consulate or the port of entry is when they openly disclose that it was USCIS. And to avoid being in the uncertainty of that situation, it's probably best to do it earlier and before there's a problem and before you're in a situation that it's much harder to overcome.
Right. So, Karan, also, I would like to suggest you to get in touch with John and his team. They are going to help you with your case. If you have any concern or anything else that you would like to know about, they are there to help you out. So, make sure that you get in touch with him and his team ASAP, as soon as possible. And the details are again here on screen. You can give him a call on the number 844-592-7336. Send him an email at support@wasden.law, and you can also visit the website wasden.law, www.wasden.law, to know more about his team. Okay, so I think we also have, and also Ronak and Karan, if you have more follow-ups, more questions, please continue posting them in the comment section. Meanwhile, let me quickly take RK's question. RK says, do USCIS allow for applicants to report those scams? Because that would help in the future if candidates don't report it, even if innocent wouldn't. You think USCIS would believe you are in on the scam? There's no full stop, no comma, so I just read it. I hope you understood, John.
So, in theory, that would be definitely the best option to take. I would say if you're considering going that route, then work through an attorney. I would say, frame it in the way that you're reporting a crime. Because if you're reporting a crime, certain protections will apply, and that might help you. However, the problem with dealing with USCIS is when you think logically and you try and come up with a reasonable approach, that's always the wrong approach in their mind, because they don't think logically and they don't think reasonably. And so, you think you're trying to do the right thing, but it still could end up, biting you. So I'd say really talk with an attorney and come up with the best strategy if you're inclined to go that route, just to make sure you don't inadvertently say something that's going to be damaging to your future.
Okay, but John, with this also, if you can also tell us that what legal defenses are available to individuals, who receive an NTA based on this alleged visa fraud.
So once you go through the NTA, once you get the NTA and you go through immigration court, it's normally they rely on documents and evidence that has already been vetted through the administrative process that you've already responded to, and you're not shocked by any of these things. This situation is new. It's never happened before that somebody's just been thrown into removal proceedings on a secret fraud finding. And so I don't know that anybody really has the answer for how that's going to play out in immigration court. But at any rate, the government will have the burden of proving that you are inadmissible. And they will have to go through the elements of what constitutes fraud or misrepresentation under the law to show that you committed those things and that was a knowing action on your part. I think for most of these people, that will be incredibly difficult to do for most people in this situation. And they probably will expend a lot of resources, and the government will expend a lot of resources trying to remove people. And I'm not sure that the outcome is as certain as they think it is. But the downside to that whole thing is, are your odds of winning an immigration court good? I think so. But does that mean it's not going to ruin 5 years of your life and cost you a ridiculous amount of money to fight? Yeah, that's likely as well. So, I think if you can avoid going through the immigration court process, that's always the best option.
Okay. Okay. Rag is also here. He says, John, what are the repercussions of TCS and L1A?
In what regard? If you have a fraud finding, that the fraud findings are going to apply to any visa category. Doesn't matter what category you're in, when they put it on you, it will continue to apply to new categories or new admissions to the US anytime.
So it's going to be the same for everybody.
Yeah.
Okay.
Yeah. There's no way, that's part of the reason why they went through all these biometrics, right?
Mm-hmm.
Your records now are all tied to biometrics so that they can prove that there's one person that this applies to and it's going to apply to them forever. And just because you change status, just because you leave the country for a while, even if you get, citizenship in a different country like Canada, those records are still going to be there and still impact you.
Okay. And I think, John, he's asking about what are the repercussions of the TCS L1A episode. I think they were recently caught doing a
Oh,
scam. Yeah.
yeah. So keep in mind there's two different things going on in the approval of any employment-based non-immigrant petition. There's the petition's approval, which gives the employer the right to hire and employ you, make money off of your work. And then there's the status that the individual gets. And the status can only be given to you if you're admissible to the US and you're eligible for the visa category. Like you have the right background or right skills necessary for the visa category. So as long as the individuals have not done anything to jeopardize their status, and as long as there's no evidence of that, in theory, they should be fine for future visas. The problem with that is, USCIS has created so much unpredictability in this situation like this that they inevitably attack the employee for something the employer has done because it's easier for them to do that. And so, that's what creates uncertainty. We just don't have an explicit answer on how they're going to handle this situation, and a lot of it's going to be case by case and what information is in there that the employee has provided that impacts their admissibility.
Okay. Okay. So, Rag, I hope you have got your answer. Thank you so much for your question. If you have more, please continue posting your follow ups. We'll take them in a bit. But, John, I would like to again come to you and also ask you that, let's say, if somebody receives an NTA, then what is the role of the employer there? I mean, can the employer help the employee in some way? I mean, that's a bizarre question,
Um,
but yeah.
yeah, they can. They can help with, getting an attorney for them and, giving them emotional support. But you're just going to have to look at all the surrounding facts of each individual case to determine, what you should do next.
Okay, okay. And then what should, as soon as, if the individual receives an NTA, then what should the employer do? If, I mean, of course, the employee is going to inform the employer. So what should be the first step of the employer?
So the employer should talk with their immigration counsel immediately and determine what the current status for that individual is and whether or not they can continue to employ them legally in the US. So that's on both the employer's interest and also the employee's interest, because if there's unauthorized employment involved, that makes your situation worse. So it's best to get with an immigration counsel and discuss, okay, what is our situation, what's our status, and what can we do to continue working.
Okay, okay. Thank you for answering the question, John. Rag says, thanks, Rachni and John. Thank you so much, Rag, for your question. And let me take Ashwin's question quickly. Ashwin says, I'm an F1 student on OPT and I have recently changed employers. I just heard that DHS is cracking down on visa fraud. How do I make sure my employment records are solid if I ever get audited?
So you just want to make sure that, if they're on your I-20, if you didn't have any work that you actually did for them, how you report that is going to be a important distinction. So if they didn't give you any projects to do or any work to do, I wouldn't really list them on your resume as a prior employer because you don't have any experience to point to. Because if you list them on your resume and submit that resume with an H1B petition, USCIS may see that as immigration fraud because, you made yourself look more eligible for the position than you actually were, by misrepresenting how you acquired your specialized body of knowledge. So, you really need to evaluate what was done with each employer and whether or not you should put them on your resume. Now, they will be on your I-20. And there's nothing you can do about that. It's going to be there forever. So if you're questioned about that and they didn't ever give you a project to work on, you just need to explain, I didn't list them as an employer because they never gave me any work. So, what would I say about that on my resume in terms of duties accomplished or things accomplished? So just be very clear why you're not listing them if asked.
Okay, okay. Thank you so much, Ashwin, for your question. I hope you have got your answer. In case you have more, please continue posting follow-ups. Let me quickly take Santosh's question also. He says, I have been working on an H1B for 2 years. My employer originally filed my petition with one work location, but I was later assigned to a client site. Could that put my status at risk if DHS investigates my case?
A lot of variables there. It would just really depend on where each location is and, if it's in the metropolitan statistical area. So that's something you'd really want to just talk with an immigration lawyer about, just to get all the specifics to get an answer that's accurately tailored for you.
Okay, but John, how do they pick? Because I'm sure there are so many people who are working in the US on different visas, right? So then, how does DHS picks that this is the case that we are going to investigate, or maybe this is the employee, or this visa is the visa that we will be giving more attention to? How do they pick?
So with USCIS, it usually starts with the FDNS site visit process. So they'll do a site visit, and then they'll ask for a whole bunch of information from the employer that they're really not entitled to and they have no business asking for. But a lot of times employers will just blindly give it to them. And then they go through that data and they look for any type of discrepancy with other visas that the employer has. So if they see that somebody's assigned to a location outside the metropolitan statistical area that's on the LCA, then that will get flagged. So you just have to be very careful of what information, if you're an employer, what information you give to FDNS. And if you're the employee, I would highly encourage you not to talk to FDNS without an attorney there with you or on the phone with you. And preferably don't talk to them and let the attorney do all the talking for you, just to make sure that whatever you're saying doesn't get twisted.
Okay. All right. Thank you so much again, John, for the answer. I think we have got a follow-up from Rag and RK. Before that, I would like to take another follow-up, which I don't know why, but it didn't come through. But it is again from Ronak, and he says, approximately how much time does it take to clear the record of fraud finding?
So in the cases that we've had so far, it's kind of run the gamut of a certain amount of time. What we do know with accuracy is that once you file the case, the government has 60 days to come back into court and tell the court what they're going to do. If they're going to defend the case or if they're going to settle the case. What we've seen happen in practice, though, is the government has asked for additional time so that they could identify who the plaintiffs are and just make sure they had the right records that they were looking at. They've asked for that additional time, and then they've entered settlement negotiations with us where they said, okay, we'll put in court a document saying that there's no fraud finding if you'll dismiss the case. So we do that, we dismiss the case, and then people have that document that they've been able to take to the consulate and through the port of entry saying that there's no fraud finding. That's come in handy for a lot of them because not everybody's records were magically wiped by USCIS. So when they went to the consulate, even if they'd been before and were told, you have a fraud finding, there's nothing we can do for you, they go back to the consulate, they give them that letter. Or if they get questioned about it at the consulate for the first time, they give them that letter. And so far, that's allowed them to get stamped and re-enter the U.S. So that's the process. It's taken anywhere from those 60 days to 7 months in the more extreme cases.
Okay. Thank you so much, Ronak, for your follow-up. If you have more, please continue posting them. I hope you have got your answer. I can see Rak's follow-up, so let me take that first. Rak says, does the DHS and USCIS have the access to the IRS, IN, and W-2 data?
So they don't have access to IRS information. The I-9 is something that is not an IRS document. It's a DHS document. And so they have access to that, but usually they do an I-9 audit and they come and take the employer's records and they look at the employer's records that are kept there at the office.
Okay, all right. Rag, I hope you have got your answer. Let me take RK's question. He says, what will happen with individuals' authorization to work while in immigration court due to this NTA for fraud?
So anybody that goes into the immigration court process, can apply for an EAD while you're in immigration proceedings. Yeah, how long they take to act on that is an open question, and how long it'll take to get your EAD is, an obvious concern. And then, it's probably going to be for limited duration. You'll have to renew that. It's just going to be a never-ending stream of hassles. But it potentially is possible to get an EAD while you're in immigration court proceedings.
Okay. Okay, thank you so much for answering the question, John. Thank you so much, RK, for your question. And I hope you have got your answer. And Ronak says, thank you very much, John and Rajni. Thank you so much, Ronak, for your question. And also, guys, I would like to tell you that very soon we are going to come up with another webinar on this topic, on this DHS's policy with John, where John is going to delve deep into each and everything specific related to this policy. So make sure that you join that webinar. The details are going to be out soon. So for that, you have to subscribe and you have to follow Immigration Talk Show so that you are informed about the upcoming webinar. It's going to be a detailed one, which I don't think so you should miss. So yes, stay tuned and subscribe and follow. Rag is back, and Rag says, do L1 employees also carry a PAF, public access file? What do you have to say, John?
So the public access file is definitely an H1B policy. I do the litigation in the firm. Justin Rivera does the non-immigrant visa filing. So I'd defer to him on that, but I don't think the L1 is something that has a public access file.
Okay. All right. So Rag, let us know if you have more follow-ups. Thank you so much for your questions, guys. So Priya is also here. I don't think so I've taken her question. So Priya says, I was previously on an F1 visa at a university that was later flagged for visa fraud. Even though I'm now on an H1B, could I be affected if DHS starts reviewing past students' records?
We have seen those cases where people are in that situation. I would say get with an immigration lawyer as fast as you can and look at all of your records and see what your exposure is and what risks you're looking at in the future.
Okay. All right. So Priya, I hope you have got your answer. Karan says, thank you, John and Rajni. Thank you, Karan, for your questions, and make sure that you join us on the upcoming webinar with John, where John is going to talk in detail about this policy and about fraud findings. So whatever questions yeah, please go ahead, John.
Oh, sorry, Rajni. On that with the webinar, so one of the things that the government has been saying in court and defending themselves in court with is that they do not engage in secret fraud findings. This new policy that they came out with admits that they do, if you look at that paragraph 4 that we mentioned earlier. So we're restructuring the entire way we're doing these cases now and incorporating that into it, because that is really damaging information. And that's something we'll talk about more, the strategy that we've got for the upcoming lawsuit in that webinar.
There you have it. So guys, make sure that you are constantly following Immigration Talk Show so that you know when the next webinar is. We are very soon going to come up with this webinar. So prepare your questions. I mean, if you have any questions, you can ask John in that upcoming webinar. For now, John, I would like to come back to the case that you won. So if you can please tell us, what legal precedents did you put in front of the court for for the H1B visas those were filed multiple times by the employers?
So the motion to dismiss stage is the first of 2 stages in these types of cases. And the motion to dismiss stage is on really, really nerdy procedural lawyer stuff. And whether or not the employees had standing to sue and challenge an action that was taken based on the employer's conduct. And we just pointed to the body of law that says you can challenge a government action that negatively impacts you, even if it's because of the actions of a third party. They weren't immigration cases, but we made analogies to those other cases. And we also just said, the Administrative Procedure Act is very clear. If you are an interested party, and the only person that's interested in the cap number, as opposed to the petition's approval, is the foreign national. So they're the ones that have been impacted. And if you've been impacted, you can challenge a government agency action that it's negatively affecting you. And those are really not controversial concepts, but the government's been fighting along those lines in each case. So I think we're on a good track for those other cases that are still out there.
Also, John, but then how does this ruling affect, the current and the future H1B visa holders?
So it'll affect those people that had their H1Bs revoked because of this multiple registration issue. So when they go to court and they sue on this, there'll be precedent that says, yes, you're legal, you're allowed to sue the government on these facts. And that will streamline their cases and save them some hassle.
Okay. All right. Okay. And also, if you can tell us that what measures can be implemented to ensure, that employers adhere to ethical practices during the H1B registration process, because I think it is going to start from tomorrow. Tomorrow is the D-Day. So if you can please.
Well, when they came out with the prior lottery rules, the way that they were doing it based on the pre-registration, everybody knew this was going to be a problem. And immigration lawyers tried to convince USCIS to do it differently and to make it an employee-centric as opposed to, a registration-centric selection. And USCIS refused to change because they didn't have time. They took too long to get this out, and they needed to have it ready for I think it was the 2020 lottery. They've now changed it because of what a debacle this was, once their incompetence came to light. And now it's an employee-centric. So you can have multiple offers, but your name only goes into the lottery once. So I think a lot of the shenanigans have been eliminated just by virtue of that rule change.
Okay. All right. Thank you again for answering the question, John. Before I take up next, I think Rag is here and says, is it prudent to hire an immigration attorney closer to the employee's work location to aid FDNS process, or should this not matter much? What do you have to say?
So typically the FDNS stuff is not done in person. The only time it's done in person is when they, knock on your door, at your home, like on a weekend morning, and try and talk with you. And at that point, it really doesn't matter where your attorney is located at. They're not going to be at your home, and it's going to be up to you to use your wits to remember that you have a lawyer and to tell them to, contact your lawyer if they want to talk to you. So most of these things, though, are done via email or done through a phone call, or sometimes even Zoom. So I don't think it really matters so much where they're at, but it matters that you have a relationship ahead of time so that you know what to expect when they do come knocking on your door on Saturday morning, before, you fed the kids and really gotten ready for your day, so that you don't get shocked by that and stumble and do something you'll regret later.
Absolutely. And like they say, precaution is better than cure. So make sure that you take it in time. Okay, John, coming back to the case and coming back to H1Bs, I would also like to know that what steps can, the H1B beneficiaries take if they suspect that their employer is maybe doing some fraudulent registration practices?
So, again, the way they've restructured the registration system, it's probably not a huge concern anymore. If they feel like something is just off with the employer, if they feel that something's a little fishy, don't work with them. Find somewhere else. Go find a new employer, because it's not worth it, because USCIS always is punishing the employee. They almost never take action against the employer. And most times they'll punish the employee for things the employer did. So that if you don't have a good feeling about what your employer is doing, trust your feelings, go somewhere else.
But then why is that? Why are they always after the employee and not the employer? Is it because they don't have money? I mean, the employer doesn't have
It's easier. Yeah. It's easier. In the law, there's really nothing that gives them the ability to, wholesale sanction an employer legally. they're kind of doing that under the table a little bit. But the only way that they can really impact things is through adjudication of non-immigrant petitions. And so those petitions affect obviously the employee. And that has always been their approach, is that they'll punish the employee through the petition decision, but ironically, they won't let the employee represent themselves in the petition process on any of these issues that are impacting them. And so that's why I say, if you don't have a good feeling about your employer, it's best to look elsewhere.
Okay, okay. And John, also, I mean, do you anticipate further legal challenges related to the H1B registration practices?
I don't think so. I think with the new system in place, I don't think anybody's really got a reason to challenge. I don't think it's really going to be something that people are motivated to fight.
Okay. John, thank you so much for answering the question. I also would like to discuss, Elon Musk's immigration status scrutiny. So, I mean, there were reports which surfaced suggesting that Elon may have worked in the US without proper authorization during the 1990s. So, if this is proven, this could lead to a revocation of his US citizenship, right? And maybe some potential criminal charges too. So I would like to know from you that what are the potential legal ramifications for individuals found to have worked without proper authorization in the US?
So you're right. In theory, there is denaturalization. And if you were found to have achieved your green card, in an illegal manner, then you can't have legally naturalized. And so they kind of trace it back that way. So if any of these things were found to have shown him ineligible for a green card, in theory, he would be, denaturalized in an unbiased and impartial process. But, obviously, Elon Musk is allowed to play by different rules by Trump. Elon Musk can wear a T-shirt to the White House in a cabinet meeting, but Zelensky can't wear his sweater to the Oval Office because that's disrespectful. So I don't see Trump ever holding anybody responsible that's in his inner circle, because corruption works that way.
Right, but then also, taking such steps and doing such things, can it also ban you completely from entering the US?
So once you have your citizenship, they have to go through the denaturalization process. But if you have unauthorized employment, that does lead to 3-year bars and 10-year bars, depending on how long you worked without authorization. So that could impact whether or not somebody legally acquired their green card status.
Okay, okay. And about, the case that we discussed, the Elon Musk case. I mean, John, how do you think, such high profile cases, how do they influence people's and, public's perception and enforcement of immigration laws?
So I think it's pretty clear that there's two different sets of rules in Trump's mind, at least, and Stephen Miller's mind. There's the rule for white people in European countries, and there's the rule for everybody else. And you see that in their policy and the way they enforce. So I think that's, as long as we have Trump and Stephen Miller in play, that's what we're going to have to be looking forward to, and taking extra steps to protect yourself, because they're trying to create an uneven playing field.
Okay, all right. Okay, I think I was just about to, wrap up, but then we have got another question for you, John. V2 is here and says, I am on an H1B visa and recently filed AOS. I-485, I-131, I-765. My I-765 is approved, but I-485 and I-131 are pending. Do I receive the EAD card or just the I-797A approval notice? And
You should receive.
Yes, please go ahead. Okay, I think, guys, there is some technical error or maybe a glitch. Okay, I think John is back.
Rajni?
Yeah, I can hear you, John. Please go ahead. John, can you hear me? Hello, guys. I think there is some technical error. We can see John very clearly, but we can't hear him. I mean, we can hear him, but he can't hear us. So maybe John, can you hear us now? Okay, maybe we can try to reconnect. Okay, we are going to fix this issue, and John is going to be back soon. And we too, please stay here, and he will be answering your question. And yes, we are going to fix this issue very quickly. Let's go take a short break until then. And yes, we'll be back right away. You don't go anywhere. Thank you so much for waiting so patiently, guys. Welcome back to Immigration Talk Show, and I hope that the problem is fixed. John, welcome back. I hope the
Thank
problem is
you.
fixed.
Yeah, I hope so too.
Okay, so our viewers were waiting patiently to get an answer from you. So if you can please help V2 with an answer.
So you should receive the EAD card. Normally it's done as a combo card with the EAD and 131. So they could be waiting to adjudicate the 131 before sending out that card.
Okay, and he goes on to say that can I use I-797A for I-9, and is it advisable to switch to the CO9 EAD?
So you need the actual EAD card in order to work on it. So I would wait for that before switching over.
Okay. Um,
But
he-
I would say also, Justin Rivera in our firm, he deals with these types of issues. I deal with the litigation, but it's probably worth just giving Justin a call just to, double check and make sure you're doing everything correctly.
Yes, we have regular webinars with Justin here too. I'm sure our viewers already know him. So, guys, you can also give Justin a call. This is John's number. If you can also display Justin's number. Okay, so this is Justin's number. You can give him a call on the number 844-592-7336. Again, and you can also email them. John and Justin both will be available and they'll be able to help you with your case. You can email them on the email ID support@wasden.law, and you can also visit the website to get more info about the team, www.wasden.law. And John, V2 is back and he says, I'm on an H1B visa, married to a US citizen, and recently filed, I think, same question. Thanks a lot. Okay, I think he got his answer. Okay. Okay, so I think we should wrap it up for today because we are going to do another webinar on this where you are going to take everything and all these questions, and you're going to discuss this policy and fraud findings in detail. So guys, make sure that you are tuned in that webinar. So stay tuned with Immigration Talk Show. Follow us, subscribe to us. Yes, and John is soon going to come up with another detailed webinar on DHS's policy and fraud findings. So thank you so much, John, for being here. It was a great episode, and I hope you enjoyed it too.
Thank you. It was a great time.
Thank you so much. And to our lovely viewers, thank you so much for all your questions. We, like I said, I'm continuously repeating, so I would like to repeat it one more time that we are again going to come up with another webinar on the same topic. It is going to be a detailed one, so make sure that you are, in sync with all the details and with each and every information regarding that webinar. We are going to post all the details and all the time, the date, and the day of the webinar very soon in all our platforms. So make sure that you follow us, subscribe to us. And okay, so Rag is again already excited and says, can't wait for the next with John and Rajni. Thank you so much, Rag, for your comment. And yes, I am hoping to see you all very soon. But for now, I'll have to take your leave. And thank you so much for being here. It was lovely chatting with all of you and taking your questions. But for now, I'll have to take your leave and seeing you. I hope to see you all very soon. Bye. Take care and keep on watching Immigration Talk Show.
Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam. And today we are here with another very exciting and very informative topic that is lined up just for you. But before that, also, friends, make sure that you like, share, and subscribe to Immigration Talk Show. We are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. So do follow us on these many platforms. And before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. So, use of information is at your own risk. So, all right, friends, once again, welcome back everyone to Immigration Talk Show. I'm your host, Sam. And it's a big day. It's 7th March, the first day to apply for H1B fiscal year 2026. So I guess some of our viewers are quite concerned, anxious, or maybe excited. I don't know. But after the session, I'm sure you guys will definitely feel confident because in this webinar, we are going to understand what are the key changes and enforcement measures for H1B 2026. So, I think without any further ado, let me welcome our today's very honorable guest, none other than Attorney Uma Mantrawadi, a leading immigration attorney and an expert in US immigration policies. So, thank you so much, Uma, for being here. It's so good to have you again.
Thank you, Sam. It's a pleasure to come back.
Absolutely.
One more interesting topic of discussion.
Right. A lot. In fact, we already have lots of questions from our viewers. So I think everyone is eagerly waiting for that. And friends, the best thing is it's not only the session you can attend, but also directly you can be in touch with our today's attorney. And the contact details are on the screen. You can call Uma on the given number, that is 713-787-5297, with the email ID is uma@mantralaw.com, and you can also visit her website, that is www.mantralaw.com. So, all right, friends, thank you so much. And also make sure to ask as many questions as possible and participate as much as possible in this webinar. And let's make this webinar a wonderful one by being more interactive and more participating. So, Uma, before diving into the question, I would like to know it from your end. Is there any update that you would like us to know about?
Sure. Under the Trump administration, as you know, Sam, it's not going to be all good news all the time. We do get news that can be alarming to our viewers, our listeners. And
Mhm.
one of the news that we just got, which is possibly going to get official maybe in a week or could be less than that, is the list of countries that are going to be on a travel ban.
Mhm.
I'm not sure if you remember during President Trump's first term, also he had a travel ban on several countries. And to list a few of the countries that he had was like Somalia,
Mhm.
Afghanistan, and we have had sources that said that Afghanistan will be again included into the list of countries for a complete travel ban. And they're also talking that possibly Pakistan would be
Mhm.
included into the ban. Now, would Pakistan be a complete ban, partial ban? We haven't gotten that information as yet. Okay. Uh, this is going to create a lot of, again, chaos for particularly people from Afghanistan. You may say why, right, Sam?
Yeah.
As you know, a lot of people we've had a session about this, the parole in place for people coming from Afghanistan, humanitarian parole. We discussed about this as well. So the people who've already applied for humanitarian parole or applied for asylum or they've worked for the US government in the past as translators or for the US Army, they've all applied either for green cards under the special immigrant visa categories. And sometimes it takes years and years before they can get it. So will this affect them? We don't know the answer yet. Could this affect the humanitarian paroles? Possibly, yes. We don't have the complete information, but it can affect those who are requesting the the humanitarian parole because if there is a complete ban on Afghanistan, so that would mean that they may not issue the humanitarian parole.
All right.
So this is not great news, but Sam, every single day as we talk, as you know, we keep getting information that is alarming under this administration. Every time there is going to be something else that is quite alarming. The
Mm-hmm.
other update that I have, actually, I have two more, if I'm permitted to talk about that. The other update is, USCIS had implemented a new 485 to begin from March 15th or something like that. I forget the date.
Mm-hmm.
But instead of bringing that, they all of a sudden, without any notice to any of us as attorneys, they took the edition back to the January edition.
All right.
So we were all filing with the new edition, and they said, no, we're not going to accept the new edition. You should file the old edition.
Mm-hmm.
But how would we know that? We've already submitted the applications to the USCIS, and now they are implementing, saying we're going to go backwards rather than going forwards. So this has also caused a lot of chaos for us attorneys, a lot of attorneys who have filed 485s. Now we are expecting those packages to come back to us because the USCIS is not going to accept, because they said they want the backdated edition rather than the new edition.
All
Uh,
right. All right. Thank you so much.
isn't this enough confusion? You
Absolutely. I
know,
think it's not only this thing, but there are so many other things as well that is creating a lot of confusion, and people are still trying to figure out what to do and how to prepare themselves. So I think, Uma, these sessions are really being very helpful for them and bringing up these information that too in just beginning of the session. I think that's really amazing. So
and
thank
the
you so
reason I
much.
bring that
Yeah.
up is because, whoever is filing a 485, whether it's a family-based, employment-based, please make sure, go to USCIS, check the edition of the form that they're asking you to file so that you don't send the wrong form and get a rejection where the package is coming back to you. And that takes 3 to 6 weeks sometimes for the package to come back. So that's the reason why people may think Ms. Oma is just alarming us with all this information. The information is also to not just to alarm, or the intent is not that, but to educate as to what is going on so that you can take the appropriate steps in correcting yourself even before you actually file it. The idea is to help people, not to alarm people. Now, the third thing is also a very alarming information, and this is actually that's happened with a few of my attorney friends. They went to court this week for their clients' final asylum hearing. They were in court, they had the asylum hearing, and the judge denied their clients' asylum applications. And of course, the judge always gives options to the people, whoever the judgment is against, that if they wish to reserve their appeal and file an appeal within 30 days. So the attorney did reserve her appeal, that she was going to file an appeal to the Board of Immigration Appeals, and
Mhm.
then her clients can file the appeal and continue to remain in the United States while their case is pending with the Board of Immigration Appeals. But what happened was, as they came out of the courtroom, the ICE officials were standing right outside the door of the court, and
Mhm.
they picked up their clients, saying that the judge gave a final order, and they haven't filed an appeal as yet, so they can pick them up and deport them. But the attorney was screaming, saying, we just got the judgment, I have to go to my office and file an appeal. I
Mhm.
can't do that right now.
Yeah.
So they said, we don't care. And since there is a final order and there is no appeal, you're in between that. So we're picking up your clients right outside the courtroom. They pick
Yeah,
them up, a family of 4, and they're in detention right now.
that's true. In fact, we also come across with these news that as soon as the court hearing is there, the ICE officials are waiting outside to just, arrest them. So it's really hard. But Uma, when did this happen? I mean, is it the
Last week,
okay? Yeah, after the obviously Trump's administration. I think
yes.
it's so
And
tough.
and when we are all told that the Trump administration is only seeking criminals who are illegal in the United States, and I had asked this attorney if her clients had any criminal background, any criminal violations, and she said no, not even a traffic ticket.
Oh, is it? That's
They
so
don't have
strange.
anything. It's just you had an asylum that was denied, you didn't file an appeal,
Mm-hmm.
so we are picking them up, and they're illegal.
So
But
Uma,
they
the
were not
one.
given an opportunity to file an asylum appeal.
So do they having
And
that judicial warrant with them, as you said that they should have
there's
that?
they don't have to because there's an order by the judge, right? The judge said, I'm denying your asylum.
Okay,
So there's no question of warrant. And this is a public place.
all right.
So this is not your house.
Mm-hmm.
If they're coming to your house, I said, ask them for a warrant. But this is a public place. Anybody can come into a courtroom, right?
Oh.
And the judge just issued the decision.
Mm-hmm.
So there is a final order which is correct.
Yeah.
In normal circumstances, this won't happen because the attorneys reserved her right to appeal. So they get 30 days to file an appeal.
But they
But
didn't
if
get.
they don't file an appeal, yes, that is the final order.
Yeah.
But if they decide to file an appeal, you've got to give them the 30 days and then you can pick them up. But they didn't give them that opportunity, saying, we don't care. And I think that's clearly a violation of due process.
All right.
It's very disheartening the way the system is being abused, I would say.
Okay, that's a big statement because most of
Yes,
the places we are listening that this time the administration is trying to make the system fairer and smoother and clearer. But I think that's okay because you're an immigration attorney and you know
I mean,
exactly.
it's my opinion. That's about it. I'm not saying I'm right or I'm not saying I'm wrong.
Mhm.
It's for people to judge. But I feel once an attorney has reserved the right to appeal, then you have to give them the chance to appeal.
Yeah.
Now, if the attorney doesn't file an appeal, that becomes definitely a final order of deportation. And then ICE has every right to pick them up. No doubt about it.
Mhm.
Even let's say an H1 is denied. I'm just talking, H1
Mhm.
is filed, H1 is denied. When they deny the H1, also they are sending a letter in the decision saying, you cannot appeal this, but you can file a motion to reopen within 30 days. So if an employer decides to file a motion to reopen, they have that right. But before they can file a motion to reopen, if you come and say, well, your H1 is denied, so you need to be deported, then that's wrong. In one, you're saying you have a right to file a motion. But if you don't allow the person to file a motion, that's a violation of due process, in my opinion.
All right.
Okay. These were
Okay.
just the updates. I wanted to just bring it up.
Absolutely. I think these were
Thank you.
much needed updates, Uma. So thank you so much to you, for bringing these very important information. And I think now let's get back to our today's topic. What's
Absolutely. Sorry, I took you on this path, but let's get back.
No, absolutely. That's completely okay. Okay, so I think Uma, let's begin our this session with a very important topic. That what are the main changes in the H1B registration process for fiscal year 2026 as compared to the previous years?
Luckily, not a whole lot. The electronic registration is similar to what we had in 2024. Um, of course, I always tell people to make sure you don't file duplicates. Um, and the system already checks for duplicates. So make sure you comply with that rule because a lot of people were affected with the duplicates, as we talked about it a few weeks ago, Sam, about duplicate filings, how it affects
Yeah.
the beneficiaries, the employees. So that is something I will reiterate, and I'm sure the administration is going to come down strong on that enforcement, that they're not going to allow any kind of duplicate filings. They don't want anybody to get the undue advantage
Mhm.
of the duplicate filing. That is one, definitely, we are going to see more stricter enforcement. There was already enforcement, but I think it's going to be much stricter. Maybe they're going to put you under a microscope and check it out. Now, we have been hearing, but we don't know this for a fact,
Yeah.
that there is a possibility that if the USCIS feels that some employer is filing duplicates, they can even ban them for the future.
Oh.
Okay, this is what we are hearing. We
Mhm.
don't have concrete information that there is some discussion to this, but I don't have any concrete memo or a letter from the USCIS stating that. But I think the discussion is there.
Right.
We may hear it in the next couple of weeks. Okay. Number two, they have increased the fee from $10 to $215. This is also one way to discourage people, filing duplicates or just indiscriminately filing 100 H1s or 200 H1s, because it's only $10. So, a lot of people may think, hey, what the heck, I'll file 50 or 100 of them and, it's only $10.
Mhm.
So I think the idea of increasing the fee is to deter people from filing, because you're filing 50 times 215.
Yeah.
That's quite a bit.
So, do you think, Uma, that in this fiscal year 2026 there may be less application due to this increase in fee?
Due to increase in fees, also due to the fear factor of the enforcement that's going to come with the H1B, which we're going to talk about in the next few minutes.
Mm-hmm.
Uh, I'm hearing a lot of employers, because I work with a lot of IT companies, and I do a monthly presentation to IT Serve, which is one of the organizations that has a lot of IT companies.
Mm-hmm.
The discussions that I hear when I go to these meetings is that they don't want to get into where there's RFEs, site visits, NOIDs.
Yeah.
I think employers are getting a little frustrated with this and don't want to deal with it. So they're like, you know what, we may not file as many. If we filed 100 last year, maybe we'll do 20
Yeah.
this year. So the number is coming down also because of the thought
Mm-hmm.
process. Plus, as I said, possibly $215 is a big chunk of money
Right.
for small employers. May not be a big one for big
Mhm.
employers, but for small
And I think, yeah,
startups,
absolutely. I was about to ask for startups and smaller companies. I think they will face more problem, isn't it? Because
yes,
they won't be having that
yes,
much funding, to give that much money, so
correct,
it will be difficult for them. Okay.
correct. Not just the funding, they may not want to invest with that if they feel they don't have a project on hand immediately. because the enforcement part comes, and if they don't have a project, they are investing in this
Mm-hmm.
candidate who they don't know whether they'll have a project
Yeah,
or no project. So that is also a deterrent for a lot of employers who are thinking twice.
that's right.
And secondly, as you know, there's been a lot of layoffs in the federal
Mm-hmm.
government, whether it's the veterans or now the Department of
Yeah,
Education, many others, IRS, Social Security, Health and Human Services. A lot of people have been
yeah.
laid off. So they're all looking for jobs.
Okay.
So that would also be a discouragement,
Mm-hmm.
because if the local Americans are going to apply for these jobs, they may not uh, have the need possibly for uh, to bring a alien from a foreign country.
Right.
So all the factors, are playing together.
Absolutely. So, Uma, as you are saying that there will be little discouragement and we may see less applications also in this year. So, can we expect that if there will be less filing, then the lottery system, lottery, because obviously we have so many people in lottery system. So, there are more chances for the people, those who are getting selected, maybe 10 or 20 or less number, but they at least they have the positive chances, Can we think like that? Because there will be less application, so less competition.
Oh,
Yeah.
yes, definitely. Like I think 2023, they had almost like a little over 500,000 applications. And I think last year was like 400,000
Mhm.
something. So I don't think we're going to meet those numbers. Definitely not. As I said, a lot of IT companies are thinking twice, and they want to outsource their jobs to other countries where they can find the labor that is cheaper than what they would be paying to an H1B
Mhm.
employee in the US. So there is that buzz going around, and most people are thinking in those terms. So you'll definitely see less number of applicants filing for the registration.
All right. Okay. Also, Uma, you mentioned about the beneficiary centric process. So we would also like to know what does this mean?
Basically, it's all focused on the beneficiary. That's why they are now specifically saying we need a copy of the passport of the beneficiary, give us the passport number, date of birth, So when they pick it, earlier they used to do lotteries more employer centric. Now it is all beneficiary centric. So they pick based on the beneficiary, not on based on the employer.
All right. So is it going to benefit the system or is it going to degrade the system? What do you think about it?
Not really. Last year, it was, nothing alarmingly that
Mm-hmm.
changed for us as
Yeah.
attorneys.
Okay.
But definitely, people are going to see lower
Yeah.
numbers in the filings, in the registrations. You know, like today, we were talking to some employers who were to do the registration, and they're like, it's okay, we are taking it easy.
Mm-hmm.
Whereas last year, the day it started, people were like, we don't want to wait even an hour. So the thought process has changed.
A lot, I think. All right. So, Uma, my question to you is next that how does the beneficiary centric process reduce the risk of fraud in the H1B selection? Because now the government is saying that they are introducing this thing, so it will reduce the fraud. So, what do you think it's going to
This
do or
was
not? Yeah.
the beneficiary centric was already there even last
Mm-hmm.
year. The idea is that they don't want duplicate filings. So they can detect the duplicate filing, because once you put the name and date of birth of this beneficiary, it pulls up how many applications have been filed.
Okay.
It very clearly indicates, how many applications have been filed, who filed it, whether they are duplicates. So when it was an employer centric, there's no way you would know.
Okay.
So this helps eliminating the fraud.
So it will eliminate the fraud and make the system at least a fairer one, right?
Correct. But even last year, we've had employers, I don't know how they went through, because as I told you, when you're registering, it
Mm-hmm.
gives you we've checked for duplicates, this is not a duplicate. It gives you the
Yeah.
answer. But how did the employers go past that and were able to file duplicates? I don't have an answer for that. Still, people did file, and the employee came to us because they got a notice of intent to revoke
Oh.
because of the duplicate filing.
Mhm.
Now, how did they surpass that? I don't have an answer.
Okay.
I guess, people want to commit fraud, they'll find ways and means. Maybe I don't know how to do it. Maybe I'm dumb on that.
I think that's so right, because where there is a will, there is a way. I think that's what people think. And if, after putting up a lots of restriction, and then also they are trying to get involved in these fraud activities, then I think nothing is stopping them. But I think, let's see, with these changes and with these enforcement measures, maybe we can see changes and a betterment to the system. And also, Uma, I would like to
Correct.
know what challenges might companies face with the beneficiary centric selection process as compared to the previous registration system.
As I mentioned, and we just spoke about it a moment ago, Sam, the basic idea is if it is a beneficiary centric, as I said, they can pull up the number of applications that were filed. If, for example, somebody is filing with AT&T and they have a second application
Mm-hmm.
with IBM, that's not a duplicate because they're two different entities
Okay.
altogether.
Mm-hmm.
You know, that is fine. They can file it, but they don't want the same employer if they have 10 companies, 10 different companies, and he's putting in 1, 2, 3, 4, or 1 to 5 and 10, you know, then that is duplicate filing.
Mm-hmm.
So they will be able to detect if there is duplicate filing.
If I could ask you, how can they detect, then can you please let us know about it?
By the name and date of birth, because
Okay.
it's beneficiary centric. They're pulling up the beneficiary's name and number. I mean, name and date of birth.
Date of birth. All right. So
Correct.
earlier, I think they were using this thing to get selection easily, right? But now it's being restricted, and now it's becoming more tough for them.
Correct. Correct.
All right. All right. Okay.
This is to discourage the beneficiaries also, because the beneficiaries do this too.
Mhm.
They want their chances to increase. So they tell them, you've got 10 companies, put my name in 3 companies
Yeah.
so that my chances are higher to get picked. And like I
Right.
said, somehow they fall through the cracks and they do get picked. I don't know the answer how.
Mm-hmm.
I've seen the notice of revocation
Yeah.
because USCI has pulled it up saying, we see that you file duplicates. And it's going to affect the beneficiary because if they're on a OPT and their OPT is already, you know, lapsed,
Mm-hmm.
and but under the new rules, the gap is extended till next year, luckily. But last year that was not the case.
Yeah.
I've even had people who had an H1B that was approved, and I've had my own clients. The
Okay.
H1B was approved.
Mm-hmm.
After it was approved, they found it was a duplicate. So they sent a notice of revocation.
Oh
And
God.
this guy had to go from an H1 back to F1.
Mm,
And it was troublesome.
a lot. I think it was really heartbreaking after knowing that he got selected for H1B visa and then again this come up.
And it got approved.
Yeah, that's
And
what.
he was on the payroll of the employer. Subsequently, after 3 months, they found out, then they sent a notice of revocation. So it
Yeah.
affects the employee.
Hmm.
So I would encourage employees also, don't go for this multiple duplicate filing. You know,
Absolutely. It's unfair also, and it's so sad because, maybe once or twice somebody has seen someone that they got approval and they are living in US. Maybe that can happen.
that's
But
what I
this
said.
time,
Somebody falls through the cracks.
yeah, that's right.
Not everybody is going to fall through the cracks.
And everybody thinks that if they have done, then why not me? But no, that's not
Exactly.
going to happen.
You're absolutely right. This question comes up all the time. Ma'am, my friend got approved. Why can't I get it approved?
Yeah, that's right. Okay, all right. So I think Uma, I'm loving the conversation, and that too, you have been being so vocal about your cases and your case studies as well. So I think that's adding up to our conversation more. And friends, I can see comments here also. Imran is here, Siddharth, Subhash. Baldeep is also here. So thank you so much, friends, for putting up these questions. So please feel free to ask more questions. And right now, it's time to have a short break. So don't go anywhere. We will have a water, and Uma can also relax a bit. So because she's speaking a lot, so I think Uma, let's take a short break, and after a quick
Sure.
break, we'll be right here. So friends, don't go anywhere. Keep watching Immigration Talk Show. It's me, Sam. With very insightful attorney Uma Mantravadi, had a great discussion on key changes and enforcement measures for H1B fiscal year 2026. So don't go anywhere, we'll be right back. Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam, and today we are having a great discussion with none other than Attorney Uma Mantrawadi on the topic that is very important and very timely as well. That is, what are the key changes and enforcement measures for H1B fiscal year 2026? So till now, we understood a lots of things, not only about today's topic, but we also got to know a different information and different updates as well. I'm sure that you guys are making notes for that and keeping questions also in your mind. And I can see also comments are here. That is, Imran is here, Siddharth is here, Subhash is here. So I think let's take up these comments. But before that, I would also like to say hi to Uma back. So hi Uma, I hope you are here. Uma, can you hear us? I think, friends, we are having right now some technical glitch. Maybe Uma system is not working that well. But don't worry. I think let's take a break for some more time. And after that, surely we'll get solved with this issue. So don't go anywhere and keep watching Immigration Talk Show. All right, friends, welcome back, everyone, and welcome back to Uma also. Uma, I hope you're here now. We just got disconnected somehow, but I think you're here. So thank you, Uma, for being here again, and I hope everything is sorted now.
Yes.
All right. Okay, so I think our viewers are waiting eagerly for your advice. So let's take up Imran's comment. He's asking, I have a master's degree from a US university and was relying on the advanced degree cap to improve my lottery odds. With Trump's policies prioritizing wages over degrees, will master's graduates now have a lower chance of selection?
The selection is not going to be based on wages, the wages part will come later. But the selection is clearly do you qualify for a master's or not? And the master's people always get a double dip because if they're not picked in the master's, they get, you know, put into this 65,000 quota. So they get a double dip.
Mm-hmm. Okay. And let's take
The
Siddhartha's.
registration or the lottery selection is not based on wages. I don't know where they're getting this information.
Okay. Let's move ahead with the next viewer. Siddhartha is here. And he's asking, the H1B wage level requirements have been a hot topic. If my employer is offering an LCA with a level 1 wage, is that still acceptable under the new fiscal year 2026 rules? Or is USCIS looking for higher wage levels now?
It all depends on your position, what it is. There's no such blanket thing that you cannot have a level one wage. This wage war was there even during 2016 to 2020. This happened. This was discussed in the past too, that you cannot have an H1B on level one wage. But it all depends on the job. If the job requires more supervision, then you can have a level one. But if the job is more independent, where the person makes their own decisions, then it cannot be a level one. It would be a level two or a so it all depends on the position. There's no blanket way that I can say everyone has to be on a level two or a level three. But if the position and the job description is stating that this individual is going to do these tasks, and the tasks are going to be very independent oriented, and you're picking a level 1,
Yeah,
which is not independent oriented, it's not going to match.
absolutely. All right. Thank you so much, Uma, for making us this understandable about the topic. And thank you, Siddhartha, also. And in case if you have any follow-up question or would like to know more, then please go ahead and put up your question. Subhash is here, and Subhash has a very lengthy comment. Okay, let me read it out. So Subhash is saying that attestation requirement registrants must attest under penalty of perjury that the information provided is complete, true, and correct. Duplicate registration detection is USCIS has implemented measures to detect and prevent duplicate registrations. Investigations and penalties about that USCIS may investigate and penalize individuals or entities that submit false attestation or engage in other fraudulent activities. Is this something new? Early were the rules similar to them were not existing. Are they going to follow them strictly this time?
This is not new. This was there last year. So they were strictly enforcing it even last year, where they were not allowing duplicates. As we just talked about it, that we've seen a lot of revocations, denials. So I think the enforcement on the duplicate filings is going to be much stricter. And as I mentioned, there is some buzz around that we don't know for a fact, but there is something that they are discussing, that not just a civil penalty to an employer who files duplicates, but they want to see if they can ban them for a period of time from filing H1s.
All right. Okay, so thank you, Baldeep, for putting up this comment. And I think let's take Sanjay's comment. Sanjay is here asking, I'm an H1B cap exempt candidate working for a non-profit hospital, but I also do some contract work for private companies. So if I apply for concurrent H1Bs, could USCIS issue RFEs questioning my eligibility? What should I be careful about?
You cannot do a cap and a non-cap as a concurrent. You've got to have them both. Either both have to be non-cap or both have to be cap. You can't have one from a non-cap, one into a cap. So that's going to be a problem. And I don't know how you're working for a private entity at the moment if you have an H1B that's with a non-cap. So I wouldn't want to discuss this in detail. What was the name of the person? I'm sorry.
Sanjay. Sanjay.
Sanjay. I wouldn't want to discuss this, Sanjay, uh, right now on a live stream. I would advise you to reach out to me and I will talk to you one on one, because I just don't know how you're doing this.
All
So
right.
will it be problematic? I see the problem already, but I wouldn't want to discuss this. So I would be careful. Please reach out to me or reach out to your attorney, whichever you need to do. You need to be careful about this.
Absolutely. I think, Sanjay, it would be better if you could directly ask Uma about your query or what problem you're having right now. And she will personally guide you, and I'm sure you will definitely get the expert advice. So I think with that, let me take up. Okay, we have taken our viewers' comments, and Uma, we do have Facebook questions as well. So, with your
Sure.
permission, I would like to go with that as well. Okay. So Navya is here, and Navya is asking that, hi, I have a question that is related to document for Dropbox for H1B stamping. I'm working with consulting company. Can anyone please tell me if I should take EVL, that is employment verification letter, from the consulting company with whom my H1B is filed, or the client that I'm working with?
I would take employment verification letter, no matter whether you're doing Dropbox, you're doing an interview, it doesn't matter. Not just the employment verification letter, but if you have a third party project that you're going to be working on, if that is the case, you also need documentation to prove that you're working for a third party. It could be a vendor agreement, a master service agreement, or a statement of work, whatever you need to carry, I would give all the documents.
Okay, all right. Let's move ahead with the next comment. And this is please advise me on the situation. So I entered USA on new H1B, and my employer didn't run payroll for nearly 3 months since I didn't had any job from the client side. Then when I got job from the fourth month onwards, my payroll started running. Will I have any problem because of this during my H1B renewal or stamping?
Absolutely. Your payroll has nothing to do whether you have a project or you don't have a project. Your employer has signed a labor condition application stating that, they would pay you the salary no matter what. Even
Mm-hmm.
if you had a project, didn't have a project, you don't have anything to do, you're just sitting in the office and doing nothing, that's
Yeah.
fine. They
Oh,
still have to pay you.
that's right.
If they don't pay you, then you are in trouble. Because the next time around, if you file a change of employer, an extension of your H1, they're going to ask you for pay stubs. They're going to ask you for W-2s. And
Mm-hmm.
if that doesn't match up to the
Yeah.
salary stated in the LCA, you're going to have problems.
So, what advice would you like to give Oma? What he can do to get the payment?
I don't know what they can do because they've not run the payroll. It is a problem.
Absolutely, that's a
Again,
big.
I would advise him to reach out to me. Again, I don't want to discuss this on live here. He's more than welcome to, he, she, I don't know who it is, reach out to me and I'll be glad to talk to you.
All right, definitely. We are going to share the contact details of Yoma. So I'm sure he or she will definitely get in touch with you. All right, let's move ahead with our next viewer. And the question is that for those on H1B who have purchased a home and car and are planned a vacation to India, given the current situation, how are you preparing for potential challenges if, God forbid, anything unexpected happens?
I have no idea what anything unexpected you're talking about. If you're talking if they will cancel your H1B, I don't know if they'll do that, but if you lose your job, yes, you're having problems. If you get laid off while you're gone on a vacation, that
Mhm.
could be a problem for you to come back. We are not advising people to travel at the moment. We
Okay.
talked about this last week as well, Sam.
Yeah.
My opinion, if you can avoid traveling, avoid. If there's no reason for you to go, please don't go. Stay put. Let's wait for all this storm to clear up, for all the dust to settle, and hopefully things will settle. I'm hopeful. I don't know for a fact. But about getting laid off, even you won't know that. Let's just say because of cost cutting, a lot of employers are laying off people.
Yeah.
So if that happens, sorry, and you lose your job,
Hmm.
then you're going to have a problem coming back into the country.
Absolutely. All right. So I think let's move ahead with the next comment that we got on Facebook.
Hmm.
Anand is here, and Anand is asking that my visa stamped for company A till to 2028, but I left company and went back India. In India, company B filed my H1B in the year 2026, while me being in India. Then do I need to go for stamping for company B? I heard if our H1B processing happens while being in India, then it has to be counselor processing only for which we have to go for interview. Is this true?
First of all, I think I have confusion with the dates because he's saying India Company B filed in 2026.
Six. Yeah.
We haven't come to 26 yet, so there is a confusion about that. Now, if you're in India and they are filing for an H1, yes, it is consular processing. And I don't know if you're eligible for a drop box. If you are eligible, then you can use that, and if not, you have to go for an interview. And you could travel on the previously stamped H1B visa.
Mhm.
However, with the current administration being so stringent and the enforcement being so strict, I wouldn't take a chance with the previous stamping. I would just go for a either a Dropbox or an interview and then get your H1 to come back. The
All right.
dates are off, but maybe he meant 24 or 25. I'm not sure.
I think, Anand, it will be better if you could let us know which date you are actually trying to mention. And by understanding the exact date, I think Uma can guide you a better one. All right. So I think these were the Facebook questions, Uma, that we got for this webinar. And with that, it's almost time, but I have one more question for you. And this will be the
Uh,
last question.
no, take your time.
Okay, all right. So I think this is the question that what advice would you like to give to companies and individuals who are looking to navigate the H1B process under these new rules?
Good question. Uh, Today's topic was going to be all about talking about enforcement under the new fiscal year 2026. As you
Mhm.
know, with the rule that came out on Jan 17th, 2025, USCIS has talked about the H1B modernization rule. And with that rule, one of the factors that they presented was that there is going to be more enforcement, meaning they're going to make sure if your employee is working at a third party site, that you provide documentation. And if the employee is physically working at a third party location and you've not stated that in your LCA, that's going to be problems. So they want to make sure your LCA matches to what your third party vendor is asking you to do. If they want the employee to be working on site, then put that in the LCA. If
Yeah.
you feel that your vendor doesn't require you to be working in person, they can be working remotely, then you give the remote address or your company address. So these are things that one has to be extremely careful in putting your H1B package together. And I've seen time and time and time again, Sam, where employers just do it themselves with a legal assistant or a paralegal in their offices, and the paralegal or the legal assistant does not understand the legal implication of each of these boxes, what they're clicking, and if they don't put the right information, one, you're going to get an RFE, or two, you're going to get a notice of intent to deny, or maybe a notice of intent to revoke.
Mm-hmm.
So I would be extremely careful with that. With the current H1B modernization rule, they've also said that there will be a lot more site visits under this administration, FTNS site visits. So, what is the advice? I mean, kind of guidance I would give, I won't call it advice, is that employers maintain their I-9 files for each and every H1B, L1, TN,
Yeah.
whatever visa your employee is on. Please make sure you have a hard copy and a soft copy of the LCA, of the paychecks, of your performance evaluations, whatever you're doing, everything connected with this employee. I would maintain a complete file. And my firm is very, very up to date on how an employer should maintain their I-9 files. We give webinars on this, we do seminars on this, we guide, we help employers how to maintain their documentation in a proper way. Should there be a site visit, you're much more prepared for this rather than, worrying about it. So I would advise employers to make sure they maintain the I-9 files. And I would also advise, if you're a brand new employer coming on board, make sure you become a e-verified company. That way, the USCIS has a lot of information about you. and you would be in a position to hire OPTs, STEM OPTs, because for that you require to be an E-verified company. I would do all of this whether you hire OPTs or don't hire. This way, your information is out there, everything is clear. You know, you're being more forthcoming by doing this. So make sure you're E-verified and do not file duplicates. Um, I've
Yeah.
even had a silly situation where I've had an attorney do this, and I'm surprised, where
Oh.
instead of using a tax ID number, a federal tax ID number, they went and used a state ID number,
Oh.
and their registration, everything was denied. I don't even know how the attorney did that. Beats me.
Surprising.
It's a very basic thing that every employer has to have a federal employer identification number to file an H1, to file an LCA. So
Mhm.
you can be filing with a state employer number.
Right.
So make sure you have all these documents for your attorney, give the right documents, and you keep all of this. And also make sure that you comply with the wage requirements. That's going to be a big thing that is coming in as enforcement. This was there 2016 to 20. I was part of those wars where, we were having meetings with the immigration officials saying that, they cannot restrict an employer to hire somebody only in a level 2 or a level 3 or a level 4. Because of the job requirement is a level 1, they are going to hire a level 1.
Mm-hmm.
So one has to be very careful how you define those job responsibilities and the task. You've got to
That's
be very careful with that. So my advice, guys, don't gamble with H1s, L1s, TNs, OPTs, STEM OPTs, whatever you're doing. This is not the administration where you want to take a gamble. This administration is coming down very stringent on everything. So make sure you speak to an attorney, make sure you have all the right documents, make sure you're filing with everything so that you don't have to turn back and look whether you've done the right things or the wrong things. Because don't take a guesswork here.
yeah. It won't work this
It's
time.
not
It's
going to work. No.
all right. All right.
I,
So that.
I, I tell this to a lot of employers on a funny note, when you're filing H1s or L1s or whatever you're filing, it's not like Kaun Banega Crorepati where you have lifelines. You don't have lifelines.
It's without lifelines.
Without lifelines, you're done with all that. So your best bet is to go to an attorney, get your consultation, make sure even brand new companies, startup companies who are filing H1. I'm not discouraging y'all from filing. Please do file, but
Mhm.
please do make sure that you are in compliance with the current administration. Again, a lot of people come back and tell me, ma'am, my friend filed it in 24, he didn't have problems. My friend filed it in 22, he's a small company like me.
Yeah.
22 is different, 23 is different, 24 is different. We are under the Trump administration now with different perspective. You've
Yeah.
got to comply with this administration's requirements.
Mm-hmm.
So no comparisons to what happened last year.
That's right.
Okay.
It's
That
completely.
is, something I sincerely want to tell people.
That's right, and that's much needed. So I think thank you so much, Uma, for making us aware about these very important information, and that too giving us a great guidance at the end also. And these advice are really needed, and I think our viewers are really working on these advices that you are sharing with us. So thank you so much again for being a part of this session and bringing up so much onto the table. So we are really honored that we are able to have shows with you and loving those shows. So thank you so much again.
Thank you, Sam. Have a great weekend.
Absolutely. To you too. All right, friends. So thank you so much, everyone, for being here and participating in this session. It was really a great one, very insightful, and very grateful to have her as well. And friends, you can also contact our attorney. You can give her a call on the number that is 713-787-5297. You can also email her on the email ID that is uma@mantralaw.com, and visit our website that is www.mantralaw.com. So that's all for today's episode, friends. I hope you liked watching this webinar. And in case you have anything else in your mind that you would like us to cover in the next webinar, then please go ahead and put that in the comment section. And I'll make sure that I'll definitely take that topic in our next webinar. So thank you so much for joining us. And don't forget to like, share, and subscribe to Immigration Talk Show. I'm your host, Sam, and we'll be back again with another very exciting webinar. So make sure to press the bell icon so that you don't miss any update. Until then, goodbye, everyone. Take care and a happy weekend too. Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam, and today we are here with another very exciting webinar that is lined up just for you today. So make sure to watch this session till the end, and you can also ask questions. That is the best part of our webinars, that you can participate by asking as many questions as possible. And with that, we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. So check out us there, and also like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. And before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information shared by our experts and attorneys, including user comments and replies from users, is not a legal advice. So, use of information is at your own risk. All right, friends, after this very important disclaimer, once again, welcome back everyone to Immigration Talk Show. I'm your host, Sam. And today, the topic that we are going to talk about is another very important and very essential, especially for E2 visa applicants. And that is, what should investors know about the E2 visa changes in 2025? So, to help me in diving into this discussion and also to make this webinar a wonderful one, I have a very special guest who is joining us for the very first time in Immigration Talk Show, none other than attorney Jessica Weiss. But before inviting her to this webinar, I would also like to tell something about her, that Attorney Jessica Weiss is a nationally recognized immigration lawyer with over 2 decades of experience and remarkable list of achievements. She was honored with the prestigious Immigration Services of the Year award from the Global Chamber for her outstanding achievements and exceptional services in the field. Jessica also serves as national mentor for the American Immigration Lawyers Association, guiding fellow immigration attorneys in the areas of adjustments of status and also on E2 visas. The great thing about her that she takes the time to understand each client's case in a very unique way, and she also guides them every step on the way. And whether it's coming to the US as a tourist, moving to a green card, or one day becoming a US citizen. So I'm really thrilled and honored to have a show with her. So, Jessica, thank you so much for being here. We are really honored and we welcome you wholeheartedly to Immigration Talk Show for the very first time.
Thank you so much. That was quite an introduction. I very much appreciate that. And I can't explain it, but I love doing E2 visas. I've done them for more than 2 decades, and I really, really enjoy them because it's such a great way for people to come to this country. So I look forward to this show today with you.
Absolutely. I'm sure our viewers are really excited for this session, and that too, it's a very important topic. So I think without any further ado, I would just like to know it from you, Jessica, that what our viewers would expect from today's webinar.
So I think what they can expect is a better understanding of where are we going with E2 visas. Is it going to be the same story as the last, what I mentioned to you a little bit earlier before we started the show was 1815 is when E2 visas started. That's over 200 years of E2 treaties. And do we think in the next year with President Trump in command of this country, is it going to change drastically? So I want you to understand, what are the changes? Will there be any changes? Are we in for another several years of a great ride with E2s? And I think you'll get that from this presentation today, a much better understanding of that.
Absolutely. I think that's great. Our viewers are going to know a lot of things in today's webinar. So, Jessica, let's begin with our very first question. What should investors know about the E2 visa changes in 2025?
Okay, first thing is, I don't think there are going to be a lot of changes. I think we're in for a great ride. If you look at the last time that President Trump managed this country, we didn't have a lot of changes. In fact, we had 2 countries that were added to the list of E2 treating countries. We had Israel and New Zealand. And I think we're in for more countries may get added on, which is very exciting because there are so many countries that want to be part of this E2 treaty that we have process, and they're left out. I don't think every country like mainland China, I don't see that one happening so fast. It just depends on our relationship with a country and how much trade we have and how much we want to benefit each other's countries by allowing them to do this E2 treaty. So I think we're in for could be some more countries added. There are a few things that actually very recently something changed, that it used to be that you could have a waiver of your interview, let's say for an E2 visa, if you got it within 48 months of the last one. They just changed recently that it has to be within 12 months that you got your visa, that they will waive the next interview for an E2 visa. So a lot of people are out of luck now. So there are probably going to be way more E2 visa interviews, which also can slow the system down. So that's what's going to be, that's happening right now. That just changed. In terms of if there's going to be a larger investment, like right now, substantial investment, we'll talk about what figure is substantial investment. I would say that figure is not going to change too much because that's the beauty of the E2, that it can be a small investment, could be $100,000, $150,000. Could be less even. I've done them smaller. Could be $1 million E2. But I don't think that number is going to change so much. I do think that the Buy American, Hire American policy that Trump puts in place could affect some of the E2s. It could be that when you apply for an E2, they want to hear, tell me about all the American workers you're hiring, because we want American workers to get jobs. So the E2, if someone says, I'm going to hire a lot of foreign workers, non-immigrants, green card holders, but not a lot of American citizens, I'm keeping an eye on that to see where the Buy American, Hire American policies will go. And I also would say that scrutiny of the cases, I think there'll be plenty more scrutiny of the cases. Sometimes I'm shocked what they scrutinize over. One gentleman, we just refiled his case again. Why did they scrutinize it? They said, well, you never ran a dry cleaning business before, and you wanted a dry cleaning business to run in the United States. So I'm thinking, for an E2, you never have to have the exact experience in the business you're going to be buying, but you need to have, let's say, managerial experience or, some business background. Just depends, but it's never so precise. Exactly. This man didn't have dry cleaning experience, but I have management experience. So he refiled it because we were like, this is ridiculous. And he just got it approved today, actually. So he's really excited. So some more scrutiny could be out there, but we deal with it as it comes. If we know what the rules are, we push on the rules. We know what the regulations are for E2s. So that's some of the stuff I think coming, some more scrutiny, maybe some more E2 treaties, which could be exciting. More American workers they're going to look for in some of these companies. The visa waiver, the being exempt from the interview, that's basically taken away. It's going to be, everyone's going to be interviewed for extensions, for renewals, for brand new E2s, all that. And yeah, so those are some of the changes that I could see coming.
All right. That's great. And I love the energy that you're putting up and, beginning our
I love
session.
this stuff. I don't know why.
Absolutely. I think everyone is loving, and that too, that's so great that you have put up so many different pointers, that too in very first answer. And I'm too getting a lot of questions in my mind, but I have to be very much particular about the topic. But with that, Jessica, I have just a random question from my side that you put up about trade and tariff from President Trump's administration. So, do you think that putting up a tariff and trade, all these things, may hamper the relationship between the two countries, majorly the US and the other one? Do you think they will have a hostile relation, or whether the relationship will increase and become better?
It's a very interesting time for that question because half of my clients are Canadian, and we see what's going on in Canada. Trump is taking a very tough approach, putting more tariffs, saying, look, we don't want to give you as free a ride as we gave you before, but they're our neighbors. Mexico's our neighbor. And I still believe that we'll work this out somehow. But I do believe that it does factor in. I think because it's a treaty, an E2 treaty, the reason for it, the basis of it is because we have ongoing trade with another country. And we want to give our citizens and their citizens an opportunity to benefit, to build a business, to create jobs in the various, respective countries. So I still believe, I'm telling you, I've been doing this 27 years. It is a great way to come here. And even though there's tariffs and even though there'll be, more restrictions, I still think it's going to keep going because it benefits both countries. And it's all about, how can the U.S. get ahead? The U.S. has benefited so much by having all these E2 foreigners come here, create jobs for American, bring their capital here. That's all good stuff. For, to build an economy, that is all really good, what we want here. So I still think even with the tariffs, it's still going to be good. It's good news. I am so positive about E2s. I love them. Besides the fact I love them, I think it's just such a great way to come here. And it's not just for the investor, it's for the spouse too. It's the children. It gives everyone an opportunity to come here. So it creates a whole life for a family in this country.
Wow, that's great. All right, I'm sure E2 E2 visa applicants are really looking forward to this session, and they are going to have a lot of different information with this. So thank you so much, Jessica, for putting up those very important pointers. As we are not having much changes, so I would like to know it generally that how is it going to affect foreign investors who are seeking to establish or expand businesses in the US?
So one thing you have with foreign investors is the currency. They have to see the currency. Like I've had clients, because I deal with a lot of clients from Canada, that say to me, well, I don't want to pull all my money out right away because of the currency difference. And right now our Canadian dollar is not as good as the American dollar. So they're slowed down a little bit of like, if they're going to do it, maybe they'll wait a little bit, see what happens with the economy or whatever. But overall, I think that the changes, because there's so few changes and because they still believe that America is a land of opportunity. I know it sounds cliche, but they still believe that they will keep coming. Even some of the changes that we see, like, will there ever be a higher investment figure? They say substantial investment for an E2. They never give us what is the figure. So it's based on, they look at the whole picture. They want to see what does it cost to run this business. And years ago, I had a case of someone who invested $40,000 in an E2. It was a little one because I usually like them closer to 100, 150,000 investment. They invested 40,000. It was an administrative office. They would use their administrative office staff at different offices. They had very little overhead, and they only needed to invest $40,000 in cars and computers and advertising, attorney fees, and that was it. And it worked, and that was like all they had. So will they look at the investment number and say, well, 40,000 is so little, maybe we want it to be higher? They haven't changed that yet. It's still out there. Your investment can be little. We like it bigger because we want to show that gross sales are strong and their net income of the company is positive. So it's very hard to show that the workers are going to be paid minimum wage 35, 40 hours a week. We need 2 of them for the E2. It's hard to show that if you buy a company that's so tiny and the gross sales are so tiny. So they look at the whole picture, and they're going to look at the finances, and they maybe even scrutinize it a little bit more to see, do we want to bring this foreigner here? Are they really going to have a productive company? They also look at job creation. They look and see, so you committed to 2 full-time workers, which is required for an E2. How soon are you going to get them on board? I like the workers on board right at the beginning. Even if I get 1 full-time worker on board, within a couple months, I got the next one on board. But I really like the workers on board. And then the documentation. I mean, I had a client once, they're from Pakistan, and they had to prove every bit of where that money came from to invest in the U.S. company. Not only that all taxes were paid, but also where did it come from? So they had to show their bonuses, their paychecks. They had to go back to the very beginning, and we had to get a letter from the employer confirming exactly what they paid them. And that was pretty specific. I usually don't have to get that specific, but it's out there. I mean, we go back to the origins. We really want to know who gifted you that money. Where did the source come from? Years ago, a client said to me, I'm so happy I got money out and I put it in a bank account in Switzerland and I never had to pay taxes on it. And I said, that's ridiculous. I can't help you with an E2. You have to pay taxes on the money that you're going to use for the E2 business. So these are some of the, the little nuances that, we're going to look for, and they may look for more as these E2 cases, and they're becoming more popular because as other categories max out, like H1B, some of the H1B people say, well, I missed the lottery. Let me try to create a business. So the E2 system can get, there's still plenty of E2s available, but it definitely, I think it's going to get busier, actually.
All right. And also, I would like to know, Jessica, that how much money do investors need to invest to apply for an E2 visa? This is the most demanding questions that most of the investors ask.
Yes, it's a very good question because they don't have an answer out there. There's no specific answer. Substantial investment they look at. So you could have, like I said before, I had a business, $40,000, that's all they invested. I tell people to stay around $100,000 to $150,000. So what does that mean? Let's say you find a business that cost $80,000 to purchase. Well, that's not $100,000, $150,000, but there's so many other expenses that are involved in making that business happen. Attorney fees, travel expenses, maybe you buy a car, other fixtures, any renovations. So now we're getting it over the 100,000 mark. So the contract itself doesn't have to be exactly 100, 150,000. If you're creating a business from scratch, you're going to keep track on a spreadsheet every time you pay something, and you're going to show proof that you paid for it personally as the investor. And you're going to keep track of all that till you get to a substantial figure. But what is substantial? I would say, look, as close as you get again to 100,000. But I have clients that say, look, all I can do. One gentleman, he was creating a painting business. I have some great stories, by the way. I've been doing this a long time. But one gentleman, he was creating a painting business, and he hired 2 painters. Only needed so much money for all the painting supplies, advertising, overhead, office location, whatever. And that was it. He said, I can't get higher than 60,000. That's all I have. That's all I need to run this business. Another gentleman, he bought 2 trucks. Each truck cost over $100,000. That got him to over $200,000 as investment. He bought 2 trucks, had 2 full-time truck drivers, and he had plenty of opportunities to, use the trucks to bring products to different locations. He ran the business as an E2 investor, and that was it. So, it just depends. What does it cost to run this business? And the other thing I'll just mention is that when you're going to buy a business versus creating one from scratch, you can create what's called an E2 contingency clause, where you say to the seller that the whole entire deal is contingent upon me getting an E2 visa or a change of status by immigration in the United States. And either way, so then you're not putting all your money down. All of a sudden you're like, what? Why didn't my case work? You can, if it doesn't work, you get your money back because it was a contingency clause. The seller has to be willing to do that. And sometimes the seller wants a non-refundable deposit, a small amount, could be 5, 10,000 something, but it holds them for a few months while you're waiting for this case to get approved. And sometimes that's what the buyer needs because they're nervous. This is could be all their money that they've saved up and they're throwing it into a business and they don't even know if it's going to get approved or not. But goodness, I have a very, very good track record. I mean, I'm telling you, I do 1 E2 probably every week for the last 27 years. I'm always doing E2s. Always. And my track record is very, very good. In fact, one of my cases they use to educate their staff at the U.S. Consulate in Toronto. So that's pretty exciting. My client was like, they asked for permission to take that file and show it to the staff. I'm like, yeah, sure. Why not? So
That's lovely. That's lovely, of course. With that, Jessica, here's another very interesting question that most of our viewers are waiting for. That how do you see the future of E2 visa under the Trump administration?
I see it as great. I see it as great. I'm telling you, this is what Trump wants. He wants to bring in more capital into the country. He wants to create jobs for Americans. He wants, he wants industries to thrive. There's certain industries that are very popular with E2s, like salons are popular. I'm not saying Trump wants all the salons to thrive, but he wants certain, it definitely can build up different areas in our country. And it's a win-win. It's a win for everybody, because there are people in countries, they just can't wait to get out of there. They don't see a future for themselves. And coming here, it also doesn't take that long. And E2 can be done either E2 visa at the consulate, which takes usually a few months, the whole process, or it can be done in the United States. If you come in as a visitor and you do a change of status, then and you can expedite it. So you can get an answer very quickly in 15 calendar days. So it works. I see a great future.
All right, that's great. Most of our
Yeah.
viewers were really worried, the Trump administration, because we are going to hear a lot of executive orders nowadays. So they were really worried. But I think, as
Yeah.
per your expertise, they shouldn't be, right?
Look, they can worry if they want, but that's what our job is as immigration lawyers. We hold their hand. We try to make the most successful case we possibly can. We look at the regulations, we look at what they have, we try to make it work, and then we give them the confidence they need to go to the interview, or before we file the case, we make sure everything's there, and then that's it, we file. So we don't take cases that we think have a very difficult shot of working. I really want this to work for them, because this is everything. Sometimes this client, it's all the money they have. And we know that. We feel that. And we work with them on that. And I'm telling you, it's like immigration is a little bit like social work, because you're dealing with somebody that this is everything to them. And I literally have clients say to me, do you understand? This is all my life savings. I had one gentleman tell me, my house burned down in this location. My house burned down in that location. This is all the money in the world I have, and everything I do, nothing ever works out. And I'm like, we're going to make this work, because this is important to you. Yeah, that's how we do it.
That's lovely. I'm sure you are filled up with so much positive energy when any client comes to you. They are just quickly becoming so happy, right?
We
Just
try.
by
I'll tell them the truth too. If they show me, how we do it usually is a business broker gets involved. And a lot of times if they want to buy an existing business, and I have to see the paperwork. I have to see, what are the gross sales, the net income, the employees, are they legal? And I tell them, look, so far things look good. Let's keep going. But if I start to see red flags right at the beginning, I tell them, do you really want to commit to something that's probably not going to work? Because you don't want to be going to that interview at the consulate and asking for a favor that, like, sorry, my case isn't fit so well, but please give this to me. We want to have a solid case when we go. And then they don't have to be so worried about, what Trump going to do, whatever. But we always ask them right from the beginning, is there something in your background that prevent you from getting an E2 visa? Because they do. We have to know anything criminal, any, bunch of DUIs, we have to know. So we don't get to that point where they need a waiver at the interview. And we're like, why didn't you tell us that you smoked marijuana and were arrested for it and it's in your record? Like, we need to know these things up front.
all right. Okay,
Yeah.
that's great. And here's another question, Jessica, about the key requirements. So, what are the key requirements for obtaining an E2 visa, and how can investors ensure that they meet these criteria?
Okay, so key requirements are, number one, substantial investment. Okay, we discussed it a little bit, 150,000 roughly, can be less, can be more, but substantial investment. It could be gifted to you. It could be your parents want you to have this opportunity to come to this country and they gift you $200,000, but it has to be a gift. It cannot be a loan. So substantial investment, you want to make sure you hit that around that range. You have to play an active role. So if years ago a gentleman said to me, I bought a gym, it's a 24-hour gym, everyone just goes in with their key and I don't have to do anything. I said, that is not an E2. You have to be there to run it on a regular basis. You don't have to be there 9 to 5, but you have to be there regularly and know what's going on with your business. Also, you want to buy something that you're not hiring your whole family. So I have clients to say, if I'm going to invest in an E2, I'm going to bring over my sister, my aunt, and everybody. I'm like, that's not going to work for an E2. You have to create jobs for people other than your family. So there's something out there called marginality. And if they deny your case because of marginality, it's because they feel that you do not make enough gross sales to cover the expenses to run the business properly, and they call it marginality, and you don't want that. You also have to have intent to depart. So I had a client once went to an interview and said, yeah, I sold everything off, my house, my business, and everything, and I'm just waiting for my E2 to get approved. And I told him, you don't do that. You have to always show in the interview at the consulate that you have intent to return to your own country, that you have something to come back to. So it's important that you have that too. So these, and also that all taxes are paid and the money was received legally. That's another thing. I usually don't have this issue, but if you got it through drug sale or something, terrorism or something crazy, like, it's going to be a problem. We have to know really the legit source of that money. And then a strong business plan is key to these cases. They want to see over a period of time, over 6 months, 1, 3, and 5 years. They want to see, how are you going to build this business up? Who are you going to hire? What are your gross sales going to be? And we do strong comparative market analysis in the business plan to show similar businesses and how yours is going to thrive like theirs. And we put all that together, and usually it's several hundred pages, and then we have to shrink it. If you file with the consulate, you have to shrink it to the amount of pages they require. And for example, Canada is 50 pages. So my clients are going to be like 200 pages, and I have to spend time just shrinking the case to like 50 critical pages. And then the rest they bring with them to the interview. So those are the keys. And when you hit them, that's it. You hit these requirements, you can have a great case. I also want to share, though, sometimes you see a case and it has potential to be a great case, but it's not a great case, meaning like the numbers aren't so great, but you're going to build it up. So immigration says, show us in a strong business plan. We want to see how you're going to build it up. So if your gross sales are good, but you have a negative net income, even if it's 10,000, 100,000 gets harder to justify. But let's say there's a lot of deductions on the tax returns or whatever. If we can explain what happened, what went wrong, and this is how you're going to turn it around, sometimes those cases can work nicely too. So I wouldn't say every case has to be really strong net income, really amazing gross sales. We look at each and see, can we turn this into an E2?
All right, that's great. Also, here another question, Jessica, that have there been modification to the minimum investment amounts or the types of investments considered eligible for the E2 visa?
So there hasn't been changes to the minimum investment amount, but the types of investments considered eligible for an E2, I would say now with a lot of remote work taking place, they've opened up themselves a little bit more E2s to some more remote, like remote offices, but you still have to justify, why do you need to come to this country? So if you have a business that all runs remote, like it's a sales business, you sell a product online, maybe you have a factory in the US, and maybe we could show how you have to check on it regularly or something like that. But when they come to me and they say everything's remote and I just need, workers in this state and another one in that state, and I'm like, it doesn't work so well. Like I had a woman years ago that she had a facility in California that made facial products and for skin and stuff, but her headquarters were in New York. But I explained that she has to go back and forth. And she really lived in New York, but most of the activity of her business was California. But we explained she had to go back and forth regularly, so she needed to be in the United States. But with so much remote work, people try to say, well, it's just all remote. And I'm like, you got to create a little bit that's not remote to work for an E2. But other than that, the types of investments, well, the thing is, people always call me up and say, I bought a house and I want to flip it. And I'm like, E2s, you flipping houses does not work for E2s, but let's get creative. There are ways to do things with the house, a house business. For example, you could have joint like apartment complexes, several of them, and say, look, I need to hire a manager, renovation person, et cetera, and turn it into an active business. When you buy one house and you flip it, it's not active. They don't like that. But there are a lot of ways to. I had one lady who she would buy the houses, she would create financial mechanisms for people to live in the houses, and then eventually they would buy the houses from her. So her business was the financial part of it. And that was the active part, even though she owned all the houses. But you can't just, one guy's like, I'll buy a house, that's my business. I'm taking care of the house. I'm like, no, that does not work for any two. It still doesn't work for any two. So.
All right. Okay, that's really interesting. Also, Jessica, why is the E2 visa country specific? We know it's obviously a country specific, so we want to know the reason. And why is it available to citizens all countries like other visa types?
So the beauty of the E2 is we say to another country, you have so much trade and interaction with us at a business level, we want to continue that. And this is another way of continuing that by having E2 treaty that we have, and they have something similar in their country. For example, the country of Israel, we didn't have it for so long, and now we have it because there's a mutual agreement that they have an equivalent, that if our American citizens want to go there and build businesses and hire workers, whatever, they have something equivalent to our E2. So that is why, because we have these ongoing relationships, and this just continues that relationship. But there are certain countries we don't have relationships with, like Iran. We have no relationship, no E2 with Iran, but there are other countries that who knows what'll happen maybe that will get it. I mean, New Zealand just came on board a few years ago, and there's a lot of talk about Greenland. We don't know what's going to happen with that. There are countries out there that are very interested in this relationship. So, but it's not with every country. That is true. And as I mentioned a little bit earlier, that it's very interesting, the date that the treaty started can be 1850s, can be early 1900s. These relationships have gone on for a long, long time. So that's another reason why I don't think they're just going to go like that. There are changes that have come between the agreements that we have with countries, like France originally had an E2 visa, it was a 5-year one. Then they took it away and made it a 2-year visa they issue. Now we're back to 4 years. So sometimes the agreements that we have for the E2, there are adjustments that come about, but they give a lot of notice if it's going to happen usually.
All right. But Jessica, talking about the country's relationship, if we specifically talk about India, then India doesn't count in the E2 visa, right? But
Right.
similarly, we have seen President Trump and Prime Minister Modi, they are having a very good relation. And not too in the second term, but also during the first term also. So, is there any chance that India can also count under the list of E2 visa, maybe after having good relations? Or what's your call?
Right. This is a good point that you make. The issue also becomes there are certain countries that the population is huge, like mainland China, India. If you look at the visa bulletin, where they're seeing, the certain amount that we issue of green cards to certain countries like Vietnam, India, Mexico, there are so many people wanting to come here. But I think there are a lot of factors that play into which countries we have the E2 treaty with. And I think India would be flooded with candidates if E2 visa came about. This is just my own personal thinking of this. Or mainland China, we would be flooded with them. So part of it is the ongoing relationship we have. And part of it is we have to look at the numbers. What would this do to our country if we open the doors to certain very large countries? Look, we do have it with Mexico. Right? We have an E2 treaty with Mexico. That was a long time ago it was established. Our relations are tenuous right now with the border and all the issues there, but it hasn't really been talked about that we would get rid of it. So there's probably a lot of factors that go into why do we have an E2 treaty. I'm only mentioning a few, but there could be behind the scenes things like, for example, with Israel, there was a lot of visa waiver overstays. So that was delaying it. They were like, Israelis need to stop overstaying on their visas. They respect our laws. And then, they were working out all the little details. So I don't know what ones are on the burner, so to speak, right now, but I'm hopeful that there will be more countries that we do have it with.
Absolutely, because nowadays we are seeing that we don't know whether the relationship are being very friendly or not with USA, but at least with India, we
Mhm.
have been seeing a better relation, and as compared to Mexico, Canada, the other countries who have the E2 treaty. So I think let's hope, and if you are saying, then I'm sure our viewers would be hopeful, and they should also be positive about it because most of our viewers are really looking forward to the E2 visa. So
I hear you. And I love the E2 visa. I don't care what country it's from. I'm happy to help any country. I've done some very interesting countries, E2s, and all the requirements are very similar, usually all the countries except for the UK. UK requires that you have physically lived in that country for 1 year before you file for your E2. Yep. And now it looks like Grenada and Portugal. These two countries, there's a way to become a citizen, and then you have to wait a certain amount. If you got it through a financial investment and you became a citizen, you have to wait a certain amount of time before you can apply for the E2. It's sometimes a 2-year waiting period or a 3-year waiting period, but that's another path in. If certain countries do not have E2 visa and you become a citizen of these countries, within a matter of a few years, you can apply for the E2. That's what some people do if they don't have a country that has E2 treaty. It's an unusual way to do it. You want to be a citizen of those countries, then go for it.
all right, that's great, and I'm loving that. But Jessica, I really don't want to take a break, but I think it's almost 30 minutes, and we didn't
Oh,
even realize that. So, friends, we are just taking a short break. That will be 2 to 3 minutes break, not more than that. So don't worry, we are not going to keep you wait for long. But till then, you keep on posting questions, keep on commenting, and ask as many questions as possible. And we are here definitely, and we will try our best to ask and as I mean to answer all the questions as possible. Till then, you can also look for the contact detail of our today's attorney, Attorney Jessica Ways. The contact number is 888 and the email ID is jessicaw@waysIPlaw.com, and the website is www.attorneyjessicaways.com. So please go ahead, and you can also contact her, and you can let her know about your immigration journey, about your concern, what process you are going through, or what complexities you have. And I'm sure she is going to give you the best advice. So, with that, friends, don't go anywhere. We'll be right back. So, keep watching Immigration Talk Show. Hello, everyone, and welcome back once again to Immigration Talk Show. And now we are going to have a second segment of this episode. Till now, we have been going through a great discussion with none other than, I would say, wonderful and great attorney Jessica Ways. And today, the topic that we are discussing is very important. What should investors know about the E2 visa changes in 2025? So till now, we have gone through a lots of information. What will be the future under Trump's administration? Then, what are the key requirements? How the investor should invest? What are the key pointers? And also about minimum money. So till now, we have gone through a lots of information, and now I think let's pick up our viewers' question. But with that, Jessica, before diving into our comments, I would just like to ask one more question because I think that is very important to answer. And that is, what are some common problems that investors face when they apply for the E2 visa?
Okay, so some of the common problems I would say is that the investment amount is too small. You have to watch that. that they don't have the hired workers properly. So meaning like if they have one full-time worker, they don't have any plans to hire another worker. That's a problem. That there needs to be a role for them and need to clearly have a role, and it cannot be hands-on. So if you own an ice cream shop and you say, I'm going to be scooping the ice cream at the interview, that's a problem. They have to understand they are CEO, they're overseeing the operations, and they have to make that clear. In terms of, I would say during due diligence, the whole due diligence process while they're buying an existing business, a lot of them don't have the financial background. So they rely on a business lawyer to help them understand, but they have to make sure it's a legit company they're buying. On paper, everything can look legit. Some of my clients literally like park their car outside the business and see what the foot traffic is like and stuff. Because this is something I always tell them, buy a business you like and buy a business that you think is going to last. Because we need this to last. Because as long as you're here in your E2, you've got to keep your business going. And they joke around, people say that E2 is like the retirement visa, because you could buy it, you could be 70, 80 years old, and you could buy an E2 business, but you know what? You still have to take care of it. But a 70-year-old can check on their business on a regular basis, and they do. And so it is like the retirement kind of E2 business, because snowbirds want to come here and eventually they love it here. And so I'm in Florida, so snowbirds. So eventually they love it here and they're like, how can we stay here longer? So that's my business, and they run it, for the rest of their lives, or they turn it into, they find it somehow switching into a green card. And I know we didn't talk about that really too much, but there are ways to go from E2 to green card and not just EB5. I do that. A lot of my clients, we go other ways to come here. It is possible. And I get that question a lot. Like, okay, now I'm here on an E2. How do I stay here long term? And I tell them, as soon as you get in here, let's talk, because let's set it up the right way so you can have, a long, long time in this country. So.
All right. Okay. So I think we have come across with lots of questions. And
Great.
I can see, Jessica, we got really a great amount of engagement here. Vihan, Trizer, then Arpita, Vihan. I'm really confused whom to take first, but let's take up Vihan's question. Vihan is here asking, looking ahead to 2025, which industries or business sectors do you believe will be the most attractive for E2 visa investors, considering the potential changes? Yeah.
Restaurants are coming back. During COVID, it was very difficult. E2 companies really suffered, but they're back. Restaurants are back, salons are back. A lot of the services that people need to go into to get those services, they're all coming back. I find even a simple coffee shop does very well for an E2. You have 2 workers, a certain amount of income coming in. So that whole industry, restaurants, I think very nice for an E2, and can slide you sometimes very nicely into an EB5 too, a green card. I would say other areas, I think real estate will come back, not flipping houses, but could be all sorts of things related to real estate. It could be property management companies. It could be any kind of renovation business, like window wiping business. All those areas that are related to real estate can come back too nicely. And it could be something completely like, who would think like a dog grooming business? Well, there's never a shortage of dogs. So those kind of like narrow, even newspaper, like, I don't know, some people have newspaper routes and stuff, and that like we get creative. The point is like there are certain industries that, yes, I think will be more popular now because now that COVID's long gone, they will be better, but we don't care what industry it is. Like we'll try to help you. If you have a dream, I always tell people, if you have a dream and you want to make a business in the United States, let's help you, because I want you to buy something you like. I have clients call me up, they're desperate, just find me anything, whatever. I'm like, no, you really should find something you like, because you're going to spend your time building it. So.
Absolutely. That's very well said. Thank you so much, Jessica, for putting up this very interesting, I would say, information. And Vihan also, thank you so much for putting up this question. In case if you have any follow-up question or would like to know more from Jessica, then please go ahead and ask those questions. Santosh is here, and Santosh is asking, are there any expected changes to the process for renewing or extending an E2 visa? For example, will there be more leniency or stricter evaluation process after 2025?
So there's 2 ways, as you can see here, renewing or extending, you said. If you do what's called a renewal of your E2 in the United States, you get 2 years to stay here. Those cases, I believe, are scrutinized more. And you don't get a chance for an interview. But there are situations where people just want to renew here and they don't want to go to a consulate to get another E2 visa. So when you have that, they're going to scrutinize them, and they could scrutinize them more, meaning they're going to look at, Tell me about your gross sales. Let me see your tax returns the last few years. Were they positive? Do you have a positive net income? Do you have 2 full-time employees? Did you have a gap and you didn't have 2 full-time employees? Why do you have a gap? So these things are going to get scrutinized, I believe, more if you do it as a renewal in the United States. In terms of going to a consulate, again, it's so based on what officer is interviewing you, right? So you could have an officer that knows their stuff and knows exactly what to ask you, and one that's clueless, and you're just like, why are they asking me this? My attorney prepared me, and it makes no sense, but they have the power. So they have the power. They can ask you whatever within the requirements of an E2 to evaluate it for the strength of it. But I think the E2 visa interview is your chance to address any questions, any concerns they have. And I think, will they scrutinize it more? I would say the general trend is right now that everything's getting scrutinized more, but I don't see it to the point that it makes it so difficult. E2 visas overall, it's very, it could be 80, 90%, like a huge number get approved. It's a very high number of the approval rate for E2 visas because we don't file them unless we think you have a very good shot at it. We're not going to waste everybody's time and everybody's money. So that's where I see, will there be more leniency? I don't see leniency. No, I don't think we're going in that direction. But I don't see it's an impossible situation. But I do think consulate processing still is a little bit easier than doing extension of service in the US.
All right. All right. Okay. Thank you so much, Santosh, for putting that question out. And let's move ahead with Ananya's comment. Hi, Ananya. Thank you so much for being here and participating. Ananya is asking, with the potential changes in the E2 visa policy in 2025, do you anticipate that there will be variations in eligibility for investors from certain countries?
So, as I work mostly with Canadians, or at least half my clients are Canadian, when I saw in the news all the things with the tariffs and restrictions, and I thought, oh, I wonder if they'd stop their treaty. I still think they're very close, and I don't see that happening. I mean, don't quote me, whatever. But where do I anticipate any variations or changes? You know, it's really the regulations are codified and there's certain set criteria. So if a consulate wants to be more specific, like the UK is like, okay, we have a 1-year physical presence requirement in the country, consulates can do that. But the overall requirements, I don't see that there's going to be a lot of variation. Even in countries, I've done E2s in so many different countries, it's the same criteria and it hasn't changed. I could just see maybe like what happened in France. Like a country says, no, we don't want 5-year visa anymore, with America. So they change that. So some of the terms of the agreements, the amount of visa, also the filing fees can change. They could increase them. You could have a larger filing fee when you apply for an E2 visa in certain countries. So some of that stuff, but not the basic criteria. No, I don't see that. I don't see changes in that.
All right. I think that's a good thing, if not the basic things are being changed.
It is, because it's a great way to come here, and people they think, oh, it's $1,050,000. It's not. They get confused because EB5 is the $1,050,000. E2 is tiny, way tinier. And even though $100,000 is a lot of money for people where they make so little per year, 100,000 is a very big figure. So, but it's not, you don't have to hit the 100,000 for an E2. You just has to be. It makes sense. What you've invested makes sense for what you need to run your business.
Absolutely. And that's the main important thing that everyone is noticing.
Yeah.
All right. And okay, so here's another question from Ananya, that are some countries expected to benefit more than others from these changes? All right. Okay.
Well, see, there aren't a lot of changes taking place, except some of these, to not have to have the interview for the E2 visa, that it was waived. So certain countries, then things would process a lot faster. So now, if they have to have interviews all the time, every time you want another E2 visa, certain countries, the E2 visa is not 5 years. Sometimes it's 6 months. Sometimes it's 1 year. So you have to, every time you want to come to America, you can come in, you get your 2-year stay, but when you leave, if your visa is finished, you got to go get another visa. So some of these countries, they don't qualify for a waiver of the interview for the E2, it's going to get backlogged. Do I know all the countries this is going to happen to? No, I don't know precisely which ones, but it could cause some delay in some of these countries. But there's always expedite request. If you need it, if there's a real emergency, you can try to approach the consulate and ask for an expedite. And it's up to them.
Absolutely, I'm sure. All right, the contact details are on I would say, the end of this bar you can see. And with that, thank you so much, Ananya, for putting up this very important question. And let's take up Raghav's comment here. So Raghav is asking about can you explain how the revised E2 visa requirements will impact the duration of the visa and the possibility of renewal or extension for investors?
Well, there aren't a lot of revised E2 visa requirements other than the waiver interview has changed. That just changed. The impact of it, well, right now, some of these consulates, it's 2 or 3 months, right? They have to review the file. They take like 2 months to review it, and then they schedule you for the interview. So will it get worse? So then they could take longer. Some consulates could take 4 or 5 months, so it could cause a delay in that sense. In terms of it says extension. So extension's different because that's in the United States if you're extending the E2. So when you extend the E2, what are any of the revised changes or anything? Well, again, if they're going to see that you have employees and there are very few Americans that you hired, they could come down tough and say, please explain your strategy for hiring more American workers. We'd like to hear it. So we don't know how that's going to filter in to the cases in the queue or the ones that are just going to get filed. What we do know is that if you have strong gross sales, usually if it's a small company, we see a couple $100,000 in gross sales. We see a net income with, even if it's 10,000, it's a positive net income. And we see over the financial statements look good. You should be okay. You should be okay for your extension. And we tell them, you got to work on it. I have clients that they have problems, that their financials don't look right, and it comes time for the E2 visa renewal. So what we tell them is, if you have a 5-year visa and you have, let's say, 6 months left on it, we tell them, leave the country, re-enter. That gives you another 2 years to stay here. Because every time you leave and re-enter, you can stay another 2 years.
Yeah.
So the E2 visa, although it's going to expire while you're in this country, you still get to stay another 2 years, which gives you maybe another 2 tax returns possibly to fix the problem. Because if they can see that your most recent tax returns look good, then that's what helps get you that extension or the renewal. And so that's what we tell them. We have to strategize sometimes so that they can have the strongest case. And sometimes we can't. Sometimes we just tell them, it's a mess. Your E2 is a mess. You're not going to get a renewal or an extension. It's time to close up shop and do something else. And if we can transfer any of the assets and they start another E2, we try to help them with that too. Because we don't want to give them a dead end. We want to find a way for them to stay here. That's what they want. That's our goal. The worst thing an immigration lawyer has to do is say, I'm sorry, there's nothing I can do. Please leave. You have to leave the country. That's the worst. If we have to say that, it's so sad. I spend all day, because I do all different types of cases, marriage cases, telling people, okay, you're getting married, congratulations. I have to tell a guy, fly to Vegas to get your marriage certificate faster than whatever. I tell people all the time, leave, stay, when are you getting married? Are you buying this business? These are critical things for people's lives, but we do it because we want to make the best case for them.
Absolutely, that's beautiful. Thank you so much, Jessica. For putting these very important pointers, and that too in a very positive way. Our viewers are really filled with lots of positiveness, and because
It's
they
good.
learn about two visas, and
It's a
I'm
stressful time for me, so I'm glad that I can give that positive over because our field, I just attended an immigration conference last week. There were 2 classes on happiness. And I'm thinking, what do you need to give us happiness classes for? But our field is so stressful because we want to help everybody. And the Trump administration has so many laws and executive orders and things coming our way that we just have to digest it all and just try to do the best we can. We have clients, yes, we have to tell them it's over. There's so many things going on right now in our field. But we try to give positive. Positive is that E2 is still a great way to come here. That's the positive.
That's great. All right. Thank you so much, Jessica, for putting that up. And Raghav, also, I hope you got your answer. In case if you still have any follow-up question, then please go ahead, and we are definitely going to answer that. Arpita is here. Arpita has another very good question. That what is the potential for increased scrutiny in E2 visa application due to the 2025 changes, and how can investors navigate these challenges?
So we are like a surgeon. We go at the case like everything that there is a gap or something that doesn't seem right. We're like, fill that gap in. Okay. So we start with, where did the money come from? Tell us all the sources. One guy says, oh, I didn't have to pay taxes on it. I said, give me an accountant letter explaining why there was no taxes required, because immigration doesn't know your tax laws and how they work. Then the money's transferred. We show the proof of that transfer. We explain where it came from. We have them sign a detailed statement of the source of the funds. We deal with every issue of the E2 case as precisely like a surgeon as we can, so we can leave no gaps. And that is what we're doing more than ever. That's one of our bigger changes, is that we always filed strong cases. We did our best. But based on my experience and what I know now, when my clients give me feedback after interviews and things, this is what we have to do now. We have to make it even more precise. We don't want a client coming back and saying, we hired you, you had all this experience, and what happened? We're like, no, we're covering it. And even when a client pushes back and says, I gave you enough stuff, why are you asking for more? We tell them it's 2025. Trump's our president. We have to be even more precise. So that's what it's done. That's what 2025 will be more about. A lot more precision than what we do.
Right. All right. That's great. Okay, thank you, Arpita, for asking the question and participating in our webinar. Pooja is here with another question, that what are the most common challenges that investors face when applying for the E2 visa? And with the anticipated changes in 2025, do you foresee any new obstacles for applicants?
So obstacles is something that's negative. I want to say E2s are, there's a path. There's a way to come here. There are great opportunities to come here. So I wouldn't say I foresee obstacles. I foresee opportunities. There really are opportunities. I mean, I have clients that search and search and search for businesses, can't find anything that exists. And they're like, that's it, I'm creating my own. That's an opportunity. They're creating their own business. And then we talk about how being very precise of all the things that we need. And, they have to get their funds in order. But sometimes they'll contact me like a year before they even start the E2, because they just want to make contact with an immigration lawyer before they start the whole process. They want to understand, what are the challenges? What are, some things I need to be aware of? Like, I'll have a client call me up and say, well, I have $100,000 and I gave it to my friend in the United States and he's going to put it into the business. And I'm like, that's not how you do it. It has to be in your name, and the transfer has to be from you. You can't just give it to a friend for an E2. So they'll call me if they made a mistake, and I'll be like, you should have contacted me 6 months ago. I've had clients have to redo deals because they don't set them up right. I've had a client that said, look, it's $1 million. I'm going to put 200,000 down. I'm going to do a seller carryback note for the other 800,000. I said, well, look, it's not really going to work because substantial investment, they look at what it costs to run the business, but tell me about the business. So he says, well, it's really a building. I'm buying a building and the active part of the business is really 200,000, 800,000 is the building. So I told him, you know what? Break it up. Have a contract for the building, 800,000, and pay 200,000 and buy the active part of the business. That's your E2. And that's how we do it. Because otherwise it makes no sense. You can't really, do not like you securing a loan from the business that you're buying, because they're afraid they give you the visa and then all of a sudden you're like, oh, company didn't work out, but I always still have the visa. They don't like that.
Absolutely. And I think those are, very important guidance that our viewers should really know about, because just for the sake of friendship, they are being into such a big obstacle. But I think that's not how it should work. So I'm sure that these pointers are really being going to helpful for them. So
Sam, I
yeah.
would just tell you one other thing also, that I feel like sometimes people are discouraged because they need it to fit into a precise box in order to work for an E2. But we don't do it that way. We look and we see what you've got and what you want to build and what's going on right now. We try to make it work if we can. We try, because they bring us their dream businesses and we're like, if we can make it work, we'll try.
Mhm. All right. Okay, let's move ahead with another question that I got from Vihan. Vihan is here asking, what are the specific legal and financial risks that investors need to consider with the revised E2 visa guidelines in 2025, especially if the investment does not meet expected returns?
So on your business plan, you have the projections. In 6 months, what you're hoping to get from the business, in 1 year, 3 and 5 years. They do not lock you into those projections. Those are just rough estimates. So if you can't bring in what you thought you'd bring in, they're not looking at your case every year. Only when you do your E2 visa renewal or you do your extension of E2 status. And then they're not going to say, by the way, you said in year 3 you were going to make this kind of money, so what happened? Case denied. It's not like that. Those are just projections. What's really important is they want to see, do you have enough money to pay your bills? And let's say you don't. Let's say 1 year you don't have enough money. So let's say you're a wealthy individual and you're going to put more of your money in to help the business grow. Well, you're going to have to explain that. If it comes time for the renewal or the E2 extension, you're going to have to explain, look, I had difficulty. It could be an industry that suffered, or you could have been, let's say it was a hurricane or something happened and it's explainable why your business suffered. Then you can explain that when you file your case. And usually with a valid explanation and to show the potential for growth that you're coming out of that rut, you should be okay. So it's just very case specific. If there's really financial loss or risk and what happened, we have to explain it.
All right. Okay. I think let's take Trizer question here. And Trizer is asking that, hi, I have a business partner. We are in the process of starting an offshore IT and production studio. Now, during the E2 application, which should we focus on as a company works on both aspects?
So I will just wonder where this business is located. Okay. Because if it's offshore and they also have a production studio. So I'm wondering if the production studio, I assume it's in the United States. So this is where we talk about how much time does the person physically as the investor need to be here. We want to make sure we build something here that they have to come and check on regularly. Otherwise, it becomes everything so remote, it doesn't work. But the focus should be on the sales, the clients, the employees that they have. That's to build it up. That's what I would say. And make sure that there's enough activity going on in the US. It's not all offshore.
All right. Trizer, you could let us know from which location you would like to have a business on, so that we can give you a better advice on that. Next, I would like to go with Srujit's comment. Okay, and Trizer here also had a comment that your show popped up on my feed. Found it interesting.
I tried.
Absolutely. It's really interesting. Okay, we are based in India.
Oh, India. Okay, yeah. So that's pretty far. Okay, so he just needs the production studio. I assume it's in the US. That's why he's wanting to come here. And by the way, this is all about E2, but don't forget there's something called E1. So if he has a majority of the trade or services are between the US and their home country that they're providing, then that could be an E1. And majority means substantial, means at least for 1 year, there's been trade or services. And substantial is usually $150,000, $200,000 in sales, but it could be anything. It could be services like IT services. It could be a product that's made in, let's say, India, and they're selling it. Majority of their sales worldwide are with the United States, and they're substantial. That's E1. I didn't say anything about the amount of investment. There was no substantial investment. It is an easier way to come here actually than an E2, but you have to fit the box. It doesn't always fit for people. So it's out there though, E1. And we have to have a treaty, of course. So
That's right. All right, Trizer, I hope you got your answer. And in case if you still have any follow up, then please let us know. Meanwhile, Jessica, we also have some questions from our Facebook group as well, because there also we have a lots of viewers over there. So I think let's take some questions from there as well. So here's another question: that can we travel on B1, B2 if we have applied for EB2? Any issue in it?
Okay, so EB2, employment based, that's the second preference. So that's green card application. So B1, B2 is temporary. That's a way to come here as a business or a visitor. So the question is, what ties do you have in your home country? And when you're coming in as a visitor, does an officer who's seeing you when you enter America, does CBP really believe you're going to return? So just having an application in the system doesn't mean you can't come in on a B1, B2. But if the officer sees it and feels you don't have enough ties to return to your home country, then they don't have to let you in. So we do entry packets. We put together a whole package showing what your ties are there, what you're doing here, and then we prepare you. So hopefully you can get in, because the process can take a lot of time. It can take several years before you actually get the green card.
Yeah, that's right. Okay, let's go ahead with the next question. Hi, I'm an E2 dependent spouse, currently pregnant, due on March. Will the birthright citizenship removal take effect that soon, or will it be on hold due to 22 state lawsuits contradicting it?
It's on hold. They're waiting right now. It's being litigated. So I don't know what's going to happen. We don't know if it'll take effect. Yep, stay tuned. But anyway, March is pretty soon. So it's on hold. So having that baby in March, it sounds like you'll be okay, but who knows if the courts speed up the case or not. But yeah, we don't know.
Absolutely. Let's see what comes at the end decision, and we all are hoping for the best. All right, let's move ahead with the next comment.
It's the same thing, the birthright issue, right? It's a problem. Non-immigrants who have kids born here, this is what it's about. They don't want to give them citizenship. Trump doesn't want them to have automatic citizenship. So yes, they are affected by this if the rule goes into effect. And then there was going to be a procedure. There should be something in place of how they turn into an E2 dependent, right? Because if the kids were born here right now, they're probably not E2 dependents. So there has to be some procedure in place to get them the proper paperwork.
That's right. Okay. I think we got this another question. And Control, if you could let us know about that question, please. Okay. I think we might have. Okay, I think Jessica, there might be some technical issue regarding the FB questions, but not to
Oh,
worry. We do have still a lot of questions, from our viewers. And okay, let's take up one or two questions lastly, and then okay, here we have Yash question. How will the 2025 E2 visa changes affect the ability of foreign investors to hire employees from abroad, especially from their home country? And are there additional steps they must take for this?
so I think that they're referring to the E2 qualifying employees, right? So you can be an essential worker, you can be a manager executive. So the criteria, again, everything will be scrutinized. We need to be more precise, but same criteria. You have to have the same citizenship as the E2 investor. You have to be coming here to work in a capacity as a manager executive or someone with specialized knowledge and skill. And you have to show that you have that experience to do that. So, and then they issue you the visa. And depending on our treaty, how long that visa is valid for, and the dependent spouse can work while you're on your E2 qualifying employee visa. So, yeah, that's the process.
All right. Okay, next up, let's take up Kunal's question. Kunal is here asking, are there any new pathways or benefits for investors looking to transition from an E2 visa to a different permanent visa or green card options following the changes in 2025? Yeah.
It's a very interesting question because right now, the EB5 is the most popular way. And it was not the most popular way because it was such a long process. It was like 4 or 5 years. Now it's a 2-year process because if you're an E2 and you file the first part of your EB5, you can file the second part, which is called adjustment of status together, which means you can apply for a work permit and travel document. The whole thing can be filed together. Some of these other categories, you can't do that. EB2, EB3, you can't do it all together if your priority date's not current, which it's not for these categories, but EB5 is for certain categories. So this is becoming popular. And what's also becoming popular is the regional centers. So regional center says you need to invest $800,000, not $1,050,000, and put your business anywhere you want. You invest in a regional center. So I asked one of my peers, I said, what if you don't have $800,000? And he says, you would be surprised that people either take equity from their house, they have relatives that are wealthy, they are gifted money from friends or whatever, and they make it happen because they want that EB5. And this right now, we see that EB5 is getting very popular. And I used to say EB3 was the way to go, but it's backlogged. And EB5 really is, even though it's a 2-year conditional green card you get, if you've invested the money, the regional center helps you create the required jobs, and then you have to remove the conditional status after 2 years, but people are doing it. They're finding ways to get that money, but that's what I see for 2025. EB5 is very popular.
Absolutely. That too. Thank you so much, Jessica, for taking all these questions and answering them in a very detailed way. So again, I would say thank you so much. It's really appreciating. And I think, Jessica, we already crossed 1 hour. So with your permission, I would just like to know, would you like to answer more questions or should we put an end to it?
I think a lot of the questions are a little bit similar, like, because they want to know in 2025, what are the changes? How will it impact them? And I think we addressed a lot of them. So I think that's good. I just want to share one other thing that I offer a free brief consult so people know to anyone who is thinking about doing an E2. It's usually 10 minutes or so, but it gives them a little bit of direction because a lot of lawyers they get on the, they're going to have a consult, charge right away. But a lot of people just want to get some of the foundation. And also my website is very helpful. I made charts. I talk about the E2 process along with other processes, and it shows the steps and stuff involved in the requirements. And I think that's really helpful too. So if people are thinking about, okay, this E2 sounds interesting, that's where I would start. And they can always reach out to me. But I think for now, the questions, because they're all a lot similar questions, that I think we've addressed, like what changes 2025 and how concerns and any financial concerns. And they just have to find that right business and just call an immigration lawyer or me and, just get started.
Of course, they will, because I can see a lot of questions here, on our webinar, and because viewers are really loving this episode and they are having a lots of queries regarding that. But don't worry, friends, keep on posting as many questions as possible. We are definitely going to take them up, maybe if not in this session, in our next session. But with that, Jessica, thank you so much. We have come across 1 hour. We didn't even realize. So it was your first time with us, and it's not only me who enjoyed. I think everyone enjoyed this session a lot. So we are really honored that you are here. Thank you so much for taking up this time and investing it here. So we really enjoyed, and thank you so much for being here.
And thank you so much as well, because I love educating people, and without education, you cannot make the decisions. So that's what I do. I give you all the information, and the client makes the decision what's the best for their family and their lives. So thank you very much.
That's lovely. We love the energy that you bring us in this show, and also the insights were that too very helpful and wonderful, I would say. So again, thank you so much, Jessica, for being here, and we are looking forward to have more shows with you.
Thank you.
All right. Thank you so much, everyone, for being here and asking a lot of questions. I'm sure if you guys are not very much happy that we didn't take your question, but don't worry. We have asked all the questions, and in the next show we are definitely going to take them up. So till then, don't forget to like, share, and subscribe to Immigration Talk Show. We'll be coming up with very exciting webinar, and that will be lined up just for you. So make sure to press the bell icon also, so that you can get notification whenever we come live. Until then, everyone, take care. Don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. It's me, Sam, signing off for now. Goodbye, everyone, and take care.
Hello, everyone, and welcome back to Immigration Talk Show. Really happy that all you folks have joined us already. And you can let your friends know that there's going to be a very important webinar with very insightful information. So do join us, let them know to also join us. And welcome once again, friends. I'm Napasa. I'm going to be your host for today's session. And I have this important disclaimer to read out before we start our session for today. And that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use at your own risk. So, once again, friends, thank you so much for joining us. We are streaming live right now on YouTube, and you check us out. Do subscribe to us. And by the way, you can also join us in this session by participating, and that you can do by commenting wherever you're watching. So also you can join us on call. All you have to do is dial this number 425-436-6335, and the access code is 988-888. So thank you once again, friends. And yes, today's discussion, as you can see the topic on the screen, it is going to be about the H1B Lottery 2025 and the electronic registration, the process, and how to file successfully and avoid mistakes, since it's the H1B season and there's just a couple of days left. So, yes, stay tuned, because there's going to be a lot of information in this session that you would not want to miss. And you can also ask your questions to our guest for today, none other than attorney Prashanthi Reddy. Please help me welcome her. Hi, Prashanthi. How are you doing today? It's always good to have you.
Great, Nipasa. Doing great. Good to see you as well.
Thank you so much. So I'm excited for today's session because H1B Lottery 2025 being a very important and timely topic right now. People have many questions and looking forward. Maybe you can give a sneak peek into what folks out there can expect from today's session.
Yeah, well, I guess we're talking about the do's and don'ts, what to look out for, how to file, basically how to file a registration, what are the key steps involved. Also, we will be discussing what the common mistakes are and how to avoid them when doing a registration. And we'll also talk about if there are any remedies. If you do make a mistake, if are there any remedies to those mistakes and how to overcome them if possible. And if there are any changes with reference to USCIS from last year to this year or over the last few years that we should be aware of and we should take into consideration when, while doing the registration.
Absolutely. So, folks, what are you waiting for? Ask your questions if you have any, and Attorney Prashanthi Reddy will be very happy to answer. So, yes, Prashanthi, I mean, there's no more time. There's just 2 more days left. I'm sure it's been hectic for you and folks out there who are, getting into this lottery this time. So, my first question to you would be, about the of course, if you can provide sort of an overview, of the latest USCIS updates, um, and maybe tell us what are the changes this year that they really have to keep in mind.
Well, if we're talking in general about, are we talking in general about the USCIS updates or with reference to
Just
H1Bs?
about
You
H1B,
want to,
H1B.
okay. So with reference to, and I'm not specifically talking about registrations, but there are a lot of changes to the H1B process recently with the new H1B regulations, and we covered this expansively in our, I think, previous shows as well. But one thing to keep in mind is that, especially if you are an IT company that sources out their employees to end clients, you should be aware that, you would need purchase orders and contracts and client letters, vendor letters to show that there is availability of work. In the last couple of years, we've been seeing that USCIS has been approving these cases without those documents, but in the new H1B regulations, they've made it clear that you have to show the availability of work, of specialty occupation work for any person that you file the H1B for. So that's one big change. Of course, there's been changes with reference to how to define specialty occupation. There's in the sense that they've included H1B type where you could own part of the company and still file a H1B from that company, and the do's and don'ts. They've said what you can do, cannot do. They're given a time period for that, which is lesser than the regular H1B type. So those are some of the changes with reference to the H1B regulation. But another update I wanted to give is breaking news as of yesterday. USCIS has posted a memo for their basically stating that the way it works with H1B employees, to the extent that it affects H1B people, that NTAs or notice to appear should be given to H1B or other non-immigrant employees or people as well. If their H1B gets denied or if their non-immigrant petition gets denied and they are not presently in status. What is an NTA? NTA is a notice to appear for removal proceedings. So they are basically saying that if you are not in status, your I-94 has expired, you filed an extension while your I-94 was still in status, but it took a while and your I-94 expired and then your H1 got denied for some reason and you are no longer in status, you will be issued an NTA. They did this even during the past Trump period. So we have to wait and see intend to enforce it strictly. They didn't really do that in the last Trump administration, though they did give a similar memo out saying that NTS should be issued to anyone who was on H1 and is not in status, but they didn't really issue those NTOs to a great extent. So we have to wait and see now if they do it more seriously. But they have certainly indicated that that should be done. Just to let you know, in the past, even if you're out of status on a H1B, ICE doesn't usually come knocking on your door. You don't get notices. Of course, you would want to leave because you don't want to get accumulate unlawful presence, and also because you cannot work if you don't have status. So most people would leave anyway. But these NTAs are really a pain because once an NTA is issued, you cannot leave even if you want to. And it could take years pretty much for that, if you go to court, for that NTA to be resolved, for the removal proceeding case to get resolved. It's difficult to go and get and self-deport, because if you self-deport, then you're considered to be deported or removed, which means that you cannot come back into the country. And you cannot file for a change of status or a nunc-pro-tunc, like a change of status on humanitarian grounds like we used to before once the NTA is issued. So there are a lot of implications with this issuance of an NTA. So I would advise employees, employers to be careful. If your employees I-94 is expiring, make sure you file well in advance, 6 months ahead if you can, file in premium processing, and try to get a response from USCIS before the expiry of the I-94. Same thing with the transfer. If you're filing a transfer, I would say don't join the new employer once the transfer is filed, which I know you can do based on AC-21. You don't have to wait for the approval. But if you don't wait for the approval, you join the new employer, and USCIS denies the case, then you're stuck. Then an NTA might be issued because you're now out of status. Because the previous employer might have withdrawn your H1, right? So we don't know exactly in what circumstances they will issue these NTAs, but it's better to be safe rather than sorry, and better to follow a path of caution. So that's, I think, my updates for today.
Thank you so much. Very important updates, Prashanthi, and thank you for highlighting them, I would say. And without further ado, I do have a few questions. So, if you can tell us, especially for employers and applicants out there who are watching us right now, what key steps should they follow, to ensure a successful H1B electronic registration for this year's lottery?
Well, first of all, I think you should create your USCIS online account. You have to create what is called an organizational account. So make sure you create the right account. Don't create an applicant account or a petitioner account. Follow instructions to create it. There are plenty of videos out there on how to create it. So once you have created your account, whether you're doing it through your attorney or you're doing it on your own, gather all the documents that will be required and all the information that's required. I mean, you should collect information such as the full name, date of birth, contact details of your employee, passport number, country of citizenship of your employee, of the person applicant that is filing for registration, and so on and so forth. Also, to complete the electronic registration process, as I said, you need to your USCIS account and complete the registration online. You can submit multiple registrations for multiple employees at one time, but each registration must be unique, which means that for the same beneficiary, you cannot submit more than one registration. The registration form basically asks for basic information about the employer and the beneficiary. Make sure you have your federal ID number, your address, the signatory, the name of the person who will be signing the document, that basic information ready before you start filling out your registration. But you can also save your registration and submit it later if you find that you don't have some of the information that they're asking for. Also important that you pay the correct registration fee amount. There's a non-refundable registration fee of $210 from $10 from last time. 215, I believe. Sorry, not 210. So they must pay this fee online when submitting the electronic registration. Make sure you submit that registration during the designated period. So March 7th is when the registration is opening up, and March 24th is when the registration is closing. So make sure you file within that window. If you file a late submission, they will not accept it. If you file a registration on the last day, you're risking it, because if there's something wrong, then you will not be able to resubmit. Of course, after you file, you monitor the registration results. After USCIS, after you file and the date after March 24th, USCIS will conduct a lottery, and it always exceeds the annual cap, so there'll definitely be a lottery, and employers will be notified of their registration, whether their registration was selected or not, by end of March or early April, before April 1st. And of course, if you get selected, then be prepared to submit your registration within 90 days of acceptance. Make sure you don't miss out on that 90-day acceptance period, because if you file later, again, they will not accept it. For the applicants, make sure that you meet all the basic eligible criteria for the H1. I mean, you don't need to for the registration, but there's no point in filing a registration if it doesn't finally get approved, right? So make sure you have a bachelor's degree in a specific field which is required by that particular occupation. Make sure your employer has actually registered for you, and they have done it correctly. Ask for receipt of that registration. Double check the information that you're giving them, such as the date of birth, passport details, etc., so that there are no issues with your registration. And also keep your supporting documents ready, like your degree copies, experience letters, etc., so that you'll be ready to file on a timely basis. And as I said, just tips for employers: double check all the information that you're providing, stay updated with all the every day there's some new news coming out, so stay updated on what USCIS is saying and what changes they've made. And of course, always have an attorney. It always makes sense to use an attorney, because they will be aware of what the changes are, and they will ensure that your registration process takes place smoothly.
Absolutely. Thank you so much, Prashanthi, for highlighting what we should keep in mind for this year's H1B lottery, and also, to so as to avoid all these common mistakes that could lead to rejections, or being not being able to be valid applicant for this year's lottery. So thank you, Prashanthi, once again. Now, moving on, if you can also tell us about how USCIS has enforced changes, regarding multiple registrations and fraud detection, and what precautions should companies take?
Well, so just to give you some context about multiple registrations, the year before last, before USCIS made the lottery system beneficiary centric, we saw that there were about 780,000 registrations, as opposed to 300,000 the previous year. So it more than doubled, and out of that 780,000, half of them were duplicates. So USCIS realized that this system is not working; it's compromised. So and I don't know why they didn't just do that before, but they came to their senses, and they implemented a beneficiary-centric registration process, whereby the person is put into the lottery based on their passport ID. So if they file several registrations, they will only get one entry into the lottery. So with having done that, they are now less concerned, I think, USCIS, about multiple registrations. In the new H1B regulations, they had the chance of putting in language with reference to, what happens if you do multiple registrations, what are the penalties that employers face. I mean, they already submitted, they already have issued a memo with reference to that, but it was not part of the regulation. But they did not actually put it part of the regulation, and in fact, they said that there was no need to, because they think registration is no longer an issue because people will not file multiple registration because there's no incentive to file multiple registrations anymore, right? But if you do file multiple registrations, you will still get an RFE. Your case will still get denied, and there might be still some punitive action taken upon you. And I must let you know that USCIS has become more advanced in finding out about multiple registrations, especially, multiple registrations anyone can find out because, that we're talking about one company filing duplicate registrations and the registration doesn't even get accepted. But what I'm talking about is collusion. And that's what I was talking about when I said that, they didn't include that as part of the avoiding, forbidding collusion and the penal action that can be taken if you do collude. What is collusion? When 2 or 3 companies get together and file for the same beneficiary, so that to increase the chances of that beneficiary getting picked in the lottery. So I was talking about collusion. Multiple registrations, of course, it's pretty straightforward. You do a multiple registration, it will not even get picked in the registration. But if you do collusion, USCIS has become more advanced. They have advanced algorithms and data analysis to detect multiple registrations for the same employer through multiple organizations that are somehow. For example, they will check the IP address and see that the registrations have been done. The names of the companies are different, the address is different, but maybe the registrations have been done from the same IP address, and that's how they track registrations done with the intent to collude. Also, they have implemented more rigorous data cross-checking to identify patterns of multiple submissions, whether intentionally or done through an error. They've identified ways of checking collusion. So there's multiple registrations, there's collusion, and there is an issue with both. They've also, USCIS has come up with increased fraud detection mechanisms, in general also, to multiple registrations, but with reference to misrepresenting job titles, fake job offers. A multiple registration through collusion is really a fake job offer because every company doesn't have a job for them. It's not a unique job. It's the same job which all the companies are offering to them. So it's a fake job offer. And, general misuse of the H1B system. Yeah, USCIS will likely conduct site visits. They will revoke registrations. They will revoke H1B petitions. Also hold employers accountable for third party. You can't even say that, oh, my attorney did it. Oh, but I outsourced this to a paralegal. The paralegal did it. It's not my fault. The employer is still accountable, and USCIS holds the employer accounting. So USCIS will send a notice of intent to revoke if they see collusion. They will. They will basically not accept registrations that multiple registrations. So you won't even get into the lottery or be counted towards the lottery. As a precautionary step in order to avoid multiple registrations, ensure that only one registration is submitted per beneficiary. Do better vetting within your company. If several people are doing your registrations from different branches, say, there is an USCIS organizational to download all the information into a CVV file, and so that then you can detect the duplicates. So make sure you do that before you actually submit the registrations into one file, and then check for it gets that way. Of course, USCIS will automatically check for duplicates if you've filed one batch and you've submitted the registration, then you try to do a registration for that person again, then it will detect it automatically. But they don't detect duplicates based on 2 drafts which have not been submitted. So make sure there's proper communication between, all the parties involved that are doing the registrations. If your attorney is doing it, don't again, do the same registration. And monitor your third party vendors, whoever, if there's someone else is doing the registration for you. Again, stay updated with reference to, all USCIS policies with reference to multiple registrations.
I really like how you said that this should have been done earlier, but yes, it's happening now. And Prashanthi, 20 years of experience in this immigration field. Would you like to maybe share any case study that could be related to H1B and fraud, or anything that comes to your mind, that you dealt with?
With reference to multiple registrations, since and collusion, since that's what we're talking about, there have been many instances of people doing that because they didn't realize, first of all, that USCIS will be able to figure it out. And they didn't realize the seriousness of it because they were like, oh, that person is doing it. Why can't I do it? Everybody was doing it pretty much. And they thought that because everybody's doing it, nobody will get caught. But USCIS, though they cannot catch everybody, will catch as many people as they can. And you might be one of them, right? So you can't be certain that you won't. So that's why, and I've seen lots of instances where that's happened and they've revoked cases. I mean, even last year when there was no need to do multiple registrations, people have done it simply because, their employees wanted them to do it. I'm like, why would you not tell your employees the downside of doing it? There's no upside of doing it, but there is a downside. And which is the fact that, even if the registration is picked, then even if you get it approved, it can get revoked, or there could be an RFE, and then they have lost their opportunity to, get a H1, and you might have lost your opportunity to file H1s in the future. So yeah, there are many examples in which USCIS has found fraud with reference to multiple registrations. And, they have come and visited. And there is also instances where they have actually, penalized them in the sense that they're considered to be a crime
Banned.
and placed criminal charges against these companies. So
Okay.
something you want to avoid.
Absolutely. Thank you so much, Prashanthi, for highlighting them. And yes, with that said, I would like to say hello to folks out there who have joined us: Supriya, Madhuri, Mohandas, RK. Thank you so much for joining us with your questions. And I think we should address some of them. So let's take up RK's one. What will be the impact of USCIS who's looking to issue NTA for more cases than the requested immigration benefits are denied?
What will the impact with USCIS? Or if USCIS is looking to issue NTA for more cases that yeah, so there are a lot of issues here. I think number one, if your case has gotten denied, then leave the country immediately. Don't hang around hoping that something will happen. If you do hang around, then file an appeal so that you're protected against removal proceedings, because you have an appeal in place, you're allowed to stay in the country with that appeal pending. So definitely, even if you think that, there are less chances of your case getting approved on appeal, you should just file it so that you can preserve your chances of staying here and giving yourself some breathing room. Also, again, I said with reference to transfers, be careful. If you're going to start working for your new employer, even before the H1 gets approved, then be aware that if it gets denied, then, and if the previous H1 was revoked, because the employers usually withdraw if you stop working for them. So I would say file your transfer in premium processing and then, move to the new company after it's approved so that you can avoid, again, receiving an NTA. Don't stay beyond the 60 days grace. You have 60 days grace. I don't think they'll issue an NTA within the 60 days grace, but you have to remember 60 days grace is also discretionary. So they may decide not to give it to you, though I haven't seen that happen, but it could. But you have to be aware that's discretionary and a lot of people don't know that. So if it gets be subject to an NTA. So overall, you have to be more cautious about falling out of status. Apply for your extension as soon as possible. Don't wait for the last few months to apply. You can apply a maximum of 6 months in advance. So do that and do it in premium processing so you're not in a situation where your I-94 has expired and your H1 gets denied. Another last tip is avoid filing anything with USCIS if you can help it. More exposure to USCIS means more chances of getting a denial, more chances of getting an NTA. So avoid filing anything with USCIS if you can help doing that.
Okay. That's interesting, the last point. But thank you so much, Prashanthi, for bringing that up and taking this question for RK. And RK, I hope you're happy with Prashanthi's answer, response to your question. If you have any further questions, keep commenting. Now let's take up this next one from Supriya. My job title is data analyst, and USCIS issued an RFE questioning if it qualifies as a specialty occupation. Under Trump's policies, are non traditional STEM jobs more likely to get denied?
Well, I don't think a data analyst is a non-traditional STEM job. I think it's very much it is a STEM job. But data analyst positions are always. I'm not surprised that you got an RFE. It's pretty common to get an RFE on a data analyst position. If you say data scientist, you might not get an RFE, but if you say data analyst, you might. So it's important to, before filing a H1, to explore that job title, explore the job duties, and see. And a good attorney will do that and see what is the likelihood of getting an RFE, and if possible, tweak it if you can. Though it's the job description that's important, the job title also will, sometimes USCIS just looks at the job title and they'll issue an RFE based on that. So I would say if there are internal job titles within your organization that, may more accurately represent your job description, use those. But I wouldn't say that it's impossible to get a approval on a data analyst RFE. Definitely there is very good chances of getting approvals. You just have to do it properly, respond properly to everything that they're asking for, prove that it's a specialty occupation. In general, non-STEM jobs might be more likely to get an RFE, especially not just under Trump's administration, but maybe more so under his administration, if the job is kind of borderline with reference to specialty occupation or not. A lot of non-STEM jobs, especially if they require like a bachelor's degree in business administration or a bachelor's degree in liberal arts or a bachelor's administration in science, and they don't specify what field of science. So if the industry just requires a broad bachelor's degree, and that could be the case in a lot of non-STEM fields, that's the reason why you might get an RFE. But if it is, even if it's a non-STEM field, if there's a requirement for a specific degree, like say economist, a bachelor's degree in economics, it's a non-STEM field, but it's still very much a specialty occupation. So, it depends from job to job, but it's more likely in a non-STEM field that you'll face difficulty rather than like an IT field where, the requirement is clearly a bachelor's in computer science. Or for that matter, another example in non-STEM field would be an attorney, right? I mean, an attorney definitely requires a JD, a bachelor's degree in law to practice. So even though it's a non-STEM field, there's no question that it's a specialty occupation. So it really depends from job to job.
Right. Very well explained. Thank you so much, Prashanthi. And Supriya, thank you for asking your question. Keep commenting. We really appreciate it. So this next question is from Mohan Das asking, I am an a Germany blue card holder. What are my options to move to US? And what would be a rough estimate of amount I would be spending for applying H1B?
Um, your options, you can move as a student. If you have an immediate relative, you can ask them to file a green card for you. If you have a job in the US, you can apply for a H1. Your employer can apply for H1. Your estimate amount should be zero because your employer should be spending you should be paying for the USCIS fee and the attorney fee, etc.
Okay, thank you so much, Mohan Das, for your question, and thank you, Prashanthi.
I mean, there are
Now,
other options as well. You could,
yeah.
a multinational executive L1 could be filed if you are working for a multinational company in the US, in Germany for the last 1 year as an executive and or a manager and you're looking to move here to work for their branch office or their subsidiary or their related company. You can also file an E2, which is a treaty investor. I think Germany is also part of the is considered an E2 country, but I'll have to look that up. So yeah, these are some of the things that you can do.
Okay. Thank you, Mohan Das, for your comments, and thank you, Prashanthi, for taking that up. So, Madhuri, now this next one is from Madhuri in YouTube asking, I'm applying for the H1B lottery this year, but my employer is worried about my new wage based selection rules. Will lower wage applicants have a realistic chance, or will most H1Bs go to those with the highest salaries?
So nothing has changed with reference to prevailing wages. The Trump administration has been talking about changing it, but they haven't changed it yet. So it does not affect the present cap season. But having said that, wages do increase every year, and so it has increased by 10-12%. It increases every year. So from that point of view, yes, it becomes more and more difficult if you're getting paid lower than the prevailing wage. You could use level 1 if you are a fresh graduate, but if you're going below level 1, and if you don't want to use the prevailing wage from the Department of Labor website, then you can do your own wage survey and see what comes up. It's expensive to do your own wage survey, but it can be done, and maybe you'll get a better wage there.
Right. Okay, thank you so much, Prashanthi, and thank you, Madhuri, for your questions. So, Prashanthi, that there are a lot of changes this year as well, and I really hope that everybody, they go through this process well. They're able to file their, fill in their forms and get into the lottery. But yes, if selected in the lottery, what are the next steps that applicants should follow to avoid delays or denials during the petition filing?
Well, first of all, you have to review your lottery notification. And the attorney will receive a notification from USCIS that your petition has been selected. So verify that you've received that. You have to log into USCIS account to check whether you've been selected or not. Once you've received the lottery, just pay attention to it. See where they say you have to send the petition to, and send it to that address. So pay close attention to the lottery notice. Also pay attention to the last date when you should file. That's also in the lottery notice. And of course, you have to file an I-129 petition. This petition must include detailed documents about the applicant, the job, the employer, You need to file, before you file the I-129 application, you have to file the labor condition application, the LCA. And you have to gather all your documents like the applicant's educational credentials, their degree copies, and get an evaluation done if it's a foreign degree. Experience letters, if that's required from the beneficiary. Of course, they have to have passports, and their passports have to be valid, even for a registration. There was recently a person who came to me for a registration. His passport expired in 2021, and he didn't notice it. And he can't do the registration now. He has to try and get his passport updated and get it renewed, but he may not have enough time. From the company point of view, get all your offer letter in place, your company documents, tax filings, proof that you have an office space, your lease, and proof that you have work for the person that you're going to hire. If that person is going to be working for a client, then that would be, purchase orders, MSAs, contracts, client letter, vendor letters. Show that you have all that. Make sure the information in that document matches with the information in your LCA, matches with the information in your I-129 petition. If there's discrepancies, you're better off not including the documents than including documents with discrepancies. And finally, make sure you file within the 90 days. And with reference to documents and information that have to be provided, job description also is important. You have to include a clear, detailed job description, job duties. There has to be a letter which also mentions the employer's business, why the job is a specialty occupation, why a bachelor's degree is required, why the employer requires you, and how they have enough work for you to be hired in that particular job. All this is, you have to submit a letter which has all this information in it. The job description has to show that it's complex and a bachelor's degree is required to perform those jobs. So be careful with the job description. It's very important. Sometimes even if your job title is, say, a software developer, but if you put in duties of a programmer, testing, programming, then you're going to get an RFE saying that, yeah, your job title says that, but your duties actually don't show that you're working as a developer. You also have to show that your employer has the financial stability to be able to pay your salary. That again can be shown by the volume of business that they have. And the filing fee, make sure that you submit the correct filing fee. The filing fee is very complex. There's a base filing fee. There's the ACWIA filing fee. There's a fraud prevention and detection fee. And there's also now the new asylum fee. And the fee is different depending on how many employees you have. Over 25, there's a fee. Under 25, there's a different fee. So USCIS has a very useful tool for this. So use that USCIS tool where a fee calculator tool where you can put in all the information and it'll calculate the fee for you. That's very useful tool to have. Last but not the least, if you get an RFE, monitor your case. If there is action required, such as if you get an RFE, make sure you wait for that RFE. If you don't get the RFE in the mail, call them to find out why you didn't get it, because sometimes if you don't pay attention to what status is on the website, you might have an RFE because there's some mess up with the post office and they don't mail it to you. That happens quite often, more often than you think. And then the H1 might because you don't respond to the RFE. So keep an eye out for what your status online. And if you see that there is an RFE, then read the RFE carefully. Provide all the information that they're asking for. Don't respond in an incomplete manner to the RFE, and respond promptly on time because there is a deadline to respond, and send it to the right office. The RFE will tell you which office to send it to. I think that is a few of the things that you should do once you get picked to have a successful approval.
Thank you so much, Prashanthi. And I'm sure that folks out there are very excited, nervous, anxious at the same time. But here's wishing each one of you who are preparing for this H1B season all the best. It's going to be all right. And stay with us because we are going to be back right after a short break and we'll take up more questions with none other than immigration attorney Prashanthi Reddy on Immigration Talk Show. Hello and welcome back, everyone, to Immigration Talk Show. And today we are discussing about H1B Lottery 2025 electronic registration and how to file successfully and avoid mistakes with none other than our guest for today, attorney Prashanthi Reddy. And it's been very interesting so far. Thank you so much, Prashanthi, for taking up so many of our questions very patiently. And there are more to go, so I hope you're ready. And
I am.
yeah, so
Bring them on.
yes. Let's go for it then. So, Control, if you can also, put up our questions from our YouTube, since we have so many people asking many questions, it'll be very nice. So, let's take up this first one. This is from Mungel Kar. Hi, my employer is willing to sponsor H1B but doesn't want to pay for fee and attorney, is there any way we can share payment or is there any legal way we can do it?
For the registration, they definitely have to pay the registration fee uh, for the attorney as well as for the registration. I think the attorney fee, if there is any. Um, For the USCIS fee, definitely, I mean, they should pay the USCIS fee, but there's some fee that is completely mandatory that that the the employer pays.
Mhm.
But in general, I think it is prudent for the employer to pay the USCIS fee, but the premium processing fee is something that the beneficiary can pay.
Okay. Thank you so much for taking that up. And let's go on to our next one. Control, please. This is from Sandeep asking, hello, I have H4 and didn't travel to USA yet. I was picked in 2025 H1 cap. Do I need to be in the USA for status change from H4 to H1B? What will be my options?
Yeah, you could come on a H4 and then file a change of status from H4 to H1 based on the fact that you're cap exempt. As of now, they would consider you cap exempt. I don't know if they would change that, how they see cap exempt cases or who is cap exempt in the future. But as of now, I think you would be cap exempt. So if you don't want to go for a visa, H1 visa, then that's what you would do.
Okay. Thank you, Prashanthi, for taking that up. And now let's go on to our next one. This is from Raja. If the H1B lottery is based on passport number, what will happen of two employers applying H1B for same person?
That's fine if two employers apply for the same person, as long as there's no collusion between the employers and the job offered is independent. Each have has their own job. Like you, for one company, they're hiring you to work with AT&T, and the other company is hiring you to work for UBS.
Mhm. Okay. Thank you, Prashanthi. Thank you for taking that up. And this next one is SSS is asking the lottery system to be abolished and preference to be given only to the merit. In this lottery system, unworthy people are trying to um, trying through fake consultancies and stealing the diets of genuine candidates and getting 2 to 1G in interviews. And finally, revocation. USCIS should put lifetime ban for them on them. What do you have to say on that?
Um Harsh, but yes, if there's fraud, they have to face consequences. So that, as he said, people who are genuine and I mean, so I must say that that's not happening as much now with the lottery fee. I'm hoping with the lottery fee having increased, the registration fee having increased, and with um, the multiple registrations not happening as much. I think the fraud has gone down significantly, but there still is fraud, and I agree that they should face consequences if they file frivolous registrations for people and take money from people, just file registrations, not even have a job for them. That's what I think he's referring to, and I agree.
Yes, absolutely. Thank you so much, Prashanti. And last but not the least, this one is from Rajkumar asking, my wife on H4 I-94 is till passport expiry date. What to do after getting new passport? Can she apply to extend the I-94 same as mine, that is H1? If so, where? Kindly please advise.
If she's in the USCIS, if she's in the US, she would file an extension with the USCIS. If she's outside the country, she just has to, if she has a visa already, even if it's on her old passport and if it has not expired, then she can just come into the country and she'll get a new I-94. Or if she's outside the country and her visa is expired, then she'll have to go for a new visa and, then she'll get a new I-94 upon arrival.
Right. Right. Thank you so much, Prashanti, for taking that up. And I think with that, we've covered our YouTube questions from our viewers. Thank you, Prashanti. And we got more questions, though. So let's go ahead and not keep them waiting. So let's take up Mohan Das, who's back again asking, would it make any difference if I apply after taking German citizenship?
I think I covered that, even though you said because I know you said you are not a German citizen, but I did cover it. If you are a German citizen, then you might be able to apply for an E2, which is a treaty investor or treaty trader visa. That is, if you're investing in certain amount of business money into the US, or your employer is investing a certain amount of money into the US in a business, and they want to send you to manage that business. That's called an E2. Other than that, there's no other special privileges for German citizens.
Okay. Thank you. Thank you, Mohan Das, for participating very actively. Now I got Vikas. Vikas is asking, the registrant or the organization for whom the registration is submitted has not worked with or agreed to work with another registrant, petitioner, agent, or other individual or entity to submit a registration to unfairly increase chances of selection for the beneficiary or beneficiaries in this submission. My understanding is of this is if I file two H1B applications, both will be rejected. Is that correct?
Because are you the employee or the employer? And just to get you to understand what this means is that if there are two organizations and they both file a registration for you, and if they're not related to each other, and if they have not colluded to decide to file for you in order so that you can increase your chances, there is no collusion and there is no problem. You can file more than one registration. You can file a registration through both the companies. And also the job has to be different, as I said before. If the job is separate in each instance, then you can file through both.
Okay. Okay. There you go, Vikas. You have your answer. Thank you, Prashanthi, for taking that up. And Prashanthi, if you could also highlight some of the red flags, that USCIS looks for in H1B registrations, and how can employers really ensure compliance with regulations?
I mean, red flags is basically I think we talked about collusion.
Yes.
We talked about I think we talked about this, Nipasa. We talked about
Okay.
collusion, avoiding duplicate registrations. We talked about I mean, and I can tell you that typographical errors should not be made. So make sure you enter the right passport ID number, the correct spelling of the beneficiary's name, right address of the employer, your correct federal ID number. Because if you do a registration and you have wrong information in there, if it gets picked and you have to file the H1, you might have some issues with, I mean, you'll have to explain the discrepancies at that point of time. So make sure you enter all information correctly. Do the registration. Don't do it in the last minute. That's a red flag. Because if it doesn't get picked, or if you notice later on that there's a duplicate, that you did it twice for the same person, you will not be able to then delete one of the registrations because the system will close you out. So do it ahead of time. Doing it at the last minute is always a problem.
Right. Thank you, Prashanthi. And Vikas is back saying that I am an employee, and thanks for your answer.
Okay.
Anyway, so Prashanthi, now if you could also, tell us if a small IT consulting firm submits H1B registrations for 20 employees, but 15 get rejected due to alleged duplicate filings. What legal options do they have, and how can they prevent this issue in the future?
So when we say duplicate filings, we're obviously talking about collusion.
Yes.
I think what we're talking about here is that registration was done, case was filed, and then in an RFE, USCIS is alleging that there is duplication due to collusion. In that case, I mean, when we say alleged, that means maybe there isn't duplication. So if there is really no duplication and USCIS is alleging that there is duplication, then you have to prove to them that you have no relationship whatsoever with that other company. That, and we've heard these stories that they are agents that employers get their resumes from, and the same agent is giving the same 10 resumes to various employers. So various employers might be interviewing these people, and that might be one reason why there's duplicate registrations. The same employer, I mean, the different employers have the same people in their list. So that could be one explanation. And you can always, it could be a coincidence, but of course it's 10 or more are the same, then it may not be a coincidence. But if it's one or two that are the same, I mean, it's unless, if you have really done no collusion, there is always ways of showing it, submit an affidavit, refuse to acknowledge that, you had any knowledge or that you colluded with this other employer. You can also show that the job offer is completely different, that your job offer for this person, you've done it because, you have a job through blah, blah. You can show proof that you have a job. You can show the contract, you can show the work order, etc. So despite that, if they deny it, then you can file an appeal, or you can file a motion to reopen or reconsider. And you can seek judicial review after that. You could even file a case in court. And of course, before you do any of these things, contact your immigration attorney to find out what is the best course of action. But if it's just based on multiple registrations, they say that there's a duplicate registration, but there isn't. There wasn't one. And then they deny your registration. I don't think there's much you can do other than refile that registration. That's why I said that make sure you file much before the deadline, because if there is even some fault on the part of USCIS and they deny your registration, you can refile that registration. And I think that might be another way of doing it, because there's not much you can do with reference to an appeal for the registration part. But I mean, prevention is always the best cure, right? So avoid obviously potential duplicates. Have like a robust internal filing system whereby you can easily detect duplicates. Use a tracking system. Educate your employees that they shouldn't file. What can and cannot be done. And of course, it always helps to have a experienced immigration attorney help you.
Right. Right. Thank you so much, Prashanthi, for taking this question up as well, and for helping us, with some of the points and tips to keep in mind today, since this H1B season it is, and there's so much going on, and people are really preparing themselves for this season. So, thank you so much. And maybe before we leave, if you can just give out a maybe like an end note or anything that you want to say to the audience out there and for those who are preparing also.
I think it's important to keep in mind that there is a short window for filing registrations, and also that there's a 30% chance of your registration getting picked. So don't lose that opportunity, especially if you're on an F1. Make sure you file your registration every opportunity that you get, because even if you have 3 years on your STEM of 3 years on your OPT, including STEM OPT, that may not be enough time. So if your employer is not willing to do the registration, find a new employer. Ensure that the employer files your registration within the well before the deadline. Ensure that whether it be the employer or employee, that you do it correctly, because again, there's only one chance that you get every year, and even that is a lottery system. So it's becomes even more important to do your registration properly.
Right. Right. Thank you so much. Friends, I hope that you really resonated with all whatever Prashanthi had to say today, answering so many of our questions. And I hope that you resonated with each of her answers as well. So do not forget to like, share, and subscribe our content, especially this one. And do not also forget to hit the bell icon so that whenever we have discussions and webinars as informative as this one, you are notified, and maybe you could also join in to ask your questions. So also do not forget to check out attorney Prashanthi Reddy, who has been such a sport, answering so many of our questions. You can also have a one-on-one consultation with her, get in touch with her for your questions, and let her know that you are connected to her through Immigration Talk Show. She'll be happy to know. And yes, email her, prashanthi@reddyesq.com. That'll be the best way. But otherwise, if it is an emergency or very urgent, maybe you can even give her a call. And her number is 212-354-1010. And definitely go visit www.reddyesq.com to get to know more about Attorney Prashanthi Reddy and the law offices of Prashanthi Reddy. So thank you so much once again, Prashanthi, for today's session. And I'm already looking forward for our next one when you can join us.
Thank you. It's a pleasure as always being here.
Thank you, Prashanthi. Have a great day ahead. And folks out there, thank you once again for joining us. And with that said, also check us out. We are Immigration Talk Show. Our handle is Immigration Talk Show on YouTube. Do not forget to subscribe to us. And also check us out on LinkedIn, Facebook, X, Instagram, and connect with us, all right? Also, you can email me. My email address is nipa@staffingly.com. You can send in your questions, queries, and we will be able to put it up accordingly to the attorney, or give you a response accordingly. Thank you. And also you can WhatsApp me or call me on my number. My phone number is 408-335-6444. Thank you so much once again. Have a great day ahead and stay tuned on Immigration Talk Show, because there's so much you do not want to miss.
Hi everyone, welcome to Immigration Talk Show. I'm your host Rivera, and before I move ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to Immigration Talk Show. I'm Rajni Bharara, your host, and today we tackle a topic that is at the crossroads of opportunity and controversy. The H1B visa program. Is it a catalyst of economic growth and innovation, or does it pose a threat to American jobs? Well, we are going to talk about that with our guest today, who is none other than attorney Aaron Green. He's not just an immigration attorney, but also an H1B visa expert. So we are glad to have Aaron on our show again. So now, without any further ado, because I have a lot of questions that I would like to ask from Aaron, so I would not like to waste any more time and directly, welcome him to the show. So, Aaron, welcome to Immigration Talk Show once again.
Thank you. Good to be here. Thanks for having me.
It's a pleasure having you. And, I was so excited for you to come back so that we can talk about this topic, because this topic in particular, everybody is talking about it, and people are so much curious to know about what's been happening. And because every now and then, just yesterday, we got an update on uscis.gov about H1B visa. And every now and then we are getting so much information about this particular visa. Before we talk about H1B visa, whether it is good for the economy or whether it is posing a threat to American jobs, I would actually like to know from you, like from the time President Trump has taken the office, a lot of people are always having a debate about whether it is good for the immigrants, especially, or whether it is bad for the immigrants. And now that the deportation is going on, people are having so much to talk about. Some are in favor, some are against. Celebrities are crying and making a video and posting that on their social media. So I would like to know from you, with all that have happened, what do you think about it? Is it like, with whatever that is happening and whatever that Trump administration is doing, do you think it is benefiting the immigrants, or is it going against the immigrants?
Yeah, I think what Trump's doing is benefiting legal immigrants, people who come here in categories like H1B, L1B, TNs, people who abide by the laws of the country, people who do not for a second want to have any kind of violation, even if it's an overstay of an I-94 or anything. So it's a good thing that when people break the law, that it's taken care of. I can't believe it's even a debate, especially at this stage. They're removing criminals right now, and hardened criminals, some of the worst. I can't believe that's a debate. But as they remove all the criminals, yes, they need to look at, for example, those who have been given asylum hearings and don't show up, when they're called, which is probably 90 to 98% of people who are given asylum hearings just don't show up to their hearing years down the road. That shows you how much of a scam the asylum entry that's been going on for years, and especially the last 4 years, where it's been elevated to a degree that no one can believe. So yes, what's going on now is what Trump promised. Those who are criminals and here illegally are being removed from the country. It's going to take a long time. But yes, illegal immigration is bad for legal immigration.
Right.
H1Bs wait years and years to do everything right. They so-called wait in line, quote. They wait in line, they pay fees, they make sure everything is right, they stress out, they do it the right way. We're the most generous country in the world. We offer the most legal green cards in the world by far. And especially when it comes to work visas and work green cards, we offer the most in the world by far. So there's a mechanism to get here. The fact that we cannot take on the entire world's poor people, even though we have a heart for poor people, but you can't just allow people to come in the country just because they're poor and tell them, just claim asylum and then you're in and you can get everything you want right away. That's not how the system should work. That's a broken system. And yes, it does affect those in the legal immigration community, like our H1B workers.
Right, very well said. But then, Erin, I would also like to know from you, all these influential celebrities who have so much influence on people, and because, people do look up to them. So, I mean, they are not directly involved with all these things, but when it comes to all these, controversies, they do share their opinions and viewpoints on what they think. So why do you think these people are, if I can say, like, crying for these people who are being deported and posting the videos and coming in favor of them, though they know that, that the path that they chose and how they came to the country was not the legal way. But then why do you think, this is also happening on the other side?
The problem is that celebrities are ignorant and or stupid. So that combination can be very influential when they have millions of followers or fans that like them just because they can sing a song or act in Hollywood or Bollywood, but here it's Hollywood. It's ridiculous. Those who follow these people are probably and believe in their opinions and what they say are probably the most ignorant people in our society, unfortunately, and not the brightest. And unfortunately, a country of 330 million will have a lot of folks who never read anything about immigration or any topic, but they get a little feed on their Twitter or Instagram or whatever they use, and some celebrity is posting that, and now they think they understand the topic. They don't. It's misinformation. It's terrible. These celebrities are the worst. If they could just do what they are paid to do or what they are famous for, which is either sports or acting or singing or whatever, then everything would be a lot better for the rest of us. But they have to now chime in on every social topic or legal topic that they know nothing about. It's unfortunate. For your listeners, I would not pay attention to any of them. None of them are experts. None of them know what they're talking about. And everyone has sympathy for poor people. I don't have to be a celebrity to say, I feel bad for poor people. I like them to come and have an opportunity, but you have to do it in a systematic legal way that's fair to everyone. Right. I've said for many years, if they could increase the H2B program, this is a little bit off topic. The H2B program is for non-degree workers. It's different than the H1Bs where you have to require a degree, right? A 4-year degray or equivalent. H2Bs are your farm workers, people who work in hotels. They come in seasonally, and it's great. They're usually people looking for a little bit of a better job, more money in their job, and this was established for that and to fill a need in the U.S.
The problem with the H2B program is that there's not a lot of them given out. I don't know the actual number. But again, like the H1B, there's a cap in the lottery for that, and companies applies for those. And it's great. The people are vetted thoroughly. They come seasonally, they go back, they bring the money back to help their families in different countries, and then they can come back again. If we could expand that program, we could help a lot more of the world's poor. But by doing what they've been doing for the past 4 years, especially, and before, with this phony asylum claiming sham, scam, and just allowing people to come in willy-nilly from anywhere, it almost blows your mind. You know, that, and that's an educated opinion. I've been reading and lurking into this for years and years. Plus, I'm an immigration lawyer. But just by being an immigration lawyer doesn't mean anything, because I know a lot of immigration lawyers, very well-respected immigration lawyers, who take the opposite approach, who think, no, all these people should be coming in and should have an asylum hearing. It makes no sense. These people don't qualify for asylum. They know it, and they're just trying to substitute some kind of logic in there to bring in masses of people. Some of these lawyers profit off them, obviously, and others are just ideologically backwards.
Right. So, but Erin, do you think, because if immigration attorneys themselves, if they, come in favor of these people, and also celebrities, them being so influential and they have so much influence on people and people's mind, and also by the political parties, they are also called for campaign promotions, right? When they are going out for campaigns, these celebrities are also called. So, do you think if they make these statements, do you think it creates any kind of influence, or like the government also creates this, or also have decisions, or makes decision based on what these people are saying?
Not this government. No.
Okay.
Traditionally, when you talk about these celebrities, they have been in our country, they've been 80 to 90, even higher left wing, meaning Democrat, very liberal left wing. We're seeing a shift now as the country saw in the last election how it had been destroyed for the past 4 years, and how these folks are just preaching nonsense. We've seen a shift in a lot of voters to say, you know what, this is ridiculous. We've gone too far. These celebrities have lost most of their influence, in my opinion. And the fact that there's a rise of celebrities that are actually posing another opinion now without the threat of being canceled or, fired, which is what had happened. They use fear in their industry to hold a grip on one political position and opinion. And if you disagreed with them, well, you weren't going to get your next acting job or your next music job, etc. So now there's a big shift. If I'm an H1B worker and I see these yo-yos screaming because we're enforcing the law, finally, I wouldn't pay any attention to them. And so that's my advice to anyone out there who's not American or who thinks these celebrities have some kind of influence. They don't, especially not on this administration that's just been elected overwhelmingly.
Yeah, really glad, right?
Yeah, I can't imagine if the other side would have won, how this immigration mess would have continued and gotten worse. Who knows what would have happened, leading to the destruction of our laws and our country. Who knows? But now it's time for law and order to restore the destruction that has been done over the past 4 years. And they're doing it now. They're starting on day one and they're getting going, and they're just starting.
But do you think this mess will be, all this mess that the government is, or the administration is trying to clean, or that they're trying to accomplish, do you think they will be able to do this in these 4 years?
In terms of stopping the ridiculous, everyone come in, we'll let you into the country, we'll even fly you in program, that's already been stopped. So it's like a drain with water. That's been shut off. Now, what has come in the last 4 years, we don't know. Is it 10 million? Is it 12 million? Is it 8 million? A lot of them came in, just over the border, and there's been no, they didn't have enough resources, and they didn't want to have enough resources to catch them. So the challenge will be how to remove a lot of the illegals that came in the past 4 years. And I don't know how long that will take. But they need to start somewhere. You start with criminals. You have a record of them. You know where they are. I think they'll move on to people who have not showed up for their asylum hearings, which is the whole reason why they were allowed here in the first place. Then they'll go after them, and but that's a whole different topic. That's not something I'm an expert in, but I certainly am very fluent in it, watching what's been going on the last 4 years in that arena and how our border we don't have a border. So now we need to build a border, and that's what they're trying to do.
Right. Okay. Now let's come back to our topic, H1B. So I would also like to know from you, Erin, that how do H1B actually impact American job markets? Because, some people are saying that it is posing threat to American jobs. So would you say that it is posing threat to American jobs? Or because we have, also heard conflicting reports about whether these visas create jobs or they reduce the job opportunities for American people?
I really think they create jobs. Look, if we had an abundance of American students who want to get computer engineering degrees and electrical engineering and mechanical engineering sometimes, and all these other related degrees, STEM, if we had an abundance of that in the computer field alone, then you can make the argument that, yeah, the H-1B is not needed, and you would see companies would not utilize the H-1B like they do now. But because we have a shortage in school of American students not taking these particular majors, they simply don't want to do coding. They find it boring. We have a great need for foreign talent. H-1Bs fill the gap immensely, and we could use even more. You can see the numbers of H-1B applications in the lottery every year. Last year was over 700,000, I believe, if I'm correct. And that doesn't even include all the existing H-1Bs that are in the country who've already made the lottery. And they're all employed. None of them are unemployed, very few. So, and you can look at these big companies' web pages, you can see all their career openings, and there's just tons of openings in these positions everywhere. So I believe that it does not hurt the American worker at all. In fact, American workers who are in the field are at a prime. Companies do not need to spend thousands and thousands of dollars on green cards and H-1Bs and extensions. If they have a talented American worker at the same level, they'll simply hire the American just by economics. So my answer is no. I don't think it hurts American workers at all right now.
Okay. All right. So also, guys, if you're enjoying this conversation and if you're getting information out of this conversation, make sure to subscribe to Immigration Talk Show and like the video, share with your friends and family who you think needs to hear this. So yes. And coming back to you, Erin, I would also like to know if you can provide some examples of maybe some companies or sectors where you think, hiring H-1B workers has led to significant job creation.
So most H-1Bs, as you know, are computers and computer-related jobs. Now expanding into AI, which involves obviously computers, data engineering, software, anything from software to even project management, anything related to the STEM field of computers and computing. That's the biggest use of H-1B. It still is. You can see the LCA data statistics. So what exactly is the question? How do these H-1Bs contribute to growth in companies?
I was saying if you can provide some examples of some companies or maybe some sectors where you felt that, this hiring H-1B workers have created significant job creation for, US workers. Has led to
so the IT sector. So for example, if you don't have talented folks here and you need an abundance from overseas, well, what comes with that is very innovative people. Some of them will go on to start new companies after they leave their company. They'll start startups. They'll make new products. The H-1Bs who are working for existing IT companies, even if they're big companies, they can develop things within their H-1B role that will lead to new products, new platforms, new algorithms. These will turn into new services and products, which will need additional employees to support them. So there can be a lot of growth, not just from the H-1B worker, but from other workers. Let me give you an example. When I was the head of immigration at Infosys, I used to go to all the client sites, which were all mostly Fortune 500 companies. And I met with all the managers, and we talked to all the employees and answered their immigration questions. They were all mostly H-1Bs and L-1s. And at the time in California, there was a big controversy over one of the clients removing their H-1B department and replacing it with Infosys, for example, and another contracting company, and basically taking over the whole IT function. So when I talked to some of the managers, I said, they're removing the IT department that's there, and they're bringing you guys in. So 3 things. Number one, in a lot of these situations where the IT department is removed, they offer the jobs to the folks that are already there. In a lot of these cases, I know they did at Harley Davidson. That was one that I worked on. The electric company in California. I'm not sure about that, but going further, the managers would tell me that when they come in and bring in a specialist like, an Infosys or another company similar to that, they save them a lot of money because what they're doing is very innovative. They save them money. And I'm not talking about just saving them salaries. They know how to do things better and faster, leading to a better product that saves them money. And in turn, by saving the money, the company can hire a lot of other employees in different fields. And those are majority, obviously, American employees. So it can be a win-win approach when a lot of H-1Bs come in and innovate. And that's what it leads to. Again, I mentioned entrepreneurship as some folks leave and start their own businesses or move. But yeah, I mean, I think it's a positive. I know fear mongers out there will say, yeah, but Americans are losing jobs. I don't know about that. There's so many jobs out there that if an American did lose a job, let's say because they replaced the IT department at that person's company, well, they could easily find another job. Also, some of those workers, let's face it, are not that great. Okay, so these companies have old IT departments. They're not doing very well. They come in and innovate. You can see right now, like with the government, what they're doing. They're going into all these government agencies and they're cleaning out the pork. People who either don't come to work, they're lazy, they're getting rid of them. They want efficiency. So a lot of that happens when you utilize either a big IT subcontractor, or just, you're hiring H-1Bs in general.
Right. Thank you so much again for answering the question, Erin. We have started receiving a lot of questions from the viewers, which we are going to take in a bit. But before that, I would like to come back to President Trump, and I would like to ask you that, very recently, he changed his stance on H-1B visa. Earlier, he said it's very, very, very bad, if you remember. And then later, he said, he came in favor of it, and he supported the H-1B visa. What do you think? I mean, why do you think, that sudden change of stance happened? And, what do you think actually influenced that?
Okay, first of all, he never said he was against H-1B visas. In fact, I can remember during his first 4 years in office, he was very supportive of them and made statements to that effect. So if we go back in the record, I guarantee you I can find you that. If he said anything negative about it, he changes his mind. When he gets educated on a topic, he's the type of person that seems to listen to people and can change his mind. So if he did say something where he doesn't support look, he runs the Trump organization. They use H-1Bs. They probably use a lot of H-2Bs as well. What I've seen is that he's very supportive of H-1Bs. He realizes the value in them, the need for that labor force, the professional labor force as it is. So I question those people who say he was very negative on it. And if you can send me some links of stuff he said, I could probably find you. I know I can, because I remember I can send you other links where he said the exact opposite. So I wouldn't put too much stock in something in the past. And also, if you want to look at the past history of the 4 years where he was president, H-1Bs did not decline in any way. And in fact, the wait times were much less. So we're hoping to get back to less wait times, which is frustrating our whole firm and probably every other lawyer out there. It's become crazy how long you have to wait. Yeah, you can pay premium, but premium is now close to $3,000, which is crazy. It's a big expense, especially for small companies. So I think things will only get better. I wouldn't put any stock in fear mongering, which is what people like to do when it comes to Trump, just because for some reason they don't like him, and then they start making up things.
Again, thank you so much for answering the question, Erin. Let me quickly.
And I don't know where that very bad shift comes from. I'd like to see that in writing where it comes from, because I don't think that's what he said at all.
Okay, all right, but thank you so much again for answering the question, Erin. Maybe if I get it, so I'll also try to share that link with you if I get that, if I see that. But for now, let me quickly take the viewer's question. But you answered it very well. But again, I would like to take the viewers' questions, and because we have been getting many, so let me very quickly take Sahil's question for now. Sahil says, as an H1B visa holder with several years of experience in the US, I have begun to question the program's impact. Do you think the H1B program genuinely contributes to job creation and economic growth, or does it primarily create competition for American workers? And I think you already have answered this, but still, if you would like to take it and answer again.
I mean, in general, I think it's good. Again, I work with recruiters all day long, my clients. I work with HR departments, legal departments, recruiting departments. But when I get to talk to the recruiters and I can see what they're doing, it's just basic common sense. If you have an American worker and you have an H1B worker and they're both applying for a role, which has a salary band, sometimes has a salary band, obviously they can go from here to here. But my point is, why would the employer want to hire an H1B worker when you have an equally qualified American worker and take on thousands and thousands and thousands of dollars and time and a little bit of unknown? Things can get denied, when they can just take the American worker, is what I'm saying. So if anything, I don't think it hurts the American worker in dealing with recruiters all day and seeing how they recruit. And yes, in some cases, they're going to need the H1B employee because there simply aren't enough Americans who have applied, or, it's some kind of niche skill and this person has it and they just happen to need sponsorship. So no, I don't think the H1Bs damage the American IT workers. I think American IT workers are some of the best off, most well-paid workers that we have.
Right. And, you're not just an immigration attorney with that, you're also an H1B visa expert, right? And if it genuinely hurts, you would know, right? More than anybody, I think you would at least know. So
typically what happens is there's a case. There's a case, someone complains because he's an American, he feels he's been wronged by his company, he files a lawsuit, and then the issue is, well, I was replaced simply by someone else because I'm American and I'm not, and that's why they replaced me. That's usually not the case. Those are far and few. I remember years ago when I was working there, when I was the head of immigration at Infosys, I remember we dealt with a lot of these cases when we were contracted to come in and perform a lot of work for some of these big companies. So there are cases here and there, but if you break it down, it's not a lot of people who are complaining. And in a lot of cases, that person simply was there for many, many years and was basically not contributing, not innovating, not doing a good job. We have at-will employment in the United States. You can fire anyone for any reason. That's how our laws work. So, but those tend to make the headlines. Something like that, it's juicy. There's an element of racism in it, maybe. So those make the headlines. News reporters love to pick that up and make a whole story, and then that gets out, and people think that's happening everywhere. It's not.
Okay, so Sahil, I hope you have got your answer. Thank you for your question. And guys, if you have any more questions related to this topic that you'd like to know answer of, so what you can do is you can also give us a call on the number 425-436-6335, and you can also put the access code, which is 988888. Yes, you can ask your questions by also calling us. You can give us a call and ask your questions by dialing the number 425-436-6335. And don't forget to put the access code. The access code is 988888. Yes, and make sure to subscribe subscribe to the channel and also like the video and share the video with anyone you feel should know and watch this episode. And for now, let me quickly take RK's question. And RK says, do you think the problem with us immigration is the employers? H2A is uncapped, yet so many undocumented agriculture workers. Had the Bracero program employers abuse the workers? Okay, I think.
Is it talking about H2B?
Yeah.
I'm not familiar with H2A. To be honest with you, our firm doesn't handle, we don't handle H2B, we don't handle H2A. So I'm not really an expert on that. I don't know if I can give a comment on that. There are definitely a lot of undocumented agricultural workers here. Is there a need for them? Maybe. Do Americans, the old argument is, well, Americans don't want to do these jobs, so we need to bring them in from, South America and now from everywhere. I mean, if that's the argument, then you got to expand the H2B program or the H2A program, which I don't know much about. And if you do that, maybe you can bring a lot more people in legally and it would benefit everyone. It's a win-win. But Congress needs to do that. It's not something the president can do. H2B numbers, like H1B numbers, can only go up through an act of Congress. The president can't sign a presidential executive order and say, okay, we want more or less. This is set by Congress. That's why we have 80,000 right now.
Right. And, he goes on to say that layoff FYI show that between 2022 to 2024, 580K IT workers, 580,000 IT workers got laid off. Why does Congress not restrict level 1 and 2 H1B workers when mass layoffs? Keep level 3 and 4, they create jobs for H1B and USC. What do you have to say?
Well, Congress can do whatever it wants. If Congress comes together and passes a law that says you can only get H1B if you're a level 3 or level 4, that will become the law. So Congress can do that. The problem with Congress is they never will pass. They haven't, I don't know in how many years, they're never going to pass a comprehensive immigration bill, either because they don't want to, they like the status quo, both sides, or they just can't agree, obviously, both sides, or because these bills are filled with so many things that they get crazy. I remember, I think it was 2012 when the Gang of Eight, when they were going to pass, I did a lot of lobbying for my company in DC, and they were close to passing an immigration bill, but it didn't happen. And then if you do pass an immigration bill, you can make some changes. You can, like what he says, maybe let's get rid of level 1 and level 2 H1B workers and just keep it at level 3 and level 4. Okay, you can do that. I don't know what effect that would have on the IT industry because a lot of level 1 and level 2 workers are very vital. Some of them are students who finish their master's or their undergrad, and then they're working for a nice company, and they need that H1B to continue. They only have 3 years on their OPT and their STEM OPT. So who knows what the impact on that would be. I think they should create more numbers personally. We have 80,000 now. I think they should get back to like maybe 200,000 a year would be a solid number. That's just my opinion. I think judging by the cap numbers, we certainly need that, if not more. So those statistics don't lie, the number of applications.
Okay. So RK, I hope you have got your answer. In case you want to know more, continue posting your follow-ups, and you can also give us a call on the given number. And yes, but thank you so much again for answering the question, Erin. We still have a lot of other questions. Okay, Skywild Designs is here and says, hello, any news on H2B programs since it feels like employers are not proceeding with out-of-country recruitments? What do you have to say, Erin?
Again, I don't deal with the H2B program. I know about it. It can be very useful. It can employ a lot of good people who might not have an opportunity in their country or just want to come here and work and bring the money back to their family without necessarily moving the whole family here. It's a good program. They do a lot of jobs that we so-called may have a shortage in America on. For example, landscaping, hotel industry, agriculture, as you say, things like that. If Congress can look at expanding these programs, we could have a lot more opportunity for people who want to work. who maybe don't have the opportunity in their home country because it's a poor country or whatever.
Okay, looks like I have a slight technical problem, but I'm trying to resolve it. But meanwhile, let's go for a short break. So let's take a short break and come back quickly. And welcome back, everyone, to Immigration Talk Show. I'm Rivera, and I'm so sorry about that technical glitch that happened before the break. But now we are all sorted. And welcome back, Erin. I'm so sorry about it. And
No
we
problem.
had to take a short break, but now it's all good, and we can continue the show. And Erin, I would again like to move to the viewers' question. Because we had so many, and so I hope Designs you got your answer. Thank you so much for your question. And let me take Empire's question. Empire says, why do groups try to remove H4EAD? Why do they keep litigating in the courts to have it removed? As well, it was on the regulator agenda in the past by the Trump administration to remove it. Why? What do you have to say?
Well, in the past, L2s and H4s were not allowed to work for many years. When I started working as an immigration lawyer, there was no work option for an L2 or an H4. And then they changed that because they figured, the spouses come here for long periods of time and are very hamstrung and handcuffed. They can't do anything. So they changed it. And then L2s could work. And then for the H4s, as you know, they could work as well if the spouse if the H1B had an approved I-140. So it's a little bit different than the L2. There's just groups now in that situation, you can make a stronger argument because an H4 can work anywhere for anyone in any position, that could impact American workers. If you think about it, it could be any job. So there are a lot of groups out there, lobby groups and whatnot, who don't want the H4s working. And they could make an argument that it does affect the American worker, as I said, because it can be in any industry at any level. So theoretically, you could just simply be taking a job. As opposed to my argument with the H1Bs, where we have an industry that we really don't have enough people in our own country. So it's a little bit of a different argument, and that's why it's constantly being challenged by groups and in the courts.
Okay. Empire, I hope you have got your answer. If you have a follow-up, please continue posting your follow-up. Meanwhile, let me come back to my questions and let me ask, the question that I prepared for you, Erin. So, Erin, recently, the new H1B visa reforms, starting January 17th, it was said that these reforms are aimed to improve fairness, right? So, what do you think? What are the most significant changes that workers and employers should know about?
I think you're referring to reforms about the lottery program. A lot of what you mentioned, a lot of what's in that January 17th has to do with cleaning up the CAP registration program so there's less fraud. That was a big part of it. There was a little bit about CAP exempt employers. As you know, if you're an employer that's not a regular employer, let's say you're like a government institution or sometimes educational entities, sometimes nonprofits, they can get H1Bs year round, so they're not subject to the cap. There was something about, making that a little bit friendlier. Otherwise, then something about how they define the specialty occupation itself, maybe when they're going to look at petitions. That could make adjudications a little bit easier for H1B. Right now, I don't see much of a problem in the H1B field. We file, I can't even tell you how many H1Bs we do every day. But so we see responses, we see the levels of RFEs, we can get pretty good statistics even internally. And right now, H1Bs do not seem to be issuing a lot of needless RFEs like they have in the past. I remember about maybe, I think 5 years ago, we just saw, it comes in waves. So there's got to be some internal directives. We all of a sudden be quiet, and then every other H1B was getting RFE'd with the same RFE. So no method to the madness. But right now, I think it's pretty good. We file H1Bs. The wait times are a little bit annoying, but we're not seeing too many RFEs, what we call the boilerplate RFE, where you get a 10-page RFE, and then you can see they haven't even looked at it, and they just print it out and send it to you. In addition, I can see lately that with H1Bs and some other categories, they're getting a little bit better with their RFEs. I think that's internally they've been instructed to do a little bit more on asking for very specific things. So maybe you'll get a shorter RFE, but it's looking for something very specific. We're seeing a lot of that trending lately. That's good because they can focus on something that actually is a legitimate issue, and you don't have to send them a response to 10 pages of nonsense when you've already provided everything there. So, yeah, I hope that answered the question adequately.
Right. It does. Thank you so much for answering the question, Erin. Erin, with that, I would also like to know from you about, with India providing the majority number of H1B visa holders, right? So, how do you think these recent policy changes are specifically going to impact Indian tech professionals?
Well, anything that's done in the H1B program will impact any H1Bs. It doesn't matter if they're an IT professional from India or a chef from China or an accountant from Brazil. It doesn't matter. Whatever they implement, it affects them across the board. So there's no specific cutout for, let's go target. They can't do that. They can target the H1B program. They can make some changes, maybe some beneficial, maybe some negative changes. But yeah, so to answer your question, Indians specifically will not be hurt any more than anyone else who has an H1B.
Okay.
Indians and Chinese do make up the vast majority of H1B users. That is true. Sometimes they get a bad rap for it because when people are criticizing H1Bs, in a sense, they could be criticizing Indians because Indians use the most, let's say. And it's just it's an unfair criticism. I work with Indians. As you know, I was the head of immigration for Infosys for over 5 years. I've been to India a lot. I live in an Indian community in Texas. 80% of my neighbors are Indian. This happens to be an Indian community. I can tell you the Indian population is the type of immigrants we want here. I can tell you the crime rate for Indians is almost zero. There might be a little bit here and there. Very good students, very good parents. They want their kids to get a good education. these are the role models for the types of immigrants and H-1B workers we want in the country. So maybe sometimes Indians get a bad rap because they're using the H-1B so much, but at the end of the day, these are the types of new Americans that you want here eventually.
Right. Okay. Thank you so much again for answering the question, Erin. Let me quickly take Empire's question again. Empire is back with his question. He says, if the 580K layoff is okay, I think we already have taken this. Maybe let's take Yuri's question. Yuri says, I'm on vacation in India and was laid off effective Feb 1st, 2025 with a half-month severance. I'm on H1B exempt visa since June 2023 with stamping valid until June 2026. My return flight is on February 17th. What are my options for safe re-entry into the US?
Well, if you're no longer employed by the company on your H-1B visa, you should not enter with that visa unless you have a new H-1B approval for a new employer. And then you could use the visa plus the new H-1B to enter. But if not, technically, you shouldn't make an entry back into the US on that H-1B visa because you're not working for them. You're not on their payroll. You're separated from the company. So that technically would be illegal.
Okay. So Yuri, I hope you have got your answer. In case you have a follow-up, continue posting it in the comments below. And
if Yuri can enter on a B visa, he could come in and look for jobs while he's here. Obviously, he's not working. And then if somebody wanted to hire him, he could change status from B to H-1B while he's in the US. He could do that.
Okay. Okay, Yuri, I hope you have got your answer. And let me quickly take Amarjeet's question also. So he says, my wife is on H4 here in New Jersey and also have Canada open work permit. She's planning to visit Canada as a tourist. Is it allowed on open work permit or need to apply visitor visa? What do you have to say to Amarjeet?
To enter Canada? Okay, so I'm not a Canadian immigration lawyer. I have colleagues who do rest of the world. I do US only. But an H4 can travel to Canada. I believe Indians have to get a visa to get to Canada. Oh, she said you have a Canada open work permit. So the H4 could enter Canada legally. She's planning to visit as a tourist. Okay. Yeah, I'm not familiar with what Indians need to travel to Canada. If I recall correctly, they need a Canadian tourist visa to enter as an Indian, I think. So in that case, yeah, you can't use visas and be deceptive about your entry. So if you're coming in for one purpose and not to work as a tourist, you shouldn't be using your Canadian open work permit. Same thing goes for the US.
Okay. Okay. So Amarjeet, I hope you have got your answer.
I get the Canadian visa. Yes.
Okay, but guys, Erin is not just an immigration attorney, but also an H1B visa expert. So if you want to get a detailed consultation with Erin, and if you have any case regarding H1B, you can directly get in touch with him and contact him on his number 469-459-1771. I would like to repeat the number 469-459-1771. You can also email him. His email ID is erin@eeglawgroup.com. Yes, you can also email him and also visit his website, which is www.eeglawgroup.com. So make sure to get in touch with him for a detailed consultation regarding your H1B cases or any immigration case that you are looking to looking for help or looking for a consultation. But for now, let me quickly take Rag's question also. Erin, Rag is here and he actually wants to know, okay, we have also, we have people posting on Facebook groups, questions related to H1B, which we would like to take, but I think we will take them in a bit. But right now we have another viewer, Rag, and it's not related to H1B, but he wants to have your guidance on L1A. So if you have anything for him.
L1A, in order to qualify for an L1A, you have to work for a company outside the U.S. that's related to the future U.S. employer. It can be a parent, subsidiary, they're affiliated companies owned by another company. There has to be a relationship. You have to work there for at least a year. And to qualify for the L1A, you have to be a manager or an executive. So if you're a manager abroad or an executive abroad and you're coming into the U.S. to fulfill a manager or executive role, then that's the most straightforward way to do an L1A. You can also do a hybrid L1A where you're a specialized knowledge person abroad and you're coming in, or vice versa. But most L1As, they're a manager in their current job, they're coming to be a manager in the U.S., and they've worked outside for at least a year. And those are the best cases for the L1A visa. There's no cap on the L1A. The L2 spouse can work right away as soon as you enter. You don't even need an EAD card anymore. So the L1 is a good tool or mechanism for companies who need to move their workers to the U.S. And yes, if I'm an expert, if there's one thing I'm more of an expert on than H1Bs, it's L1s. So those two are pretty much my bread and butter. I've been doing that for over 20, I don't know how many years, but yeah, solid visa. Your company will obviously have to sponsor you just like an H1B. But if you want to reach out to me, a lot of our clients are companies. Most of our clients are companies, and they do a plethora of L1s or H1Bs.
Great. So maybe Rag, you can directly get in touch with Erin. You have the details right on screen. You can note down his phone number, his email, and you can also visit his website.
Oh, one thing about L1s, I get people calling me a lot, and they're like, "Well, I don't have a company." We're a law firm, so if you have a company that you're employed with and they're thinking about moving you, yes, call me. I can speak to your company. We can explain how it works. I can talk to you. That's great. But if you're just asking about L1s, the first thing you need to do before you come to me is have a company that you work for. Same thing with an H1B. Have a company that's going to sponsor you. So once you get that company, then yes, I can talk to you and answer your questions, and we can move from there and facilitate how we're going to do an H1, an L1, whatever the work visa is.
Okay, so he's back and he says, thanks, Erin. What are the latest trends for L1A?
Trends, they've been pretty consistent over the past 8 to 10 years. The trending L1As have gotten much harder over the last 8 to 10 years. When we used to do them 20 years ago, it was very simple, very small application. You just put an org chart and you didn't need much more. But now, even an L1A, which, as I mentioned, you just need to be a manager overseeing professionals. Our applications are like this. I mean, because there's been a big shift into attacking these. So we don't just put org charts in. We want to show them that you're overseeing people. We want emails. We want resumes of the professionals you oversee. We want examples of you calling a meeting, making a decision. Maybe you have budgetary authority. So there's no right or wrong, but when we do an L1A, the support letter can be 18 to 25 pages, if you can believe it. Whereas years ago, it was 2 to 3 pages. So they've come a long way with L1As and L1Bs in terms of making you prove it, really. That's the big trend over the last 8 to 10, maybe 15 years, I'd say.
Okay, great. So thank you so much again, Rag, for posting your questions. If you have more, continue posting them. We will try to take as many as we can. Okay, so I think Skywell is again here, and Skywell says, thank you for answering that. I would like to know if you need a petitioner to acquire the H1B, and does it only get tied to Silicon Valley companies only? What do you have to say, Erin?
Number one, you do need a petitioner, but it doesn't have to be an IT company or a Silicon Valley company. I'm doing a H1B for a construction company that needs a project manager, for example. I have another client that's a social working group in New York. They're like social workers, and they're hiring an H1B. As long as the job requires a 4-year degree. So if you say, well, I want this restaurant to hire me as a waiter, that's not going to work for an H1B degree. I can tell you I've done an H1B for an executive chef years ago, which was a tough one because a lot of chefs at that level traditionally don't require a 4-year degree. So we really had to prove that this role did. Not easy. But most occupations that require a 4-year degree, it can be in IT, and it can be in accounting, it can be in construction, it can be really anything. As long as the role is it's a specialty occupation requiring a 4-year degree within the industry and within the company generally. And you can show that, then you can go ahead and pursue the H1B category.
Okay, so Skywell, I hope you got your answer. Thank you so much for your question. If you have another follow-up, please continue posting it. And Rag says, thanks, Erin and Rajni. You're most welcome, Rag. And make sure, I'm sure you must have already by now, but if you're not, please make sure that you subscribe to the channel, and all of our viewers, please make sure that you subscribe to the channel, like the video, and if you think your friends who needs to know the information about H1B, please do share this episode with them. And let me take Miss K's question. And Miss K says, why would the birthright citizenship EO include work visa and students? Administration asks individuals to do it right away, but I think the executive order would punish H1B workers. Why would the administration do that? Also, why the uptick in 221G at the embassy? What do you have to, I mean, it's not related to H1B. So, I mean, if only you would like to answer,
first,
Erin.
No, I can answer the first question. The reason why they put out that executive order is because they want this issue to finally go to the Supreme Court. It's not because they want to hurt H1Bs, people here legally. They want the Supreme Court to decide who should benefit for birthright citizenship. As you know, there's not many countries in the world that have blanket full birthright citizenship that we do. So it's a very novel idea. When it was introduced in the States, the purpose of it was to give freed slaves and their children citizenship at the time, and it served a useful purpose. Since then, there hasn't been much debate about it. It's just always been the law, and it's been abused. I can tell you, they've busted Chinese and other rings where they would bring in these rich folks, rich Chinese people. They put them in a very fancy hotel just to have their babies, so the kids could one day, the kids would be citizens and they could come back and then they would go back to China, for example. They busted a lot of those rings up. So me personally, I feel yes, the Supreme Court should take a look at this and decide. And the reason why they worded the executive order that way is because they knew the next day it would be challenged.
Mm-hmm.
Okay, they knew that nothing was going to change, and then it will be appealed until it gets to the Supreme Court. The Supreme Court will eventually have to decide this case. My personal opinion, I think H1Bs and L1s and people who come legally should definitely maintain the birthright citizenship. I think that's a good idea. On the other, I don't think anyone who comes illegally should benefit from birthright citizenship. I just think it's just a tool, a wrongful reward for people breaking the law. I don't believe that. Now you might ask, well, what about tourists? Someone who's here not too long, like a B. That's a little bit of a gray area. I'm not sure about that. There's a lot of tourists that come in. There's more Bs that come in than any other category. So do we want to maintain the birthright citizen? That's something that's an interesting question that should be decided. There's a lot of people who feel that birthright citizenship was for a specific purpose and not for the way it's been used for hundreds of years. So we'll see. But to answer your question, Trump wasn't attacking birthright citizenships for Ls or H1Bs or people here legally. Mm-hmm. He just knows that it's going to be attacked, so he wants to get the issue out there, and then they want to debate it and have a final decision eventually about it.
Right.
What was the second question?
Also, why the uptick in 221G at the embassy?
I don't know if I can report an uptick. I have a lot of L blankets all over the world. I have a lot of you can imagine the amount of people processing. I don't report an uptick, but if you see an uptick, I don't know. I don't think there's an uptick. I just think, different embassies are harder than other embassies. For example, I do a lot of E2s. This is a little bit off topic, but E2s India doesn't have an E2 treaty, but E1s and E2s are per treaty, and most countries have them. I can tell you For example, E2s in Canada or other countries are pretty straightforward, whereas if you try to get one in Tokyo, it can be very hard and they're very strict. So, different consulates have different people working there and different protocols and different ways in which they decide cases, and probably the same thing for 221G. I don't know if there's an uptick now. I haven't seen anything about it.
Okay. Thank you so much for answering the question, Erin and Ms. K. I hope you have got your answer to both your questions. And if you have any more, you can continue posting your follow-ups. Even if the show is over, we will try to, share your question with Erin. We'll try to get an answer from him. But thank you for asking your question. And now, Erin, I would like to move to the Facebook questions that are posted by the people and the viewers in the Facebook group. So, Control, please, if you can share the screen. And yes. So one of the viewer has said, hello, my H1B extension was approved on January 23rd at the Texas Center. So when can I expect the approval notice?
Yeah. So unfortunately, it can take, we're seeing anything. This is something that has trended downwards. It can take at least a week, 2 weeks before you'll get the approval notice. I assume you looked online based on your receipt notice, or was a premium case and you haven't received the approval yet. Either way, yeah, they can take time. I'm going to say anywhere between 7 to 13 days from when you can see that it was approved. You should have your receipt notices. That's what we're running right now, approximately.
Okay. Let's move to our next question. So the next question that we have is from this anonymous member who says, what is the current processing time for H1B approval notice to be released for master's court?
So if you're talking about the master's cap lottery, that is done on the same day as the regular lottery or the day after. They used to do that one first. They used to do that one second. Now I believe they're doing that one second. Yes, to give the Masters people a better chance of winning the lottery. They switched that about 2 years ago. I'm not sure the processing time. Processing, you mean just to get an approval notice after being approved, like the last question? It would be the same answer. I don't. This is kind of a vague question.
Okay. Maybe let's move on to our next question. So because not much details are there in this question, so let's move to our next question. So this anonymous member says, hi all, my H1B transfer has just been submitted to USCIS, but my wife and my son have to travel on family emergency to India. Is it okay for dependents to travel while petition is filed with USCIS?
Yeah, so H1B transfer, also known as an H1B portability, is when a worker finds a new employer who files an H1B and they call it an H1B transfer. Everyone should know that if you wanted to, you could start working when the case is filed for H1B transfers. You don't have to wait for the approval notice, which is great. Although a lot of employees, they want to wait until the approval is in hand before they jump ship, just to make sure, give them some peace of mind. The question is, yes. So the I-539 H4 for the wife and son were filed together with the H1B, and now you need to travel. Well, look, if you have a visa that's still valid and you can travel back in, then I would say you could travel. You're going to need that visa anyway, because you're not coming back without a valid H4 visa. Sometimes what will happen is when that's filed, they will notice that the person has left the country and they may cancel the I-539 application. It's possible. So just be wary of that. But if you have to go and you have an H4 visa to return, you can certainly do that. And in most cases, you should be okay.
Okay. Thank you so much again for answering the question, Erin. I know it's 5 o'clock, but we have completed an hour. But if you have like few more minutes, I would like to take maybe 2-3 more questions. If you're like.
Yeah, sure. I have time. That's fine.
So much. Thank
Go
you
ahead.
So much.
Yeah.
Okay, let's move on to our next question. So the next question that we have is Control, can we please move to, okay. Anonymous member says, hello, I just came to United States on H1B in the end of December. It was finalized that employer will pay me 180,000 annually. Now he's saying to pay 150,000 USD per annum. So there will be change in petition. Is it an issue or is it normal? Please advise.
Normally, H1B employers don't lower the salary, but they certainly have the right to. But before they pay you the lower salary, they must submit what's called an H1B amendment, which tells the government that we're paying less than what we stated on the original H1B. So it looks like here they're going to file a new petition with an H1B amendment, and then they will be able to change the terms of the H1B that you're currently under. If they don't file an H1B amendment, then you're entitled to the 180,000, which should be noted on the I-129 and in the support letter, and they must pay you that. They cannot pay you less unless they file an H1B amendment.
Okay. Okay, thank you again for taking that up. Let's quickly move to our next question. So the next question that we have says, hi everyone, sorry, this is not related to H1B. Last night I had an accident. The person in front stopped in the middle of the road. My insurance expired recently and yet to renew it. Her insurance company called me today and said the blame is on me for everything, but I can dispute it. Please, what should I do, and will it affect my green card application? How can I get a lawyer? Thank you for your help and suggestions. What do you have to say, Erin, to this person?
It won't affect your green card application. This was an accident in the road. Everybody thinks the other person is at fault. If you have an insurance company, you should have an insurance company, car insurance company they're using. I would speak to them and explain to them the situation and see what they say, because they're supposed to represent you in this situation. And then based on whatever their suggestion or their guidance is, you may get a lawyer or not. But I think if you talk to your insurance company, they will tell you what to do. If you don't have insurance, then I would hire a lawyer. You can go online and there's a million lawyers who do personal injury. This is what this is. Just put your city, put personal injury lawyer, and you'll have 100 coming up. And you can call them. Yeah, that's what I would do.
Okay. I think now let's quickly move to our next question. Okay, this is from Yogeshwara, and Yogeshwara says, visa process for family. Hello, I'm currently on H1B and wife is on H4. We are planning to start the visa process for my parents, sister, and brother-in-law. I have a few questions on the process. Can they, mother, father, sister, and brother-in-law, go for the visa interview together or separately? Let's take one by one. What do you have to say about this?
Okay, first of all, you have an H1B, your wife has an H4. Your mother, your father, your sister, and brother-in-law are not entitled to any H category visa. So maybe he's referring to them coming to visit on a B visa. That happens a lot. Indians in the U.S. like to bring their parents here, and they come. Sometimes they'll come for up to 6 months at a time. So if you're doing that and they're going to get B visa interviews to visit you, that's perfectly fine. Your mother and father could technically go at the same time. Remember, each person needs to fill out their own DS-160 online and schedule an interview. So I think the mother and father can go together, and the brother-in-law and sister would go together separately, but together. The process for a B visa is the same, whether they're a parent or a brother or a friend who wants to visit you. And what are the documents needed? Well, for the B visa, you want to show that you have ties to, I assume you're from India, you want to show you have ties to the home country. So, maybe you get a letter from your employer. If you have an employer, your last pay statements, bring a bank statement. If you're renting an apartment, bring your last few rental payments, even the contract, the lease of your apartment. If you own a home that you live in, you can bring that. I've counseled clients sometimes to bring a gym membership to show that that's still active. There's a lot of stuff you can bring, but those are the most popular ones. and you have to convince the officer that you're going to the U.S., but you have a life to return to, and that you're not just going to stay in the U.S. forever and ignore your I-94. So, yes, I think he means getting a B. So I answered it in that context.
Okay. All right. Let's move to our next question. I hope Yogeshwara, he got all his answers. Let's quickly move to our next question. So next question says, me and my wife have upcoming travel to India for stamping. We have booked our tickets, but lately we are feeling very anxious to travel, fearing what would happen if 221G is issued, which may take weeks to months to resolve. Having said that, I'm reaching out to understand your experience. If you or your friends have traveled to India or stamping in last 2 weeks, how, they are talking about this anxiety. They want to know how people are dealing with it. How are you dealing with this anxiety if you are planning to visit for stamping in coming weeks? There is a lot on stake here with the kids' school and mortgage in US, and hence want to understand how is everyone. Okay, so this is more about, I think they just want to hear from other people, but as an immigration attorney and an H1B visa expert, what would you like to say? I mean, what would you like to tell this person?
So the first thing is when you're going abroad to get your new visa, plan ahead. You obviously want to have the appointment already scheduled while you're in the U.S. and usually schedule it for the beginning of your trip abroad, not the end. So you can have your interview at the beginning, and then you'll get your passport back, and everything will be smooth, and then you can enjoy the rest of your trip. In some categories, you can use the Dropbox. So if you've already had that visa already before, you may be entitled to use the Dropbox where you don't need an interview. Nevertheless, my advice to anyone is if you're traveling abroad and you're going to need a visa to come back and get the stamping, when you're in the U.S. a few months before, secure your interview date already, do your DS-160 and secure your interview date from here, have it all set up, and then plan your trip around that date. That would give you the least amount of anxiety because at least you have it early. Maybe there's a week or two delay. You're still good because you're there for 2 or 3 weeks, but try not to schedule your appointment towards the end of your vacation or your trip because, you got to get your passport back. And sometimes there are delays and they're out of your control.
Right.
I mean, that's the best advice I can offer.
Miss K also has an advice to offer to this person, and Miss K says, I don't think the child should be punished for the actions of their parents, but should remove the ability to sponsor that parent for a green card. Let's see. Well, I don't know. But let's move to another question, maybe. If we are left with any, so
That had to do with, I think that was from birthright citizenship, but go ahead.
okay, I think that's it. For the questions from Facebook, but we still have one question which is not related to H1B. Erin, this RK actually has asked this question, and only if you want to answer this. RK says, don't you think the federal government has jurisdiction over undocumented immigrants, given that they can arrest and detain them for deportation?
Yes, I do. The federal government has jurisdiction over them. If they're here breaking the law, they can certainly arrest them. Coming in illegally is breaking the law. So you can arrest somebody for that if you're here illegally. I just came from the Bahamas 2 days ago, and I went through customs. In this case, it was in the Bahamas. It was pre-clearance. But can you imagine if I just ran through there? What would happen to me? And I'm an American. I would be tackled, number one. I would be held in secondary. I probably would be arrested, just for starters. I don't know when I would get into the U.S., I don't know what would happen, but yeah. So obviously the federal government is charged with overseeing our immigration laws, not the states, the federal government. And they have the power to arrest and to make the laws, obviously, to enforce the laws or not enforce the laws, as we've seen. So yeah, that's a pretty basic question.
Okay, I think that's it. Thank you so much to all the viewers for asking these amazing questions. And thank you so much, Erin, for answering all these questions in so much detail. And we really, really loved your insightful answers. And, honestly, I would love for you to come back for another episode. And guys, if you want to get in touch with Erin for a detailed consultation, make sure you give him a call on the number 469-459-1771. I would like to repeat the number 469-459-1771. You can also email him. His email ID is erin@eeglawgroup.com. You can also visit his website, which is www.eeglawgroup.com. So make sure you get in touch with him and his team. And thank you so much, Erin, for being here. Really, really, a great episode. And I really would love for you to come back. So I'll get in touch with you. I'll share an email maybe whenever you are available. So we can do another episode on H1B or maybe L1A, right? So
yeah, we could do L1As for an hour. There's a lot to talk about there. If you have a lot of L1 folks and listeners, that could be a good one. Green cards are always interesting. So thank you for having me. I love talking to you, Regina. You're a great host. You're very smooth. I think I should see you on the TV here soon. If you're going to go into journalism, you'd be good. You could ask some great questions. So, but yeah, thank you. Yeah, I look forward to any time. I like talking.
Thank you so much, Erin, for your kind words. Really hoping to see you very soon, and we'll decide on the topic. I'm going to frame a topic and share it with you. But for now, thank you so much for being here. And guys, thank you so much for your questions and for joining the session. We'll see you again very, very soon. We have another show coming up, Daily Immigration Dose. So make that you are tuned in on that. But for now, I'll have to take your leave. Make sure that you like this video, share this video, and also subscribe to Immigration Talk Show. I'm Rajni Bharara signing off for now. Take care and bye.
Hello, everyone, and welcome to Immigration Talk Show. I'm Napasa, your host for today, and I'm happy to be back. So, welcome once again, friends. We have got a very interesting webinar lined up, and before I introduce you to our guest for today, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. With that said, friends, today we are going to have a very familiar face who has been a part of Immigration Talk Show for quite some time now. And he is an immigration attorney from Dallas, Texas, from SPB Law Firm. So without further ado, help me welcome attorney Chand Parvathaneni. Hi, Chand. How are you doing today?
Hello, Nipasa. How are you? Pretty good. And thank you for inviting me again on this show. Hopefully, we'll have a very good discussion today about some of the current topics on the immigration side as it pertains to the employment-based immigration.
Absolutely. And it's the H1B season, so nothing better than our topic of discussion for today. Yes, friends, today we're going to discuss about H1B RFEs on the rise this year, 2025, and what it means for the March lottery. And of course, Chand is going to be here to answer to all of our questions, mine, yours, and you can participate in this webinar by commenting. So wherever you're watching us, you can put your questions in the comment or even join us on call, actually. You can call us on this number, 425-436-6335, and the access code is 988-888. There is 8 5 times, so 988-888. Join us and it'll be very nice. So Chand, what can folks out there expect from today's discussion on this topic today?
Sure. So we have a new administration since January, and a lot of things are changing because, again, anytime a new administration comes into office, because they do things a little bit differently. And right now, the Trump administration, they're kind of refining all the processes, not just in immigration, but across all the federal agencies. And what that means is we will see things a little bit different. And on top of it, the Biden administration, while they were leaving office in December, what they have done is they have changed some regulations. They came up with strengthening and modernizing H1B regulations, and they came out with a final publication of a rule where things from January 18th, they got changed a little bit. So now we have these new regulations that the previous administration finalized that started in January. And then on top of it, we have a new administration where they're revamping and re-looking at their own processes. And what that means is we are seeing different kind of RFEs. We have started seeing new RFEs, new ways of USCIS adjudicating things. And on top of it, based on the current administration's priorities, we know that a few things will change. And we will use this opportunity to see today, discuss what is changing, what are the new kinds of trends we are seeing in terms of new requests for evidences for H1Bs. And since the new H1B lottery will start in about a few days, it's starting on March 7th. So we're just a few days away from March 7th. So we'll also talk about what people can expect once the lottery starts, and once the lottery is over, what they can expect, and how we can do things to make sure we are in compliance with the rules and regulations of USCIS. We are in compliance with the requirements, and people do things the right way. And by doing things efficiently, they can at least try to aim for an approval, because this process is pretty expensive. The whole application for H1B, the employers have to spend a lot of money. They have to pay a lot of money to the government. And on top of it, the employers also have a burden of ensuring that they comply with a lot of federal regulations.
Right. And so, friends, thank you so much for joining us once again. You can follow us and don't forget to hit the bell icon. We are on YouTube and our handle is at Immigration Talk Show. So, yes, subscribe to us at Immigration Talk Show. Also, check us out on Facebook, LinkedIn, Instagram, and also on X. All right, so now let's not wait any further. So, my first question to you, Chand, is that there are so many reports out there saying and speaking about the increase in RFEs for H1B petitions, especially this year. So, what do you think are the main reasons behind this trend?
Sure. So in the last 1 month, we definitely saw a little bit of uptick in increase in RFEs. I would not say that we are drastically seeing a huge increase, but I definitely can say that at least for the H1B petitions, we are seeing new kind of RFEs, and we are seeing a little bit increase in the number of RFEs. And I think the primary reason for that is definitely the new H1B rules that came into effect in January. So this stemmed from the final rule where they published these regulations, uh, stating that they're strengthening and modernizing the H1B regulations. And a part of these rules, what they've done is they're focusing more on the bona fide nature of the job. So in terms of focus on added focus on that, nowadays they're requesting for contracts. Now you have to show the contracts, you have to show the purchase orders, you have to show the content of the purchase orders, and client letters, vendor letters. So this new requirement, I think, is causing USCIS to issue new kind of RFPs. So they're coming back and saying that the old memo, the memo that got issued in 2020, so in the RFPs they're stating that this memo has been rescinded, and now they are asking for some additional evidences. So that is where we are seeing some increase in RFPs. And then we're also seeing increased RFPs for proof of maintenance of status. So if a company has applied for a H1B in the past, and that same employee is getting filed for an extension, one of the things that USCIS will see is whether that employee has been maintaining his prior status. So there is a lot of focus on USCIS's side, where they're actually looking and asking us to prove that the previous petition, the employee has followed the terms of that petition. And what that means is, if it's a transfer, the employee has to work with the previous employer. He has to have pay statements. He has to be in that particular role. Or if amendments are required, amendments have to be filed timely, and so on. So USCIS has been definitely scrutinizing what employee has done in the past. So before applying, So the previous H1B petition, has the employee been working as required, and so on. So we are actually seeing a lot of scrutiny on that. And the reason for that is this new rule, the regulations that went into effect in January, they actually talk about ensuring that the employee has maintained his prior status. So that's also is contributing to this trend. And on top of that, the new administrations, because of the new administration's way of looking at things. So again, they are looking at employer-employee relationship in a different manner. They're looking at wage level discrepancies in a different manner. If it's a wage level one, so we're seeing an uptick in RFEs where USCIS is questioning the wage levels. And in general, because USCIS, as they kind of look at their own data, they want to prevent fraud. So there are increased fraud prevention measures, and a part of that, what USCIS does is they have something called Vibe Check, Validation Instrument for Business Enterprises. So it's their database where they cross-reference employers' information. They look at their data. They look at the data that's coming out in the I-129. They want to make sure employer is legitimate, the number of employees, the revenue of the company, and so on. So they have their own internal database, a Vibe database. So they check against that database. So as a part of increased fraud prevention, we are seeing RFEs which specifically talk about Vibe, where they say that things don't match up, things don't line up. So they ask for more information. And so this is another reason why we are seeing a little bit more uptick in the number of RFEs. And then overall, I think I would say this whole H1B modernization rule and the codification that went into effect in January. The USS officers, they're also having to look at this new modernization rule and look at things in a different manner. So initially, what that means is because even the officers are new to this rule, so sometimes the likelihood of RFEs increases, which I think is what has happened. And all these factors have contributed to the rise in RFEs in the last 1-2 months.
Exactly, and I think it was 17th of January, right? Many things, many new updates started, and these new rules also apply. And the lottery is going to start up in about just a week or so. So there's a lot of
Yep.
changes and things that you have to keep in mind. So maybe you could give out a few tips, Chand, for folks out there who are going to participate in the lottery.
Sure. So again, the good thing about the lottery this year is it is beneficiary centric, and what that means is 2-3 years back, we had a lot of issues with multiple registrations, and multiple registrations means some companies are colluding together because the companies are owned by the same set of individuals or their relatives, and the companies are colluding together, and they're trying to increase the chances of somebody in the lottery. So that was giving some people unfair advantage. And what USCIS has done is they went back and forth. They changed the rules last year. So now it's a beneficiary centric process. And a beneficiary centric process means even if an employee has multiple legitimate job offers, say Microsoft is filing for him, Google is filing for him, Apple is filing for him, whether a person has one job offer, has multiple job offers, the chances are exactly the same. So this is a good thing. So what that means is no matter how many job offers somebody has, the chances of getting selected in the lottery is exactly the same. And what that means is it will definitely prevent fraud. It will definitely prevent collusion. So that's a good rule that went into effect last year. And after that rule went into effect last year, the number of registrations dropped dramatically. So they almost came down 50%. That's what happened last year. So that's a good thing for all the folks out there who are getting the registrations ready by their employers, because nobody's going to get any unfair advantage. So everybody is on the same level field, which is a good thing. The only drawback this year is the registration fee. Last year, the employers were paying $10. This year, the employers have to pay $215. So that's a big hit. So employers will have to pay a lot more for the registration this year. In a way, that's really bad because some employers might be discouraged even if they have a good employee, because if the employee does not get picked up in the lottery, the employer will not get that money refunded. So the money is gone. So whether somebody gets selected in the lottery or not, that $215 that they have to pay to USCIS is gone. So for that reason, some employers might not really be willing to spend that money unless they know, hey, my employee is going to get selected in the lottery, and it's a good use of money. So for that reason, I do think that the number of registrations might come down. But the other side, the positive side is that anybody who's just trying to register just because it is cheap, they will not register. So at least the good thing about $215 registration fee is only if the employer is really serious, they know that the employee is highly qualified, they would not get them into the lottery. So there are positives and negatives about this new $215 rule. But in reality, what I think would happen is you will definitely see a decrease in the number of registrations. Last year, because of the new rule, we already saw the decrease in registrations. But last year, I think it was a good rule because it eliminated the multiple registrations problem. This year, we have to wait and watch. But one thing I can say based on my discussions with our clients is this year clients are going to, I mean, the employers are going to file only if they're really serious of that employee, because it's an expensive process this year compared to the $10 they were paying last year. And in terms of suggestion, employers, I think, should file only if they have a bona fide job offer. If they don't have a bona fide job offer, they should not be getting into the lottery because it's an expensive process. And not only that, they're going to waste somebody else's slot. Number one. Number two, people have to make sure they have a valid passport. And not only that, they have to make sure they're entering the right passport, the right information. If there are any typographical mistakes like date of birth or passport number or anything, tomorrow USCIS could come back and cause a problem when you finally apply for the H1B. For this reason, people have to be very, very careful when they are doing the registration. Make sure the data is accurate, the passport number is accurate, the names are accurate. And if somebody's passport is not valid, has expired, or about to expire, make sure that you apply for a passport renewal right away, because for a lot of countries, there are ways to expedite passport. So people can, if somebody's passport is expiring, there are ways where somebody can quickly get a passport. Like, for example, in India, there is Tatkal. So people can get a passport in about a week. So anybody whose passport has already expired or is about to expire, it's a good time, well ahead of the lottery deadline, they should go ahead and get their passports renewed. And one final advice is there is something called master's quota and regular quota when they apply for H1B registration. People have to be cautious. And if somebody marks it inaccurately, they make a mistake and they put somebody's quota as master's quota when they don't qualify for master's quota, that H1B registration will be invalidated. So always make sure that if somebody is getting put in the master's quota, verify the name of the university, make sure the graduation date, and so on, before putting somebody in the master's quota. Okay. So again, the registration part is pretty simple. Again, if things are, the data is accurately input, it's a very simple process. And before March 31st, the lottery selection will be done. And then the actual filings will start.
Very, yes, thank you so much for those wonderful tips, Chand. And I'm sure that folks out there are liking all these tips, since, H1B lottery is really knocking at the door. It's almost the season now. And talking about the fees, $215, it's a huge hike, 200% almost or more. So, what do you think is going to happen with the money, that US is going to accumulate with this? The registration process.
Sure. So USCIS is a self-funded agency, and what that means is they're not really relying on the government for the funds. They are self-funded. So basically, they generate their own revenue and they use it for immigration purposes. So what that means is, again, the money is not going into private hands. It's going back to USCIS. So hopefully that money is required to be spent for USCIS purposes. And what that means is they use it for hiring, they use it for making the processes more faster, more efficient, and so on. So normally when we hear about any government shutdowns, typically USCIS is not impacted because they have money. So the $200, it's a huge money, and hopefully USCIS will use that money to refine their processes and make things a lot more smoother for others. But again, even if they get 200,000 applications, which I think they will definitely get this year, because last year they got 400,000 registrations. So 400,000 registrations at $10 for each registration, that's equal to about $4 million. This year, $215 times the number of registrations. So it'll be a couple of millions of dollars. It's a huge amount that USCIS will be getting. But hopefully that money is being spent for modernizing their computer systems, making things more efficient, which is what eventually will happen with that money.
Absolutely. Thank you so much, Chand, for taking that up. And, at this moment, I would just like to say hello to all our folks who have joined us with their questions as well. And also everybody out there who are watching us. Thank you so much for joining us on Immigration Talk Show. Please don't forget to subscribe to us if you haven't as yet already. And our handle is at Immigration Talk Show on YouTube. We are also on LinkedIn, Facebook, X, and on Instagram. So check us out, follow us, connect with us. All right, so hi to Nandini, Rag. Rag says hello, Nipasa and Chand. Hello, Rag, one of our very frequent viewers. Always good to have you. So, Rag, if you have any questions, also please feel free to comment. Also, hello to Geeta, Reddy, Abha. We are going to take up your questions. Please stay with us. All right. So now, Chand, my next question to you is, you know, there are probably certain job categories or industries who are seeing a higher rate of RFEs compared to that of others. So, if so, why is it like that?
Sure. So when we talk about H1Bs, the majority of the H1Bs go to the IT and the tech industry because the tech jobs are or who use the H1Bs on a large scale. So when we talk about just the numbers in general, normally the IT and tech industry is where we typically could see more RFEs. The other industries that use a lot of H1Bs are nowadays a lot of the pharmaceutical industry, the semiconductor industry, healthcare industries. They're also using a lot of H1Bs. And normally, my uh, experience is healthcare occupations typically have very, very low rate of RFEs. And the reason for that is since COVID, I think the general consensus has been that healthcare is pretty, pretty important. And USCIS normally they tend to do healthcare petitions a little bit quickly, and healthcare I typically don't see issues. And after COVID, a lot of focus has come down to bringing industries back to US, which means the pharma industry and the chips, the semiconductor industry. So we're seeing a lot of jobs come back to US, at least a lot of validation engineering, the pharma jobs, and the semiconductor, those kind of jobs coming back into US. Those also we typically don't see a lot of RFEs in general. And even within the tech industry, if it's a staffing kind of a company where you have an end client, so basically you have a situation where employee is an employee of a certain company, and through a vendor they're working for another end client, and the end client is somebody else. So those are the kind of areas where we tend to see a lot more RFEs. And I mean, again, historically, anytime you have a consulting or a staffing kind of an arrangement, they definitely face higher volume of RFEs. And the reason for that is for the last 15-20 years, always USCIS goes back and forth with this employer-employee relationship. If somebody is a full-time employee, the employer-employee relationship is pretty easy, very easy to establish. But when you have this situation where you have in the consulting world and the staffing world where somebody is working at the end client, the employer-employee relationship is a little bit difficult to establish because who's giving the direction for somebody's work, who is directing and supervising somebody's work, and so on. It becomes a little bit hard. And then in 2020, we had a lawsuit, and USCIS came out with this memo. And ever since, employer-employee relationship became a little bit easy. But again, in the new modernizing rule, again things are a little bit different because that old memo was rescinded. And what that means is consulting and staffing companies can anticipate RFEs even going into the future. And again, the lesser used industries like education positions, research positions, a lot of universities use research positions, creative positions. So those kind of fields, I do think that we will not be seeing a lot of RFEs. And staffing kind of roles, and even within the staffing roles, so there is something called own it. So every H1B that gets filed, you have to map it to an own it occupation, you have to map it to a own it code, you have to also give the wage level. Normally what happens is when the wage levels are low, or some particular occupation, some particular own it occupations who don't really have a bachelor's requirement, when you look at the occupational outlook handbook and look at their requirements, those are the ones you typically will always see a lot of RFEs, because specialty occupation is something you have to prove on every H1B petition. And some own it codes, by the nature of their data, by the nature of their occupation and how it is in the occupational outlook handbook, the USS will routinely come back and say that is not a specialty occupation. Okay, so high level, some industries are always a target, and even within the industry, some own it codes are always going to be problematic.
Okay, Chand, thank you so much for taking that up as well. And I think we should take up a few questions from our audience right now so that they do not wait too long. So let's take up Nandini's one. Nandini is asking, I have an IT consultancy offering me an H1B, but I heard that USCIS is increasing RFEs for third party placements. How can I prove that I have a valid employer employee relationship for the entire duration of my visa?
Sure. And so again, ever since we have this H1B modernization rule in January, so the way USCIS is looking at third party placements has changed a little bit. So they even modified the I-129 form. So now you have to actually put the end client name and a few things about end client on the I-129 itself. So this is a new thing, and it was not there prior to January 18th. And how do you prove? So again, because we have done a lot of filings in the last 1 month, and what we are seeing is, so the way you would prove the employer-employee relationship is, you have to initially prove what your assignment is. And what that means is, if it's a third party assignment, like in your case, you have to produce the purchase order, you have to produce the statement of work, or you have to produce the vendor letters, or you have to produce the client letters, one of these documents. I mean, again, USCIS does not say this is mandatory or that is mandatory. It is the company that has to prove the bona fide nature of their assignment. And if they're able to establish the nature of their assignment, USCIS does not have a problem, because staffing is allowed, consulting is allowed. And the purchase order, even if it is not for 3 years, because it's very hard for every employer to have a 3-year purchase order. So even if it's a short-term purchase order, at this point of time, we are not seeing any issues with USCIS. However, what USCIS wants is, do you have an assignment on the day of filing? Whether it's a 6-month assignment or a 1-year assignment, as per the purchase order, that's okay. But you do have to prove that on the day of your filing, you do have a valid bona fide assignment with a third party, with the end client. And how do you prove it? The easiest way is, the company will sign a purchase order or a contract with somebody, and you use that to prove that you have a valid assignment. And if you're able to show that, we are not normally seeing any issue. So if somebody comes to us and say we don't have any contract, but we want to place somebody on a project after we do the filing, that cannot be done. On the day of filing itself, you need to have a bona fide assignment, which means on the day of filing, you need to have the contract signed. So if that is the case, in general, you should not have any problem with employer-employee relationship, even in the current new rules.
Okay. Thank you so much, Chand, for taking that up. And Nandini, I hope you've gotten your answer. Thank you for participating. Now, next up, we got Geeta Reddy asking, I heard USCIS is scrutinizing specialty occupation criteria more than ever. So, my H1B job title is Market Research Analyst, and I have an MBA in marketing. Could this raise red flags, and how do I prepare for potential RFE?
Sure. So, market research analyst, that particular ONET code, historically it had a lot of problems. And if you Google, you'll see a couple of lawsuits filed for USCIS denials on marketing research and analyst positions. And in 2000, I think it was like 2020 or 2019. So there was a lawsuit where the court said market research and analyst, I mean, it is definitely a specialty occupation position. And in general, it is prone to RFEs. But again, we are not seeing challenges in the last couple of years if the duties require a bachelor's degree. So again, in your case, you said you have a degree in marketing. Your position is market research analyst. And if you look at ONET, market research analyst on an entry level also requires a bachelor's degree in a specific field. So more than likely you'll be fine. But historically, we did have challenges with that occupation previously, a couple of years back. So even now, as long as the job duties are detailed and there is a nexus between your degree, your qualifications, and the job duties, and the job duties do require a bachelor's degree or above, and in your case you have a master's degree with focus in marketing, so more than likely you should be good. And this is a field that is prone to RFAs, but again, if you're able to prove, you should not have any issue.
Okay. Thank you so much for taking that up for Geeta. Geeta, thank you for participating. And well, Rag is also here with a question. So, Rag is asking, with the current state of RFEs, will it be better to go for a blanket L1A instead of the individual N1A, provided the company is eligible for both?
I mean, I would go with individual L1A rather than a blanket L1. The reason is if you go with an individual L1A, if you get an approval and everything looks good, tomorrow, normally what companies do is the companies look at explore the EB1C option. So I would say, if the company has a blanket L1 and you're also qualified for individual L1A, L1 can be done in premium. So to me, it's always worth taking that extra effort and trying for an individual L1A, because if you get an approval for L1A, you're able to prove you're basically proving that you're a manager on the offshore entity side. You're coming here to work as a manager on the US entity side, and tomorrow you use that to explore EB1C options. And EB1C option is a great option to explore. Not a lot of people qualify. So when you have the chance, I would always say that like maybe you should take the harder route. Look for the individual L1A. The good thing is it's possible to do it in premium, so you'll get a quick answer. And if the company has L1s, blanket L1s, I'm pretty positive that the company is a huge company. It's a big company. So based on your role, definitely I think I would say try for L1A, and if you get through, EB1C becomes a great option for you.
Thank you. And Rag, thank you for participating as well. I hope you got your answer. And next question, this is from Abha. Somebody with family preference AOS already filed. Can their employer apply for H1B? Things that need to be kept in mind given the pending AOS. And when you say staffing companies and consultancies, does it also include consulting companies like EY, McKinsey, etc.?
Yeah, yes, technically, even they are consulting companies, and in the past, before 2020, even they had denials for H1. And if you look at like just Google Infosys or TCS, Infosys got a huge penalty, I think, last year for immigration. TCS, I think there is an issue about TCS. Recently, I think it's in news about some issue that they had with immigration. So even big consulting companies could run into issues. That being said, it's not about uh, the consulting company or not. In general, whenever you have a consulting company and you're saying that your employee will work at a third party location, the rules are a little bit different. The analysis is a little bit different. So, I mean, a small company, I mean, I've seen lots of small companies with one or two employees not have any problems with their H1B. Sometimes big companies could have a problem, or big companies might not have a problem. So, the whole thing is it is what exactly is the assignment. So, the big companies, if they're able to prove the assignment, they'll not have a problem. And even if it's a big company, if they're not able to prove what that assignment is, they will have a problem. So, but again, in general, whenever you say it's a third party kind of an arrangement, in the new rules, in the new I-129, they are actually asking for that information on the I-129. And what that means is whenever they see that it's a third party kind of an arrangement, the analysis will be a little bit different. But again, if it's a big company like E&Y, McKinsey, normally they have a valid assignment, they have valid bona fide assignment. So it's a lot easier for them to prove when you're a big company. But again, in terms of USCIS officer looking at things, yes, even big companies get RFEs. Even again, it's just a part of their job. So every case is different, and the occupation for the case is different. The salary they're providing for that case is different. So all these things will contribute to the H1B. And going back to the other question, so you have a pending AOS. Pending AOS means based on your family relationship, somebody has filed for a green card. You can always pursue a H1B even if you have a pending AOS. So even if you have a pending green card application, H1B is a dual intent visa. So you can have employment based H1B non-immigrant visa processed simultaneously along with the pending family AOS. It's completely legal. And what I advise is it's always better to maintain your own status until that other AOS application gets approved. Because if something were to happen to that AOS, H1B is your backup. So legally, you can pursue both. So you can stay on H1B while the pending AOS application is in progress. The only thing is, if you're on H1B, you have to make sure you're following the terms of H1B, which means you are working as required, you're getting paid as required, you're staying in the same metro where you're working. So all these requirements about H1B. So as long as you maintain valid H1B status, you comply with the rules of H1B. Having a pending AOS will not cause you any problem, and it's actually a good idea. If you have a pending AOS, pursue it in a legal way, and be on H1B until that case is approved.
Okay. Thank you so much, Chant, for taking that up for Abha. And right now, I think I would say that we should go for a short break. But we also have Sanjay who has joined us with his questions. Sanjay, stay with us. We will take up your questions after the break. And Chant, I also have some more questions from my end. So for now, we'll just go for a short break and be back on Immigration Talk Show. Folks out there, don't go anywhere. Stay with us. It's Nipasa and Chant. Hello and welcome back, everyone, to Immigration Talk Show. I'm Napasa, and today we have a very interesting webinar with none other than Attorney Chant Parvathaneni from SPB Law Firm, Dallas, Texas, and we are discussing about H1B and the most common RFEs this year. And he's also giving out tips on how can we prepare ourselves for this upcoming lottery, the March lottery. So thank you so much, Chant. It's been great so far, and also folks out there for joining us. Abha, and we got Rag, Geeta, and Nandini. And also, let me tell you that if you're enjoying this session, do not forget to subscribe to us. Our handle is at Immigration Talk Show. We are on YouTube, LinkedIn, Facebook, X, and also on Instagram. Do check us out. And also, if you want to contact Attorney Chant Parvathaneni directly, have a one on one consultation, maybe have him guide you for your H1B this year, call him on this number 817-523-8247, and you can also email him at law@spblawfirm.com, and do go visit www.spblawfirm.com to get to know more about Attorney Chant Parvathaneni. So, also, friends, you can join us on call. Why don't you call us? I mean, Appa or even Rag, maybe even anybody out there who's watching us. Why don't you join us on call to ask your questions yourself? 425-436-6335. That's the number. And when they ask for the access code, dial in 988-888. Okay, so I was saying after the break, I'm going to take up Sanjay's question. Sanjay is asking, I work in STEM field, but my job requires a mix of technical and managerial skills. If USCIS issues an RFE asking for proof that my role is a true specialty occupation, what kind of evidence should my employer provide?
So USCIS has certain requirement on how you would prove a job is a specialty occupation. So the way you would do it is you look at the normal industry standards. So you look at the industry standards for the job. And if you're working at a client location, you look at what your client requirement is. You look at how specialized your job duties are. you look at for that occupation, you look at what the occupational outlook handbook says regarding those job duties. And so there are like a whole bunch of ways you can do it. So you can also get expert opinions from a professor, where the professor will talk about the nature of the job and so on. So USS has a certain requirements. So they have like 4 prongs that you can meet any of those prongs in general to prove that your job is specialty occupation. Again, the goal is, as long as your job duties require at least a bachelor's degree or above, in a field, in a relevant field, not like any field. So when I say relevant field, it could be like computer science, IT, software engineering. It could be like different fields, but all of them have to be related to the job duties. So if you say like software engineering, computer science, IT, they're kind of related to the job duties. But if you say mechanical, that's completely a different field. So you, as long as a set of closely related degrees are required to do your job duties, pretty much that job is a specialty occupation job. And the way you prove it is just looking at the detailed job duties, seeing how does somebody qualify, the industry standards, if you have a client, the client requirements, and so on. And that's how they would do it. And again, if you are in a very technical role, more than likely you should not have a problem.
Thank you so much, Chand, for taking that up, Sanjay. And Rag was back. He was still asking because okay, he asked, "Thanks, Chand. And are blanket L1A not eligible or tougher for EB1C?"
So EB1C is basically where your company will apply an I-140 on your behalf in that managerial category. So again, when the company applies for EB1C, you don't even require an L1. In general, like L1A is not even required. But what happens is when the company applies for a L1A, as a part of the petition, they're trying to prove that you are a manager in India, you're a manager abroad, and your role in US they will talk about your role in abroad entity, the role in US entity. They'll try to prove all those things. So normally what happens is you can reuse a lot of that data when you apply for EB1C, because EB1C is, again, it's like independent application. So whether you're an L1A or not even on L1, the company can still apply for EB1C directly. But since if the company does an L1A, individual L1A for you, the company is documenting all those things, they are getting everything ready. Your EB1C normally becomes a lot easier because you have all the documentation ready. You can easily convince your company that, hey, we already have all the data. It's a lot easier. But in terms of eligibility, L1A is not even required for EB1C. EB1C is completely independent by itself. And the company will have to do it independently. So theoretically, even if you don't have an L1A, individual L1A, if you are eligible, the company can still file EB1C for you.
Okay. Thank you so much, Chand, for taking that up. And Rag, I hope you've got your answer. We also got K. Vishwanathan with a question saying, "Hello, Sam. Hi, K, but I'm not Sam. I'm sure you miss Sam. Sam is going to be back with another webinar at 2 p.m. Eastern Time, so don't forget to tune in to Immigration Talk Show, all right? And I'm sure that this question is also going to be very relevant at that time. But Chand, if you would like to take it up, or maybe you could just briefly answer to K. Vishwanathan asking, "My question is L1A visa interview getting into any challenges or hard vetting? I'm waiting for appointment scheduling for L1A 2 with family. Should I go alone or with family together?"
Sure. So I think starting from January, we are seeing a lot of issues with appointments in India, and they've been canceling appointments. And again, like 2 weeks back, they actually announced and changed the rules for Dropbox. And what that means is more and more people are required to go for interviews, and we are seeing challenges where appointments are getting very, very tough. And we also heard some news about 10% of the staff at Department of State, so at the consulates, could be reduced in the next couple of months. And what that means is the staff gets reduced, and now the Dropbox appointments, people are not getting Dropbox, but they're mandated to go for in-person interviews for a lot of other visa classes. All of these are going to like create more challenges at the consulates for your interviews. We expect things to slow down even further. And what that means for you is keep checking the website, and rather than go with the family, try to book an appointment for yourself. The minute you get an appointment, try to at least get your appointment done. And unfortunately, because so many rule changes, so many staffing changes, uh, getting appointments could be tricky, could be taking longer. And to me, if you ask me, definitely go. Uh, you as the primary applicant, I think you should go get your visa first, and then the minute the family gets their appointments, they can go for their appointments.
Thank you, Chand. Thank you. So he also is asking another question. Kay, what's your thought? He's saying, "Hi, Chand. What's your thoughts on L1A staying in same city as mentioned in I-129 petition, or take risk to move to another city, but I work legally and justice to my job and organization and my client."
So this is again something you might have to talk to your company, because you have to make sure you follow the terms of your petition. So whatever the company's petition is, you do have to follow the terms of your petition. So just make sure you check with your company, and if you got an L1A, you're probably working at a big company. So and again, the company will know what they've done in their filing. So as long as you maintain the terms of your petition, you will not have a problem. So you cannot do anything that is violating the terms of your petition. You cannot have material changes. So just make sure you check with the company and see what they have filed, what they have notified USCIS. And as long as you maintain the terms, you should not have any problems. If you have any material changes, typically that's when you could have issues.
All right, Chand. So, thank you for taking that up. And Kay, I hope you've got your answers. Also, my next question to you, Chand, would be, if you could tell us about specialty occupation again, and what specific documentation can H1B applicants provide to avoid or effectively respond to RFE related to specialty occupation issues?
Sure. So when you talk about specialty occupation, you have to convince USCIS that that particular job requires at least a bachelor's degree or above in a particular field. That is pretty much what you're trying to prove when the company applies for your H1B. So in terms of what you can provide upfront to avoid these kind of RFEs, the first and foremost thing that your company should do is they should give a very, very detailed and elaborate explanation about your job duties. And normally where I see an issue is some companies are giving only 5 or 6 lines of the job duties, and if the job duties are not clear, not very elaborate, that's basically your biggest risk, because USCIS has to know what your detailed job duties are. You're asking for a H1B for the next 3 years, and what that means is be as elaborate as possible. To me, that means maybe 2 or 3 pages of detailed job description. Put percentages. Okay, so what that means is, say you're working on client calls, and so client calls don't require like any education. So you have to be very, very specific. If you say client calls, you're calling the client, you're getting on the client calls to discuss about technical requirements, for example. So you have to detail your job description. You have to put percentage, how much time do you spend, because you have to spend your time on complex tasks, specialty occupation tasks. So give as detailed explanation as possible about your job duties, very elaborate description. Put the percentage of time that you will allocate. Okay, just don't give some random duties, but very clear, and give a very clear picture to USCIS on how your day looks like or how your week looks like. Maybe 40% of the time you're spending on software development, 10% of the time you're spending on software testing, 10% of the time on requirements gathering for your technical product, and so on. So uh, elaborate job descriptions with percentage allocations is the first and the foremost way that you go to USCIS. That's first thing. Second thing, again, if it's a third party client, if at all possible, try to get vendor letters or client letters where the client or the vendor, they talk about the education requirements. So if the client comes back and says, hey, for doing these job duties, our normal requirement is so and so degree in so and so field, that adds a lot of value. So what you should be doing is, if it's a third party client kind of an arrangement, get a letter from the client, get a letter from all the vendors discussing the educational requirements for doing this job. So that will give a very good clarity to USCIS on what kind of a what kind of an education requirement you need. And the other thing is your employer themselves actually telling USCIS what the education requirements are, their normal practices are for that particular role. That is also very important. And again, some employers go ahead and submit some kind of proof upfront, maybe like a expert opinion from a professor, or maybe some of their prior hiring history, and so on. But on a high level, at least the basic these basic things have to be tackled upfront. And on top of it, you have to use the right ONET code. So when you use the right ONET code, good practice is to also include the occupational outlook handbook documentation, because the occupational outlook handbook documentation or Bureau of Labor Statistics, their reports, they clearly show for this occupation what is the standard. For example, if somebody is a software developer, the industry standard is a bachelor's degree in computer science or a very close field of computer science. But if you see something like basic web developer, for example, if you look at occupational outlook handbook or ONET, the general requirement is not a bachelor's degree. So including those documents upfront as a part of the filing, showing the ONET code, showing what the occupational outlook handbook requirements are for that ONET code, that upfront will tell USCIS what that requirement is. So these are some of the things that you do to reduce the risk of specialty occupation RFE.
Thank you so much, Chand, for taking that up. Now we have Galela, who has another question for us. Hi, Galela. Thank you so much for joining us. I wish you can also join us on call. If you can, dial this number 425-436-6335, and the access code is 988-888. So Galela is asking, do I need to mention about my green card application in DS 160? Perm process just started. I have a visa appointment in May 2025. I am on L1B right now. I am in USA changing H1B, same company.
So the question that the DS 160 asks is, do you have an immigrant immigrant petition filed on your behalf? So perm is not the immigrant petition. So if the perm has just started, your immigrant petition has not been filed. If somebody's I-140 has been filed, I-140 is the actual immigrant petition. So if the I-140 is filed, you would always mark it as yes and give information about your immigrant petition. But if the perm has just started, the perm is just a Department of Labor application. So perm is not really an immigrant petition. The I-140 or the I-130. So for family-based folks, I-130 is filed, or for employment-based folks, I-140 is filed. So, and for like investors, like EB5 investors, I-526E is filed. So if one of these petitions are filed with USCIS, that is when you have to mark it on DS-160 and notify the Department of State, the consulate, that an immigrant petition has been filed. But if it's just the perm is not really an immigrant petition, so you don't really have to put that on your DS-160.
Thank you so much for taking that up. Galela, I hope you've gotten your answer. Rag is back with another question asking, I am in current light. Could applying as a third country national work if consular appointments are not available for work visas?
So be cautious about the third country nationals, the TCNs. So what is happening is now all pretty much like every consulate is overburdened because of so many people trying to apply for visas in the last couple of months. So even before President Trump started, there was a talk that people, I mean, I guess people thought that things will slow down. So there were like countries like Mexico. We saw a lot of challenges. Even in December, November itself, people were finding it very, very challenging to get an interview appointment. So, and what this these foreign consulates, a lot of these consulates, if you're not a resident of that country, they tend to prioritize things for their own residents. So the rules for the consulates keep changing very, very frequently. So you would have to actually call the consulate or talk to the consulate and look at the rules. We had a number of cases where at the last minute appointments got cancelled. So whenever you're in a third country, uh, be aware that the third country, every the consulate, they can make their own rules. So things keep changing. For example, if it's Mexico, if it's first time H1B stamping, they don't do it for TCNs. If it's Canada, they're doing it. And again, within the country, you have multiple consulates. So the answer for you is you would have to personally check with that consulate's requirements, because the consulates don't have uniform rules. So every consulate is different. And if you're not really a resident of that country and you're going to a third country as a third country national, they may or may not accept you.
Okay, thank you so much. And okay, Kay is saying, just for your information, my friend I-129 is approved, say 131 and 310. in his family visa interview. So about 20-30 days lag for now, I see. I'll update next week the dates I get for myself. Okay, thank you so much for the information, Kay. And I think, yeah, Chan.
Yeah. And again, what I see with the dates is all of a sudden the dates get opened up. So I think you have to constantly look for the dates because they open up dates and then you have to take appointments. And again, right now I can tell that there is a lot of demand for appointments. The reason is this whole Dropbox, the way they change the Dropbox rules. Now they're saying that majority of the people have to come for in person because a lot of people who used to be eligible for Dropbox, they simply never had to go for an appointment. Now those people are having to go for in-person interviews. So so you'll have challenges, but again, keep constantly looking at the slots. The slots will open up at random times, and then you just have to book a slot whenever they open up.
All right. Thank you, Chand, for taking that up. And with that, I think we should also take up a few questions from our Facebook groups, if that's all right with you, Chand. Control, if you can display,
Yeah,
please.
sure.
This is Brinda asking, hi all, I have H1B visa started on 10/2022 and expiring it on 10/2025. When should I apply for extension?
So one can only apply for an extension when they are within the 180-day time period. So if it is 10/2025, 6 months, so basically April 2025. So from April 2025 till October 2025, during that 180-day period time, extension can be applied. And our recommendation is applied as quickly as possible. So what that means is, in April, she'll be eligible because that 180-day the time window will start. So as quickly as possible, which means April or May, it's a good idea to finish off the extension part.
Okay. Thank you for taking that up for Brinda. And Kay says, wow, as we chat, I got my soft copy for I-797B. That's really nice, Kay. Congratulations. All right. So let's go on to our next Facebook question. Control, if we can have that. Yes. So this is from an anonymous member, Chand, asking how much usually the cost for H1B extension, H4 extension, and first time H4 EAD with average attorney fees. Company is small scale business, less than 25 employees.
Sure. So the H1B extension, so I'll tell you the fees. So the for a company that is less than 25 employees, the first time they file a H1B, it is $2,010. For the first extension, they have to pay $500 less. So it is 1,510. So 1,510. That's the first time extension fees. And the second time, it gets even lower. So the second time, the fees is even lower. It decreases by another $750. Okay, so that's the USCIS fee. And then when it comes to H4, the USCIS fee is $470. EAD again has its separate fee. EAD, the fee is $520. So you're looking at about close to $1,000 for H4 and H4 EAD, just the government fee. And then that attorney fees, I mean, typically you'll start seeing from $1,000 for the H1. And depending on what your company is doing, whether they're doing it in-house or they're using an attorney, the price could differ. But in terms of the USCIS fees, those are the constant fees for anybody that has less than 25 employees. Once they cross 25 employees, the fees increases a little bit with USCIS.
Okay. Thank you so much, Chand, for taking that up. Now, our next question is on the screen. This is also from an anonymous member. I received my I-120, I guess. I want to prepare myself for the interview. Why is the best question about why USA? What can I answer about I want to finish my studies now because I haven't studied for years? How can I answer this question and how can I convince her? I want this really. I got rejected twice before, and the second reason was that I wasn't proficient with English.
Sure. So I think so when you go for an interview, I think for an F1 interview, the officers are looking at two main things. One, what is your real intention? Are you coming to study and follow the rules of F1? That is the first thing. The second thing is your intention to go back to your home country after your studies are done? So the focus will be a lot on these things. And what that means is So they have to be able to convince that they have ties back to their home country. So they have to show through evidence what their ties are to their home country and why they would come back. That is very, very critical. And the other part is what exactly are they studying, how it will fit in their career plan, and what exactly is their goal. So once they finish their studies, what exactly is their goal? And if somebody is not able to articulate the reasons for studying, the reasons, their future plan, normally we see issues. So the thing is, you have to be able to articulate and explain to USA's officer what your the nature of your study program is, how it would fit in your career aspirations. And everybody's case is different, so that, and everybody's program is different, because some people are taking computer science program, some people are taking English as a second language program. It could be different programs. So overall, the nature of the program is very important, and they have to establish their ties to the home country. And again, every officer is different, and the consulate officers have a lot of discretion. And if they deny the case, unfortunately, you cannot get it reviewed, you cannot file a lawsuit in the court. So the thing is, they have a lot of discretionary power. So all that means is that particular office, a lot depends on that particular officer. So you have to be able to convince that particular officer. And if they are convinced that somebody's intention is to come and follow the rules of F1 and then go back to their home country, they are successful. If not, they typically have challenges with F1.
Right. Right. Thank you so much, Chance, for taking that up. And now we have another question. This is also from our Facebook group and from an anonymous participant asking, "Hi, I am on an L1B visa and I will be completing my third year in September 2025. My company will apply for a green card, and they said that I should extend my L1 visa for another 2 years and at the same time apply for an H1B visa, as the green card process may take more than 24 months. My question is, can I get an H1B visa on a future date? And can I apply now and get the visa after the expiration of my L1B? Or do I have to move to H1B immediately once it's approved?"
So again, in the new rules, when I mean, the first thing is somebody has to go get through the lottery, and if they get through the lottery, the new rules say that you can apply for with a future date. So when you apply, you can put a date that is 6 months ahead of time, and that can be done. And the other thing is whether somebody has to move to H1B right away or not after the approval. There are two different ways of doing a H1B, and this is applicable to even students. You can do H1B as counselor processing, or you can do H1B as change of status. And if you do it as a change of status from the day, so if you do it as a change of status filing, the H1B is immediately active from the date of that change of status approval date, the validity date. If somebody files a H1B as counselor processing H1B, so people can always take some time and they can convert into H1B in the future. So a lot depends how the company is filing the H1B, whether they're doing it in counselor processing or filing it directly with change of status request.
Okay. Thank you so much, Chand. So now we have another question, right? Control, if we have, can you please display it, please? Okay. I'm on OPT. I want to travel to India in April, return back in May first week, and my OPT is ending on 17th of June. Did anyone travel from Canada to USA on F1 visa from Montreal Airport to Toronto Airport? My question is, where will be the immigration in USA or pre-clearance in Canada, and they ask? What do they ask for?
I'm not sure if Montreal has pre-clearance. I mean, like some countries, like for example, Abu Dhabi. So you can have customs clearance done in Abu Dhabi airport. I'm not really sure about Montreal, how it works in Montreal, but at a certain point of time, they have to go through CBP, and CBP officer has to be convinced. So a CBP officer, only if he's convinced, they'll grant admission. So definitely, whether it's either in Canada or in US, you have to go through the CBP. Some airports like Abu Dhabi do have the CBP officers in the foreign country itself. I'm not really sure how Montreal does their things.
Okay, Chand, thank you for that. And I think we can take one more from our Facebook group. This is I applied for a change of status F1 here in America and got approved last year. I'm planning to visit my home country, Philippines, this June for my sister's college graduation. Will it be hard for me to come back to America? I've heard mixed opinions from other people that I will have a hard time. Your opinions and suggestions are highly appreciated. Thanks.
So I think the challenge is because it was a change of status approval. So when he goes to Philippines, they have to go for stamping. So I think basically that word mixed opinions from other people. I think it's because when you go for stamping, anything is possible. A lot depends on the officer. So this person has to go for stamping for F1, and depending on the officer, if at all there is a denial, there is a problem. But my experience is if somebody is already studying in US, you have a lot to prove that you're paying your tuition, you're actually uh, progressing towards your degree, you're getting all the pass grades and so on. So most of the time, when you're able to show that evidence, I think the office it's easy to convince the officers because this person has already started his F1. He has done a change of status. He's in US, already studying in US. So in general, it's a lot easier to convince the officer showing all these evidences. That being said, it is not 100% guaranteed because the officer will still have to give a visa. Only if the visa is given, he can come back. So that uncertainty is always there until he gets his visa stamping done.
And so the mixed reactions, the mixed opinions, right? Thank you so much, Chant, for taking up all of our
Yes.
questions so patiently. And I have this one last question to you, because there could be chances also that people would not make it to the lottery. So for those who would not be selected in the H1B lottery, what alternative visa or work authorization options should they explore?
So again, if somebody is in US, most of the time they are in US either on F1. Majority of the time, some people on H4 because they try to convert from H4 to H1, or sometimes people are on L1 and they try to convert to H1. So if somebody is already in US, again, they can continue that status. The only problem is if it is H4, you can't really work on H4 until you're eligible for H4 EAD, which means you're dependent on your spouse getting I-140. If it's a student, most of the time what luckily happens is students still have their OPT period, and some people will be having like STEM OPT and so on. So if somebody is a student, has their EAD card, continue on your OPT as long as you can. Some people, what they do is they extend their F1. They again get enrolled in another program. And if you're doing it, make sure that that college is legitimate. You're actually following all the F1 regulations if you're doing that F1 program. Uh, and for the folks that are not in US but are outside the US, again, in terms of work visa, again, you have the O visa option. So O visa again is a good option even for people in US. However, O visa is very tough. But again, a lot of people have been exploring O visa. So everybody that is not getting selected in the lottery can look at their O visa options. And some folks who are eligible for L1 because they're working in the foreign office, the company is also in US, they definitely should explore the L1 option. So L1 and O1 are actually very good options. And other than that, I think there are not many options for specialty occupation. But if somebody is from some other countries like Mexico or Canada or Australia, there are other options. There are like options called TN visa. There are options called E3 visa and other options. So depending on where your country, where your passport is from, you might be able to find some other options in general.
Okay. Thank you so much, Chand. I'm sure that would be of great help, to folks out there. So, folks, if you resonated with today's webinar, and I'm sure you did, do not forget to, subscribe to our channel. We are Immigration Talk Show on YouTube, and we are also there on LinkedIn, Facebook, X, Instagram. Do check us out and also go visit www.staffingly.com. And in case you want to have a one on one discussion with Attorney Chant Parvathaneni, why don't you go check him out as well? His website is www.spblawfirm.com, and you can also call him on his number 817 523 8247. And it'll be best if you can actually email him with your case, because every case is different and need its own attention. So his email address is what you can note down. It is law@sbblawfirm.com. Thank you so much, Chand. And yes, I think H1B lottery season is knocking at the door. So maybe if you have final words, to folks out there who are watching us right now, it would be great.
Sure. So again, the H1B lottery, I mean, I definitely think we will have a lottery, but I think the numbers will come down compared to last year. Last year, we had 400,000 registrations. I definitely think the numbers will come down. And the big reason for that, I think, is the $215 fee. And that being said, I think the companies should not wait until the last minute. March 24th is the last day. March 7th is when it starts. So I don't think people should rush and file on the very first day. But at the same time, they should not wait until the last minute. So try to do it maybe like in the middle somewhere around March 15th. So that way you're doing things carefully, making sure all the data is accurate, and finish the registrations. And just because I think the numbers will be lower than last year, I think the selection percentage, the selection chances more than likely will be a lot better than last year. And I think people should just, I think, look out for the lottery once it is done. They have 90 days to do the actual filing. And we have cases where people wait until the last minute and then they miss the deadline. So getting through the lottery next month, that doing it cleanly with the right data, that is very important. If they're selected in the lottery, remembering that there is a 90-day deadline, and again, not waiting until the last minute, but doing it a little early than the deadline and wrapping it up, that's also pretty important. And hopefully, I mean, again, at this point of time, we are not really seeing like denials or anything for H1B. As long as the company is legitimate, the job is legitimate, USCIS is still approving cases. And President Trump's administration, they're also saying that they are not really in favor of doing anything to H1B. Yes, they're talking about changing EB5 and other immigration things out there, but in terms of H1B, most of the administration officials, they're coming and saying H1B is valuable, and they don't have any plans of removing H1B or making any drastic changes at this point of time. So hopefully, I think people get selected in the lottery and they get through and use this as a part of their career and move ahead.
Absolutely. All the best, folks out there, especially those who are going to, try their luck in this H1B lottery this season. So thank you once again, Chand. It was such a pleasure and an honor having you here on Immigration Talk Show. It was a great discussion and a very insightful one. So thank you once again.
Thank you,
Have a great
Natasha.
day. And folks, do check him out and also check us out at Immigration Talk Show. Do not forget to also, check us out at www.staffingly.com. And you can also email me. My email address is nipa@staffingly.com. You can also WhatsApp me. My phone number is 408-335-6444. This is also where you can call me and message me on WhatsApp about your case or questions. So thank you once again. Folks out there, have a great day and stay tuned on Immigration Talk Show because we got more webinars lined up. Thank you for joining us.